Good morning, ladies and gentlemen. It is now 10 o'clock. I'd like to call the hearings together. I'd like to begin with the Pledge of Allegiance, please. Representative Gay, can you start us? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I see here that I have many pink cards already, so if you do want to speak, if you do want to come up to the table, you have to submit a pink card. And with that, I will call the sponsor of the first bill on our agenda, which is House Bill 1346, the establishing a committee to study the New Hampshire family court system. And with that, I'll call the prime sponsor, Representative Betty Gay.
Thank you very much. I have allergies, and that's from eating something with soy or milk in it. I've just passed out an amendment, OLS, I owe them big. It dawned on me when I was talking with other attorneys who are reps and people who are affected by family court, that if we open in a commission, we already have professional commissions, but we don't have one that's primarily the people who are affected by the family court. So the amendment simply changes the members of the commission to 4 House members, 2 Senate members, but they're volunteers. They're people who are really interested. They're not going to be handpicked, according to this, by the Speaker or the President, because that's really hard. They've already had to staff many commissions, and they may as well just ask for volunteers who are really interested in the subject. We asked for 2 domestic violence counselors, 5 New Hampshire citizens who've been involved in family court, an attorney who's part of Domestic Violence Emergency Project, the DOVE project, attorneys who have experience in family court, certified mental health therapists. So that's the change. I don't have to tell you that we have issues with the family court. Most people have been involved or have family. So I will just now yield the floor to people who would like to testify.
Representative Gay, can you do a pink card, please?
I will.
Thank you.
Thank you. Oh, can I add? I've also passed out the yellow sheets, which is written by Barry Goldstein, who's a very famous attorney who represents victims of domestic abuse. And I thought this was the most interesting thing on the website. It's 12 misconceptions about domestic abuse that were set in the 70s. And the courts haven't changed, and there's been a lot of research since then. So this addresses these 12 rare events that unfortunately the courts think are standard. Then the pink is a testimony from a woman who spent 7 years in family court. And she, would you believe today is when her parents' house contents are being delivered to her house. So she couldn't come. So she spent a lot of effort. All her testimony, she sent testimony, very short testimony, on several bills. So I printed them all on pink so you could see it. She's also kind of at risk because she's still in the court system to say anything critical. So that's why her name's not on here. So thank you for reading it. It's really heartfelt, and she's a very intelligent, compassionate person. Thank you.
Thank you. The next pink card I have is Representative Sue Hanola.
Oh, it's fine. No worries. Thank you for allowing me to speak. I just have some brief comments. I don't have written testimony. I'm from Hollis. I'm a state rep there in Hollis. And I just wanted to say that a year ago, the family court system wasn't on my radar. But there was a couple constituents who've actually brought some issues to my attention at that time. And it was at that time centered around the Judge Introcaso issue. As you may all recall, Judge Introcaso was the family court judge who was convicted of falsifying documents. And it could be a felony, it could be a misdemeanor, as it turned out. I was actually at that sentencing hearing. It was decided it was going to be lo and behold, go figure, a misdemeanor with no jail time. And the precedent they were using for that was another court judge who was actually also convicted of something that could have been a felony that got a misdemeanor. That's slightly erroneous to what this bill is, but when I started getting involved in looking at things, I try to look at things in a wide angle. So when I was looking at the Judge Introcaso case, I was actually talking to the Assistant Attorney General, I was talking to the Judicial Code Conduct Committee, and I was trying to really understand it. And one of the things that I was surprised to find in all of my research was actually there was quite a few people in my town who actually were in the family court system and had some very heartbreaking situations, things that they were currently happening in their family, and they were left to languish for quite a long time. That was the reason that I decided to participate with Representative Gay on this bill. One of the things that is pretty clear to me now is that there's a need for a look. There's a need for a look. There's a need to lift up the rock a little bit and see what exactly is going on in family court system. Because since that Judge Introcaso case, we've actually had other situations where we've had a marital master have an issue. We've had issues with the GAL. There are a lot of hardworking, wonderful people working in the family court system that do yeoman's work. Having said that, there have been enough issues from people that you'll hear today that it just deserves a little bit more oversight. One of the things that I've learned about the Judicial Conduct Committee, while they are very thorough and they do great work, they have a very narrow scope in which they can look at things. And they look at things with only regard to, does this violate this or that? There's a lot of things that seem to be falling outside of that area that they cannot look into, and that's why it's our responsibility. And that's all I have. Does anyone have any questions for me? Thank you. Oh, yes, sir.
Would you take a question
Oh,
from
please.
Representative Long? Thank you.
Are you, thank you for taking my question. Are you familiar with the amendment?
No, I'm not as familiar with the amendment.
Okay, I should have asked Representative Gay, but yeah, that's
Okay.
fine. Okay, thank you.
Thank you, sir. Thank you.
Next, we have Mr. Richard Head. Good morning, Mr. Head. I see here that you're asking for 10 minutes. We have a huge stack of cards. Do you think you could keep it to 5?
I will certainly do my best, obviously.
Thank you kindly.
And some of what I'm going to talk about today relates to some of the bills generally that you'll be hearing today. So my first opportunity to talk to you may be a little bit longer than some of the later ones, because I won't repeat myself relative to the other bills.
Well,
But
if you could just keep it to this bill, we'd appreciate that, sir.
Absolutely.
Thank you kindly.
So my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. One of the things I just want to clarify, and it's a common theme, I think, is there is no family court anymore. There is now a family division. In 2011, the legislature consolidated and created the circuit court. And the circuit court has 3 divisions. It has the family division, has probate division, and it has district division. And judges in the circuit court sit in all 3 divisions. So there's no, with some exceptions. So there used to be a marital master system, and in the same statute in 2011, the decision was made to start phasing out marital masters. So as marital masters retired, those by statute could become judges instead of masters. We currently, with the resignation of Master Dalpra, we have one marital master currently in the system, and when Master Cooper retires, there will no longer be any marital masters. So in the circuit court, with again some limited exceptions, judges sit in all types of cases, and you have roughly in the circuit division 125,000 cases that are heard, that are filed each year. In the family division, there are roughly 19,000 new cases and roughly 5,400 cases that are reopened. So in the family division itself, we're talking about 25,000 cases. So it just sort of puts into context sort of what we're talking about when we're talking family division, because we no longer have a family court system and a dedicated family court process. In sort of within that, we have 47 full-time judges that manage that 125,000 caseload. So it's a significant caseload that these judges are working under. The one marital master, we have 2 senior judges and 9 referees, I think, although once you get into the seniors, those are retired judges under 70, and the referees are over 70 or no longer able to act as judges. And they work essentially on a volunteer basis. They're paid, but they work at their own schedule. They're not a full-time, they're no longer full-time employees. The other aspect that I think is important for the committee to know, so with regard to this bill, which is to create a commission, there is currently a task force, a domestic violence task force that began in January, is expected to issue a report probably sometime in March or thereabouts. And many of the people that are participating in that domestic violence task force are similar to the types of people that would be in this commission that's being proposed. And I've not seen Representative Gay's amendment, so I don't know exactly what was proposed there. But within the domestic violence task force, we have county attorneys, we have legal assistants, we have victim witness advocates, we have chiefs of police, we have the coalition, we have Dove, CASA, private attorneys. So it is a wide spectrum of people that are currently participating in a task force that ultimately is likely to lead to legislative recommendations. So it may make sense to look at those recommendations, see what comes out of that, and really tailor what it is that you're talking about in this bill into a more substantive bill that can incorporate those task force recommendations and also the testimony that you'll hear here today and from other people that you may be hearing from. But it just may be premature, given that there is this task force, given that they will be issuing a report, and given that it is likely to include legislative recommendations. And I'll say simply that, this is a very difficult area of the law. And in the vast majority of the cases, roughly 75% of the cases that are in the family division, they are completed within 1 year of filing. Not all cases are. There are some highly contested cases, and you're going to hear this afternoon from Judge Lemire, who is one of the few judges that does mostly family division cases. But they are significant, and they are in some instances highly contested. And judges are simply, in the context of the cases that are being presented, trying to take the evidence and render decisions. And what we're talking about when we're talking about family division is not only divorce and parenting, child support, we're talking about domestic violence, guardianship of minors, abuse and neglect cases, children in need of services, juvenile delinquency, adoptions. There's a wide range of cases that are being heard in family division. At the same time, those same judges are hearing in the district division and in the probate division. Relatively few in the probate division. We're primarily talking district and family.
Excuse me, Mr. Head, you're past the 5 minutes, so if you can what you're saying is very important to us and the decision-making process. So if you could,
I'm happy to wrap it up.
Wrap it up. Thank you.
I'll be talking throughout the day on many of these bills.
Thank you.
But I'll be happy to take any questions.
Thank you. Does anybody have questions? Representative Long.
Thank you, Madam Chair. Thank you, Mr. Head. So with respect to the task force, if you look on page, actually it's the first page, starting at line 28. I mean, it looks like they're looking at domestic abuse. So some of these would be picked up with that, I would suspect, correct?
I think that's
Okay.
correct. Thank you for the
It-
question.
it's-
I think that's right.
Okay, and with respect to other educating court staff, trauma suffered by victims, children permitting to speak for themselves, do you think any of that within the task force will be addressed?
Truthfully, I'm not sure. Some of it, certainly training, is on their agenda.
Okay.
And again, I'll note that it is a domestic violence task force.
Right.
So it doesn't cover the full range of
Okay.
matters that are being heard in the family division. But I think in terms of that type of recommendation, I do believe that is one of the specific items that they have on their list of things to look at.
One more follow-up, if I may, Madam Chair.
Certainly.
Who picked this task force?
The Chief Justice.
The Chief
I thi-
Justice?
I think that's,
Picked that.
and I think he consulted with some folks, but it was created by the Chief Justice.
Okay, great.
And I should have added, there's also the task force has a public hearing scheduled for the 21st, where they'll be taking public input, and their meetings are streamed, and their meetings are also recorded and available on the task force website, which is accessible through the Supreme Court website.
Okay, thank you.
Thank you.
Any further questions for Mr. Head? Are you going to be able to submit your written testimony at the end of the day
I actually don't have any written testimony. I apologize.
with what's in your notebook?
My notebook is scattered random notes.
I see, okay.
I have nothing.
Thank you anyway.
My system is pretty random in terms of what I end up saying versus what may actually be in here.
Like mine. Thank you.
Thank you.
Next, we have Katrina Heinrich. You've asked for 3 minutes. I forgot to say while she's taking her seat, if everybody could please be sure to mute their phones so that we don't interrupt whoever is speaking. Whatever they have to say is important. So thank you for that. Thank you, Ms. Heinrich. You've asked for 3 minutes?
Yes, and I hope I can keep it to that for all of you. So, my name is Katrina Heinrich. My case has been in the control of the family court for over a decade. On this particular bill, I'd like to speak to some notable reasons I believe that this needs to happen. First, let me begin by saying I was delighted that the governor signed the Family Court Awareness Month proclamation, which embedded in that proclamation was governmental and academia studies that support the reasoning behind it and the need for it. With that said, the statistics from 2020 from the Administrative Office of the Court noted that about 20% of the family law cases actually are extracted from the overall pool of whatever the number was at that time, 25,000 cases. In those cases, when you break it down, that's 3,000 cases, and in that 3,000 cases, that's actually affecting at least a minimum of 2 citizens of New Hampshire, because there's 2 people in every case. That doesn't even include what children there is. So a number of people are being, affected by this. So with that said, I'm going to go on with some of the issues that I have found that are very transparent. You can see them. You have to look at the data, and the only way to do that is to investigate it. The lack of transparency issues with the family court for me, one of the biggest ones is the GALs are paid private contractors. In that particular case, I feel like they should not get immunity. They do not work directly for the government. They work for themselves. They have no direct boss of responsibility. They themselves are the boss. The control of that goes without speaking. They work directly with children and family without obligation or accountability. This includes their business practices, actions, and decisions. Non-medical professionals are paid privately also in most cases. Void of accountability, the court is ordering medical and psychological services and treatment to families and children where it's not needed. There has been failed billing codes. There is no litmus test for them. The court is making judgments and orders, rendering opinions and decisions about individuals who may or may not be party to the case without service. And a very good example of that is they're including people that have never been served, they've never been given court decisions, but they're in the orders, restricting them from their rights. Children do not have the voice, as in my case, my daughter has already stated in numerous letters to numerous legislators how her kidnapping occurred. And that had the GAO actually been working for the child, it would have never happened. The result of that is her lifelong PTSD, which is the reason she is not here today to testify. The little girl that is missing, Harmony, really set her off for the last week due to the fact that she herself was removed from the state, and the state didn't care no matter what I tried to do. She couldn't contact me for 45 days. She found a way to get a message to me. I had no idea where my child was. None. The court fails to acknowledge the abuse and trauma suffered by the victims. Instead,
Excuse me. Your 3 minutes is up. I'll give
Yep.
you a minute to wrap it up, please.
Yep.
Thank you, dear.
Instead, the victims are included in stalking, harassment, cyberbullying, gaslighting by the unhealthy parent, and third parties that are outsourced. Requests for family court financial information that I have tried to get from the family court for audits. I would like to know their money trail. I'm very curious about their money trail. They cannot provide me with any financial audits for the last 20 years. Court income and billing seems to be in some type of dispute. By way of written transcripts of family court proceedings are frequently incomplete and missing critical data, suggesting that the family court software and technology is incapable of accurately recording proceedings in their entirety. Such as, I have one that's missing 30 minutes. It's a 30-minute court case, and it's missing 20 minutes of actual documentation. Parental rights are violated when the child is kidnapped to a southern state. That was my case. And it violates constitutional rights and civil liberties, freedom of speech, suppressed without due process, using Rule 1.1 or 1.2 and 2.2. Thank you.
Do you have written testimony to submit, please?
I do not. These are my notes, but I absolutely can get that to you.
Thank you kindly.
Mm-hmm.
Next, we have the Honorable Dan Itza. He's asked for 5 minutes. Can you know what it's like,
Yep.
Representative?
Thank you, Madam Chair, members of the committee. There's no place like home. I spent 16 years in your seats. I want to tell you something. About 6 years ago, there was an attempt to dissolve this committee. I'm going to tell you what I didn't say in defense of this committee at the time. If you understand that the simple summation of the natural rights that our Constitution, state Constitution, is designed to recognize and protect are that a man's home is his castle. The subjects that this committee deals with, every one of them, every single one of them, reaches inside that castle. And therefore, it is incumbent upon you to have a particular regard to those natural rights. The family court, this committee was formed the year after the first family court was created and then it was under the auspices of this committee that it was eventually expanded statewide. Those courts deal with the subject matter of your committee, whether it's divorce, child protection, whatever. And it is therefore your duty to make sure that the court is doing its job in dealing justly with your constituents. One thing I'd like to bring up, it was brought up that there are no longer any marital masters as of 2012. They were phased out, that is true. They were replaced with referees. However, while the district court, probate court, superior court all have specific requirements of their referees, family court referees have no requirements. When I tried to impose requirements, it was pursuant to a tally of the referees in family court at the time. Was approximately 2014, 2015. I can't really give you a precise number anymore. A large number of them were simply listed as former court employees. They were not attorneys, they were not former judges, they were former court employees. You can obtain this information through legislative services, and I advise you to do so. See who is there making recommendations to the judges. This is important because second party, or second hand, I have knowledge of referees or marital master who was then a referee and is now a judge who accepted closed envelopes as information upon which children were removed from custody. No one ever saw what was inside of that. It was observed by then Representative Paul Imbertson in person. Ms. Heinrich, who you just heard, observed the same behavior. This is not everything. There's a lot of good that happens in family court. There's a lot that is not good that happens in family court, and it's your job to make sure that it ceases, the bad. If there's anything I find missing now in this legislation, I advise you to adopt the proposed amendment. I think it's a very good idea to have members of the community. What is not included is investigating what happened, those cases in which it goes sideways. And find out why certain cases go sideways, when there is loss of due process. And that's basically every time it goes sideways, it's a loss of due process. Court Rule 1.2 says the court, in the interest of justice, the judge may waive any rule not in statute, which means simply there are no rules, except at the discretion of the judge. So you need to determine which rules or what needs to be put into statute so that it cannot be circumvented. I'd be happy to take any questions.
Thank you, Mr. One question, Representative Cody Belanger.
Thank you, Madam Chair, and thank you, the Honorable Dan Ensign, for being here today. If anybody understands the family court at this table, probably one of the number one people who do. One of. What was that? The court rule you just mentioned?
1.2. It dovetails with the authorization of the family courts. I think it's 473D:4, which says notwithstanding, in spite of, which means in spite of any law to the contrary, the family court has equity powers in all of its cases, which means that any law that was passed prior to 2012 has no particular force in family courts.
Follow up?
Yes, ma'am.
Certainly.
Thank you. Can you provide that to this committee?
Of course.
Thank you. Follow-up.
Further follow-up?
So, unfortunately, I don't have the amendment in front of me, but if somehow I can get that, that'd be greatly appreciated. Thank you very much. Thank you, Representative Rung. Thank you, Madam Chair. And do you think this bill seeks to kind of dissolve that court rule?
I don't know that it needs to be particularly dissolved. What what this committee needs to do is to determine what constitutional rights are being circumvented by the waiving of rules and establish them in statute, so to ensure that they are protected.
Any further questions? Seeing none, thank you, Representative. Next, I'll call on Dana Alberti. Dana Albright, you've asked for 2 minutes. Good morning.
Good morning. Thank you, Madam Chairwoman. My name is Dana Albrecht, and the committee heard me testify last Tuesday about the shared parenting bill. I'll try to make this brief. At this time, I'd just like to remind all of you that I'm one of at least 9 family law cases in which former Judge Julie Introcaso appointed her very good friend Kathleen Sternenberg as guardian ad litem. You'll probably be hearing from a couple others as well. But instead of hearing me say that, I'd like you to briefly listen to them say it. On May 1st, 2014, in the Sobel case, and there's a list of all 9 cases up there. You've got Julie Introcaso and Kathleen Sternenberg together in open court. And if we can just listen to that briefly. Excuse me.
And I recognize Attorney Sternenberg's writing, I believe. Maybe not, but her name. The council should know that Attorney Sternenberg and I are very good friends. Very good friends. I don't know if she shared that with you or she did not. I'm going to look to Kay, who I refer to as Kay. I don't call her Kay.
Excuse me, sir. Excuse me, sir.
Yeah, we're very good friends.
Can you speak to
Very
the
good
relevance
friends,
of this?
godparent of my child.
Yes, the need
we
to
are
establish
very
a
close.
court record.
Thank you.
So again, we have serious issues in just these 9 cases alone. And I just wanted to ask if everyone caught that on the audio, because Kathleen Sternenberg was a little harder to hear, but they were both there, and she certainly agreed with Julie Introcaso about the friendship. And the key, that's back in 2014.
Okay.
And marital master Bruce Dalpra also knew about the conflict since then, too. And we know that because Julie Introcaso said so in her sworn deposition.
Okay.
Anyway, not everyone from all those 9 cases is here today, but we have a couple. You can hear more from them directly. And so I just wanted to be crystal clear to everyone what the issue was in those cases. It goes far beyond the alteration of court documents, and for everyone to pretty much just hear Ms. Introcaso and Sternenberg to say it for themselves.
Thank you.
So that's right there is reason enough to support the bill. I'll just add I like the amendments, and I agree there's probably plenty of other good reasons as well. That's all I have to say on this, so I'd like to save the bulk of my time to speak to appeals later. Thank you.
Thank you. Does anybody have any questions for Mr. Albrecht? Representative Long.
Thank you, Madam Chair.
Sir,
Oh.
he has a question.
Yeah, just a quick
Oh,
question.
forgive me.
How do you believe this commission is going to solve all the issues that you're bringing forward?
So I'm just bringing forward respectfully 9 cases in which we know there are serious problems. And so that really justifies the need for this commission. And I would imagine in its existence that more cases with serious problems other than these 9, I think you'll probably hear from Vivian later, would also be representative of cases that a commission like this just might want to look into and figure out what's going on.
Okay, just a follow-up for me?
Certainly.
Yeah,
Follow up.
I don't see in the bill where they're looking at specific cases. So that's where I'm having a hard time tying into how these 9 issues are expected to be resolved with this study committee. I'm trying to get that tie-in. Can you help me with that?
I would gather if they don't look at any cases at all, what are they doing?
Well, they're doing what the bill says they should be looking at.
They're
And the
studying the
cases aren't
family
one of
court
them.
system, but how do you do that without some representative examples of what it's doing?
Yeah, I don't know. Okay,
Yeah.
thank you.
Thank you. Next, we have Robin. Oh, I'm sorry. I apologize, madam. Sir, sir,
Yes, one more.
we have one more question, please.
Here I am fumbling all around. Yes,
Thank you
ma'am.
very much for your time. I'm sorry to drag you back like that. In the bill, it says that on line 28, part 3, the commission shall study parenting cases and decisions by courts within the judicial family branch system. Is as I understand, you're one of these 9.
Correct.
So is it your hope that your case will be used as instructive?
Yes.
To
All of the 9 is
I understand.
instructive.
And may I follow up, please?
Yes.
And
follow up.
so is it, I guess what I'm asking is, are your hope, if I understand, your hope is that these 9 will create a template for exploring further cases? Is that? Like as in a
Possibly.
case review? Is that?
I think these are a great example of things that can make a template. That doesn't mean there aren't some other different types of cases that can't as well.
Okay, I get it. It clicks
Yeah.
now. Thank you. I understand what you're,
Yeah.
what you were getting across. Thank you so much.
You're
Appreciate it.
welcome. Thank you.
All set, Representative
Yes, thank
Altshuler?
you. I'm clear.
Thank you. Anyone else? Seeing no further questions, now you can go.
Thank you.
The next person I have is Robin Partello. We have so many speakers on this. I'm hoping that your
I'll be brief.
testimony will be bringing us new information.
Correct.
Thank you.
Thank you. Good morning, panel. Thank you for hearing my testimony today. My name is Robin Partello. I'm a resident of Nashua, New Hampshire. In October of 2018, I went through the family division in Nashua, where Judge Introcaso and marital master Delpra assigned Kathleen Sternenberg. Moving forward to 6 months later, March 12, 2019, Judge Introcaso personally signed off on 3 specific orders related to the guardian ad litem, her payments, and how I have to comply with her. And in one of the cover sheets from the court, it said my failure to comply with the guardian ad litem would potentially result in my incarceration. 3 days later, Judge Introcaso issued a handwritten order in my case in which she said, I have to disclose for the record that G.L. Sternberg is my best friend. We traveled together. We discussed finances. She is the godmother to my children. And this is a conflict of interest that, in my opinion, cannot be waived. At this point, I looked at the order and I said, it took you 6 months to realize this and to disclose this to me. This is not fair when you are making substantive motions regarding my life, my child, and how I pay for the guardian ad litem. So I filed a Judicial Conduct Committee complaint. While under investigation, Julie Introcaso took my file into her office and altered several of my documents, including whiting out the handwritten portion where she said I had to pay Kathleen Sternenberg. She went on to blame me for this. I didn't do it. I would never do anything like that. She blamed the court staff. They said, we didn't do it. We have no interest in doing something like this. So I had to be prepped by the Judicial Conduct Committee, and in my opinion, the Attorney Waste Act did a stellar job. However, moving forward, I went to the court and I filed a motion saying, can we remove this GAL? There's clearly a conflict. She's an attorney. She had a duty to disclose this conflict with former Judge Introcaso, and it makes you question her ability to testify truthfully if she's not even disclosing a known conflict. despite my request to have her removed as GAL, my new judge said to me, this can be redressed with the Supreme Court. You can file an appeal.
Ma'am, can you stay with the substance of the bill? Your
I'm-
issues are very valid and relevant to a degree, but we really need to hear about
Okay.
the bill.
I apologize.
Thank
so
you, ma'am.
I'm just trying to tie it together, and I'm almost done. So my judge said to appeal it to the Supreme Court, go to the Judiciary, or go to the GAL board. I tried all three. GAL board said you cannot file a complaint until your case is concluded. I can't appeal to the Supreme Court until it's done. The Judiciary said go to your judge and ask. I have no recourse at this point. So that's why, to tie it all together, I think if there was a committee to investigate this, it would give litigants who are in my situation an opportunity to be heard. I feel like my hands are tied at this point, and every state agency that could be helping there's a loophole, and nobody can help me at this point. At this point, that concludes my testimony. If anybody has any questions.
Thank you so much.
welcome.
Any questions for this? Seeing none, thank you for your
Thank you.
time. Next, I'll call on Laura Montgomery. You've asked for 3 minutes.
Yes, ma'am.
Can we,
I will try to make it short.
thank you
even more.
kindly.
Thank you. My name is Laura Montgomery. I'm the mother of 2 children, a daughter currently age 16, a son currently age 6. My daughter and son are from separate relationships. As such, they have separate court cases, both of which I'm labeled the respondent, both of which were heard through the Nashua, New Hampshire court system, and approximately 2019 with JL and Sternenberg, initiating both of those. Since then, it's just gone off of that initial determination by J.L. Sternenberg and former Judge Anacosta. The exhibits that you have in front of you are labeled chronologically. This is especially important given the fact that, in particular note, there was an instance in which Julie Anacosta wrote an ex parte email directly to my attorney at that point in time, saying she was going to appoint Kathleen Sternenberg as a GL
leave them
in the case unless my attorney objected
you.
within the next 27 minutes. I've been going through this process since 2005, every 3 years. 2019 was the initiation that both my exes had started, and essentially that was the point in time I lost both my children. They were taken away from me, citing the fact that my GPS wasn't working and I couldn't make it to the softball field my daughter's softball game was at, and they felt that that was an extreme case of mental disorder, and that was the rationale behind taking my kids away. I haven't had normal parenting time with my children since 2019. Prior to that, I was a primary caregiver for both my children with limited involvement from their respective fathers. This is an extreme upheaval, and it goes against everything that you are required to learn in the CIP classes, everything which is in the best interest of the children, meaningful involvement from both parents. And I am speaking here today in support of a committee and review process for cases in which supporting information is available and has been presented, yet in which the court system is either unwilling or frankly just not wanting to listen and review.
Thank you.
Thank you.
Any questions? Seeing none, thank you.
Thank you.
And that was your testimony that was handed out? The exhibits? Do you have written testimony that you can give us? Yes. Perfect. Thank you kindly. The next person I have here is Angela Lorenzo. Sorry,
Lozier.
Angela Lozier.
Yep.
You've asked for 5 minutes. We're
I'll make it
already
quick. I'm
15
just
minutes
gonna-
past.
Yep, no worries. I'll make
Thank
it quick.
you.
Thank you, Chairwoman and Committee, Children and Family and Law. Again, my name is Angela
Ma'am,
Lozier, and
ma'am,
I'm a
you can't
mother and a
approach.
one.
You have to leave it at the end. Thank you.
My name is Angela Lozier, and I'm a mother of a wonderful 13-year-old daughter. Many of you heard my testimony on Tuesday last week in support of shared parenting. I started out as a full-time mom for almost 12 years, and I offered and proposed a schedule close to 50-50, and now I've become an every other weekend mom for the majority of the year. My entire life changed when Kathleen Sternenberg took my daughter away for no good reason in a 20-minute review hearing before marital master Thomas Cooper on November 30th, 2020. It's hard to believe a GAL can make such an influence on a marital master did decide without any proof of neglect or abuse. Never did I think November 30th, 2021 would result in the outcome it did. Unfortunately, it happened to me in a blink. I am still struggling to figure out why and how Kathleen Sternenberg made her recommendation on hearsay and false allegations before my scheduled final hearing, January 28, 2021. I brought the transcript for you for that. It's only 15 pages. That's all it took to lose the most precious thing in my life. 20 minutes changed my entire life. Excuse me. This recommendation from the GAL did destroy the close and fun-loving relationship between my daughter and me. One would think the court exercising its equitable powers would exercise fairness and good conscience ought to be administered. All relief with the nature of the case and the facts demand. Please understand what the courts did in my case. I'm not just a case number. Only having one child in the judiciary system took that honor away from me. All of this is extremely difficult to comprehend. It is inequitable to change the child's residence in a school on a temporary basis. I feel the findings of fact and ruling of law should have weighed significance in determining the relocation of my daughter. And this is exactly why I support HB 1346, and I hope you will consider it too. We need to study the family court system and figure out why this is happening to families.
Thank you.
Any
Do
questions?
we have any questions? Representative Long?
Sure.
Ma'am, you can have a seat back there.
I was just supporting my friend.
Thank you, Madam Chair. Thank you, ma'am, for your testimony. This is what I need to hear. Did I hear you say that at the beginning you had a 50-50 agreement?
No, I left when she was a year old. I always tried. I think both parents deserve to be involved in the child's life. He had every Thursday, Friday, and every other weekend. When she became 5, he took me to court again for full custody. We went to mediation that time. No GAL. Worked out okay. He then became an every other weekend father. And every other week in the summer, school vacations, anything that wouldn't disrupt her schooling here in Concord. He lives in Dover. Now it's completely flipped. I offered throughout the course of this previous time of November 2019, pretty much every weekend, school vacations, every other week in the summer. My daughter wanted more time with her father. Absolutely, she craved it. And I never wanted to deprive her of that. But yet, when you have somebody that almost has his, and not to say, but it feels like, his hatred for me for leaving him was almost stronger than the love of his child. What father really wants to do this to a mother? It's obviously to hurt her. And he manipulated the GAL. And we'll hear more. I have a few bills I'm going to testify on today. But I really felt when a parent is trying to do the best of their child and the other one's just bashing the other one, and there's no evidence. It's just boggling to me how I could end up like this. And what's scary is I'm very well known within the community. I'm a realtor. I've owned a hair salon business for 22 years, and everybody knows what type of mom I am. They're scared to see what I've gone through. They are scared. They're like, how does this happen? We can't even imagine. You are such a wonderful mom. You and Stella have always been like this. But unfortunately, a child can be bribed. A child can be made promises. A child wants to love both parents, period. And a GAL in the middle of it, no kid deserves to be in the middle. And a GAL does that and favors, is it perhaps the parent that's paying her? Is it, I had allegations made against me when he wasn't getting his way, and then a GAL was ordered. Marital Master Thomas Cooper refused to give him an in-camera interview early into the proceedings of him filing again for full custody. So things were going right. I can't say Thomas Cooper is to blame for everything, but I think GALs hold too much power, and it needs to be overlooked more. Because if you were to read the temporary order and her recommendations and the things that are said about me are horrifying. It's embarrassing. So embarrassing. And I guess I hope I answered your question. I know I probably went off a little.
No, you did.
But I think I was fair. I think I always try and look at things from all perspectives.
Thank you.
Tuesday was very hard for me. I'm very emotional about this. Like Tuesday reminded me of being in court, a mic, people staring at you, being judged. So I'm here today to hopefully say to my daughter and future families that voices can be heard, things can be changed, but you can't stay silent. And I think we kind of stand in numbers today, and I really appreciate you guys hearing us.
Thank you.
Thank you.
I just want to make an announcement for the safety of the committee. I would ask all audience members or people who are testifying to not approach the committee members. If you have something you would like us to enter into the record, please do. Leave it at the first of each end of the table, especially those who are not wearing masks. It's safer for our committee members for you to not approach. So I appreciate that. Thank you very much. And the next person I'd like to call is Vivian Gerard. You've asked for 3 minutes. Thank you very much.
Thank you, Chairwoman and members of the Children and Family Committee. I actually won't even need 3 minutes, but I did
Okay.
that just in case. My name is Vivian Gerard. I'm the mother of 2 daughters, aged 13 and 15. Many of you heard my testimony on Tuesday last week about my struggles getting child support. I had 20 trial court hearings, mostly by Julie Anticaso and more recently, Master Bruce Delpra. I had 4 appeals to the New Hampshire Supreme Court. The rulings came from them, they were all okay. And it's been a 7-year sentence from hell for me. Clearly, something is very, very wrong here. So maybe, just maybe, we should figure this out, what it really is. And that's why I support this bill. If anybody has any questions, I'd be happy to answer them.
Thank you. Any questions? Thank you very much. And the final person I'll call is Alicia Brochu. Thank you. You've asked for 3 minutes?
Yes, ma'am.
Okay.
Thank you. My name is Alicia Brochu. I'm not very good at public speaking. I apologize. I'm here today as a mother, stepmother, and a former legal professional, and I support this bill. Our family courts do have an unbelievable amount of discretion. The only guidance that they really have when determining children's lives is in their best interest. That guidance is vague. Our judges are only human, though they have all sworn an oath to complete their duties in accordance with the law and without bias. Because they are only human, that bias will affect their decision. They can't help it. Sometimes they get it right, but other times they get it wrong. And when they get it wrong, it can have a devastating effect on the children, not just physically and mentally, but also mentally and emotionally. We need this committee to give the legislature the information and the data they need to determine where more guidance to the judiciary is needed. We've all heard the statistics regarding the benefits of equal shared parenting. It needs to be known how often our judiciary follows the science and ensures that when parents are both willing, fit, and able, that our children are able to maintain an equal relationship with both. We all know the devastating effects that domestic violence has on children. As the gentleman in the smashing tie said, there is a task force regarding it. But what is not talked about is the effects of false allegations of abuse and how that has on children. I personally have been a victim of domestic violence in my past relationships, and my family has been the victims of false allegation, and that pain is very real. That trauma is very real for children. We also need to know if the guardian ad litems are performing their duties ethically and without the loyalty binds that where the payment comes from can create. Without all of this data, every attempt of the legislature to issue more direct guidance to the judiciary will be like trying to stop a flood without knowing where the water is coming from. The only ones who will truly suffer are not the parties listed in the case name, but it's the children whose lives these orders directly affect. I believe in the need for the study so much that when my husband said to me, we need to do something, there needs to be a study into these courts. There's been too much going on there. And I said, okay. He said, let's sue the state. And I was like, okay. He couldn't find an attorney to take it, so I said, you know what, let's throw the spaghetti on the wall, let's try it. So we petitioned the Superior Court in Rockingham County to issue a mandamus relief for studying the family courts. Of course, Superior Court doesn't have the authority to issue mandamus relief and create a study, so now I am here looking at you all to do the right thing. We really need this data. The only people that are truly 100% affected by these judicial orders are children, and it's lifelong. And now we have generations of children that are now adults being traumatized by when judges get it wrong. Thank you.
Thank you. Any questions? Thank you very much. We do have one more person who wishes to testify, Eric Brond. Eric, you've asked for 3 minutes. Can we make it even more brief?
I will. Thank you, Madam Chair. I will do my best.
Thank you kindly.
Thank you, Madam Chair and committee members, for listening to me today. There are obviously a number of bills affecting family courts that are on the docket today. I only plan on speaking on a few of them. Most of my remarks and many others here will probably be very duplicate in nature. I am pretty much a lifelong citizen of Nashua, business owner for 30 plus years, father of 3. I do support HB 1346. This committee is seeing an onslaught of bills between this week and last week that all have to do with the family court. This is really all coming in light of the 3 court officials that were removed from Nashua. I believe, and many others believe, that there are many others that have been affected by not just these judges and court officials, but by many others throughout the state. There have been many before myself and the group of people behind me that have tried to make some change within the state, within the court systems, that have kind of given up. It's a very, very hard uphill, icy battle in order to try to make change within the state on a lot of these things. Currently, the judges and masters, the court officials, can throw out evidence, not listen to evidence, use their own opinion as fact, completely erase one parent, completely disable financially another parent, all without any oversight. As you're listening to the testimony over the last week and what you're going to hear today, it should be very clear that there needs to be a look into what's going on in these court systems. There's more than 50% of the population that is affected by divorce and parenting plans. With so many people that have been affected by this, there's been very, very few changes over the years that have gone to help out individuals, families, and parents. Representative Long asked how this bill would help before. As I mentioned, there are so many people that have tried to make change before that haven't gotten the ears of the committees and of the rest of the legislature and the Senate. We're just the tip of the iceberg here, trying to make a change, and we really, truly hope that everyone in this room is listening and that we've gotten your attention and we can make some change together. It's not just the guardian ad litems that we hear a lot about, but it's really the whole entire process that's erasing parents. I've had my children removed from me, from my life, to become just an every other parent when I was probably one of the most involved dads that you can imagine, not just in the community, but in the upbringing of my children, from feeding and changing diapers to teaching them things, to coaching for them and doing all of this, and to practically erase me financially and as a parent doesn't seem like it's the right thing to do to help my children. I think that this review will help find the flaws and make the correct changes that are necessary. As you can see with a lot of the bills that are coming out last week and this week, there needs to be that change. Our children don't deserve just to be with the best parent, as some of the guardian ad litems try to choose. They deserve to be with both parents. And this is just part of the whole complexity to what's going on within the family courts. You also need to look at the financial aspect of it as well. So it's the whole court system that needs to be done. I'll be happy to take any questions.
Do we have any questions? Seeing none, thank you very much.
Thank you.
And with that, I'll close the hearing on HB 1346 at 11:04. Representative Gay, I don't have a pink card for you for this. Oh. Wait a minute. That one was for the other one. Yeah.
I apologize. I was a clerk too.
There you go. Okay, 1436. Here you go. Thank you. Representative Gay, go.
Thank you. What is the appropriate way to address y'all? I should know by now. Just thank you for hearing my presentation for House Bill 1436. To establish the right to a de novo, which means from the beginning. I don't have Latin, but they said that means starting over. Appeal to the Superior Court for Family Court Divisions, because right now you have to appeal to the Supreme Court. And some of the inconveniences of that are, number one, the Supreme Court's extremely busy, and there's only one of them. And the other is that they just review what has happened. So if you were not able to present testimony, excuse me, I don't know what I ate. If you are only able to, or you were not permitted to present evidence and testimony, it's still not going to be in the record or reviewed. So if you start over with Superior Court, you can have your case reheard. And it's true, there is a risk in there, because they said over 90% of the cases are pro se. So, I mean, you're stepping into something that, you know, a good attorney could just work right around you, but hopefully the truth will out. So that's the conclusion of my testimony. If anybody wants to ask questions, please.
Any questions? Seeing none, thank you very much, Representative.
Thank you.
Next, I'll call Mr. Richard Head.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. Just in terms of background, the Superior Court would be where these cases would be appealed. Currently, there are approximately 21 Superior Court judges. They hear about 17,000 plus cases a year currently. If we were to incorporate family division into the Superior Court on de novo trials, so essentially starting over again, going to make the parties start over again, the courts are going to start over again, the evidence is going to start over again. You were talking about a significant increase in caseload in the Superior Court where they don't currently do family cases. So if you currently in family division, and again, family court doesn't exist anymore, we're talking family division of the circuit court, there are roughly 25,000 new or reopened cases there that would all be eligible for appeal on a brand new case, essentially, in Superior Court. The increase in load, the increase in complexity of managing the Superior Court is going to increase exponentially if these cases were all appealed, or some significant percentage of them are appealed on a de novo basis to the Superior Court. I can't say how many are going to be appealed, but it's an inevitable significant increase in caseload where they're simply not currently set up to do that. I don't know that that's, the other aspect of this bill, it doesn't talk about what type of decisions can be appealed, it just says aggrieved by the decision. In the course of any particular case that's pending, there are numerous decisions that are being made along the way. And it's just unclear from the bill as to whether or not we're talking every decision that is being made at the family division is appealable to the Superior Court to be heard over again. You're going to cause a significant load in the Superior Court. You're also going to potentially create significant additional costs for the parties. Especially you have the non-appealing party who's now going to have to try that entire case over again. There are just significant complexities that I think are not obvious from a fairly simple bill that simply says you can have de novo appeals to the Superior Court. I think what that would entail is significant and not currently manageable in the system we have today. I'd be happy to answer any questions with that.
Thank you. Any questions? I don't know who raised their hand first, so will Representative Long.
Thank you, Madam Chair. So, Mr. Head, when we set up the family division, that was to expedite out of Superior Court, correct? That was to expedite these cases?
No. Family division was established as part of the creation of the circuit court. So there was a consolidation of family court, district court, and probate court, all of which operated separately, and brought them under the new circuit court. A lot of it was a budgetary issue, so a significant reduction in staff flowed from that, and just some other efficiencies. But no, it was not a Superior Court operation. It was a family court operation prior to that.
Okay, follow up, if I may?
Certainly.
So there was no expedition with respect to this family division the circuit court being set up. It was financial.
My understanding, I wasn't involved in 2011, but I think a lot of it was both efficiency and financial.
Okay.
That's my understanding.
Okay, thank you.
And the next person, Representative Belanger.
Thank you, Madam Chair, and I'm going to preface this because, and I will get to my question, just there is a preface to that. So, I've been to family court myself twice now for 2 different cases. one, to adopt my nephew, and one to obtain, one to obtain custody of my niece. The second case, we have a judge who tends to think he has a lot of power in that courtroom, and in fact mentioned to me directly that it's his courtroom and his rules. So with that being said, for many families that are dealing with the same issue and the same judicial discretion that is slightly more inappropriate, if you will, what is the current appeals process for families like myself and some of the families that are dealing with that power-hungry judge, if you will?
So there's a couple aspects, I think. Thank you for the question. There's a couple aspects. One is appeals on the decisions being made to the Supreme Court. There are, if the judge is acting in a way that is unethical, there's the Judicial Conduct Committee, which would enforce, as you heard earlier, specific rules of conduct. Some of those could apply to the circumstances you're talking about. I don't know the specifics. There can also, some people would at least flag any issues for the administrative judge of the circuit court, Judge King. But in general, what you're talking about are appeals to the Supreme Court on decisions, appeals to, or complaints filed with the Judicial Conduct Committee on ethical violations, and on the basic administration of the courts, Judge King.
Follow up?
Yes, Madam Chair, thank you. Thank you for answering my question. So basically what you're saying is there's already an appeals process. If I can clarify, there's already an appeals process to the Supreme Court, correct?
Absolutely, yes.
Okay, so
Follow up?
So this bill is saying that you can appeal to the Supreme Court, correct?
No, this bill would say that any party aggrieved by a decision of the family court shall have the right to a de novo appeal in the Superior Court. And actually, one other defect in the just the way the bill is phrased, it says has a de novo appeal in the Superior Court in the county in which the aggrieved party resides. Not all the parties necessarily reside in New Hampshire, so it would be unclear, at least as the bill is written, as to where those appeals would go. I'm sorry.
Final follow-up?
Yes.
Thank you.
So for those of us who don't know what a de novo appeals is, can you kind of, I don't want to say, for lack of better terms, dumb that down, but
It's a start over. So nothing in the original decision would apply to the Superior Court. In that case, you essentially start over again. So it'd be as if nothing had happened. You file a new petition. In this case, it would be an appeal in Superior Court. Unclear, sort of the way the bill is written, as to whether or not you would start discovery over again. But typically, when you're in Superior Court, you have a period of discovery. And you have motions that are filed, and you have a trial if a trial is warranted, or if it's not resolved in the pleadings. So again, it's a start from scratch proceeding.
no further questions, and thank
you.
Thank you. Representative Grossman, did you have a question? Thank you. Representative Altrill, did you have a question?
Yes, thank you, Madam Chair. Thank you very much for the explanation, and I'm curious, Mr. Head, what does the appeals docket look like right now? It seems that what we're hearing is that the process is either so backed up, maybe, or arduous to access that that we have this bill sitting in front of us. So what does the administrative judge's appeals docket look like?
The family division appeals, you mean?
Yeah, that's what we're talking about, yeah.
So currently in the Supreme Court, from the family division, in taking sort of 2019 through 2021, there were between 184 to 193 cases that were appealed to the Supreme Court each year. So 2019, 193, 2020, 184, and 2021, 186. That's roughly 25 to 30% of the Supreme Court's caseload. And then within family division, of course, you have a host of types of cases that are within the jurisdiction of the family division. So that includes abuse and neglect, adoption, chins, divorce, domestic violence, family, sort of general, guardianships of minors, juvenile delinquency, paternity, and termination of parental rights. All of those under this bill would, in theory, be appealable to the Superior Court for a start-over trial.
I'm sorry, could I get a clarification on what you just said?
Follow up?
Yeah, follow up. Correct me if I'm wrong, please, but that was a lot of numbers real fast.
Yeah, I'm sorry.
No worries. Did you just say that there are between 184 to 193 appeals from the family division pending? Did I catch that correctly?
Every year, so those are annual
Annual.
files. So there are not. So taking 2020, for example, there were 184 appeals filed in the Supreme Court from a family division decision. Of those,
Okay.
so like the termination of parental rights were 68 of those. 15 of those were abuse and neglect. 31 of those involved divorce decrees, so on, et cetera.
Okay. May I gather a further clarification,
Follow up?
Madam Chair?
Sure.
Thank you. And of that number that you just gave us, of that range,
184.
yep, 25, are you telling us that 25 to 30% of the Supreme Court's total caseload is reviewing these appeals? Did I understand that correctly?
Yes, I think so. So approximately 25 to 30% of the total number of appeals filed, approximately 25 to 30% are appeals from the family division.
From the family division alone?
Correct.
Okay.
Which then has, within that division, a wide range of types of cases.
Okay, thank you very much. I think I get it.
Any further questions?
Actually, may I inquire, the numbers that you have, is that submitted to us and I just haven't seen that?
It was actually submitted, so Judge...
Oh, is that in the email?
No, so...
I'm sorry.
On, I think, the 11th, Judge King, Judge Ashley, and Judge Lemire all came and presented to this committee, and this was part of Judge King's testimony, and he submitted some written documents when he testified, I think, on the 11th of January.
Yeah,
I
okay.
might have that wrong, but so
Thank
this
you.
is from Judge King's testimony when on the introduction session for this committee.
Okay, to also be applied here.
Thank you.
Got it, thank you.
Thank you very much. Sure, Representative Long?
Thank you. Are there any cases that are denied?
I'm sorry. say
Appeals
that-
cases to the Supreme Court, do they deny any of them? And would you know what that
So,
was?
fair question. So, appeals from Superior Court and Circuit Court are mandatory appeals in the Supreme Court, so they're not subject to discretion as to whether they accept them.
Okay.
If you're asking whether they accept them, they accept all of those. There's some
So they
technical
can't
variations that I
deny-
won't need to get into.
So
If
the
you're talking
100
about the decision on the merits, I don't know how many are.
No, but as far as what's the appeals that are being, the numbers you gave us, they can't just deny.
They're not rejecting
they're
the
not-
appeal
They're not
unless,
able to reject the appeal.
you know,
Okay,
absent
great.
technical defects
Yep.
or, if they're not yet a final decision on the merits. There's some
Okay.
in-between stuff too.
Thank you.
Thank you, Mr. Head.
Thank you.
The next person is Katrina Heinrich. You've asked for 3 minutes. Thank you again, Ms. Heinrich, and if you have written testimony and can
We'll get
submit
to you.
that, we'd appreciate it.
Yes, absolutely. I'm Katrina Heinrich. I'm not going to need the full 3 minutes due to some information has already come out. There's no point in doubling down on that. For my experience and the cases that I've observed or participated in, the access to appeals, filing fees, tools, resources to the family court causing undue burden occurs in the 20% of the family cases that I'm speaking about. Access to law and legal protection seems to be almost void. In my case in particular, like most other cases, the numerous barriers to access a fair review with a higher court or functional deterrence do exist. One of the biggest ones, of course, being financial. All attempts at trying to follow the processes that were in place at the time have been caught in loopholes, and they continued to deter me. I mean, that was effectively what they did. So there was no opportunity in any way to get a review, and that's all I have to say.
Thank you. Any questions? Seeing none, thank you very much. The next person to testify will be Alicia Brochu. And you've asked for 3 minutes.
That's correct. Thank you. My name is Alicia Brochu. Once again, I'm in support of this bill, and once again, I'm testifying as a former legal professional, a mother, and a stepmother. As it states in the methodology of this bill, the Supreme Court appeals are a matter of, basically they're a matter of law, not of fact. So what it doesn't state in the methodology is that except for the first final order out of a family law case, the Supreme Court appeals are discretionary. They're not mandatory. So what that means is that if a person files an appeal with the Supreme Court, unless it is the first final order, the Supreme Court can use their discretion to not hear the case. And then, because of Supreme Court rules, discretionary appeals, when they kick it out, they don't even have to give you a reason why they're rejecting it. So that means that this leaves the majority of the parties with a family law order with no recourse if the orders are in violation of the law, or if the violation is of facts which caused a violation of the law. Family cases can and usually do have several final orders, especially when the parties, per statute, have the right to reevaluate child support every 3 years, or if there's a substantial change in circumstances. My husband has appealed to the Supreme Court 3 times with 2 cases. All 3 times the Supreme Court justices decided that it was discretionary, so they were not going to hear them. 2 of those cases were in front of the Supreme Court at the same time. Both were for child support. In the first case, the issue is whether or not the child support order was legal due to the fact that the judiciary 9 years earlier effectively terminated his rights and issued a lifelong no contact order. But then 9 years later, same court, same judge decided to issue child support, even though there's a statute in place that specifically states that any order that permanently severs the parent-child relationship also severs the responsibility to financially support the child. That's the TPO, Termination of Parental Rights statute. The other case is in a different court with a different judge. My husband in that case has 80% residential responsibility, with the mother having 20%. But yet the judge decided that her monthly child support obligation was $0 a month. The factual reason was because she determined that the parents have approximately equal shared parenting. Not only, as we know, equal shared parenting is not a reason permissible by statute to deviate from the child support guidelines, but last I checked, 80% and 20% is not even remotely equal. By allowing family court rulings to be appealed to the Superior Court, it will allow parties that are aggrieved by the family courts to have that right to review. The way the system currently functions, there is absolutely no recourse when a case is opened again and again. Once a family law judge makes a ruling, whether it is right, wrong, it is done. If they made a mistake, there is nowhere to turn to fix it. The family court judges are aware of this, and last I checked, that's not the definition of justice, that is actually tyranny. Thank you.
Thank you. Any questions? Representative Long.
Thank you, Madam Chair. So, I mean, I've been hearing an hour of all the court systems are not doing their due diligence.
Yes.
So why would going to another court help
Because,
that matter?
Mostly, a little backstory for the past, 5 years. We've been basically trying to build documentation, and it's kind of hard because going to another court, it just gets that eyes in place. And right now, for instance, the case where my husband's rights were terminated, and then now he has to pay child support 10 years later, the judicial referee in that case actually threatened to default him if he didn't create a crime, if he didn't illegally access my personal banking information, even though we are married. We keep everything separate, so he has no access to my bank account information. She point blank said, if you do not tell me your wife's income and her bank account information, I'm going to default you. We filed a complaint with the Judicial Conduct Committee, and that went nowhere. We went to the Attorney General's office. They said they didn't have jurisdiction. We filed a federal lawsuit. That went nowhere because of judicial immunity. We even contacted the FBI to say, hey, maybe you guys can do something about it. I think it's the desperation that people need right now, because not only are these judges and court actors, they're not upholding your statutes that you guys passed. They're not upholding them. They're finding ways to go around them. But then you go to all these other agencies and they don't want to do anything about it. So I think that filing the appeal to the Superior Court it's going to create that paper trail, because that's what you need. You need to have that paper trail in order to have more effective action by the legislature, because that's what checks and balances is about in our government.
Right, thank you.
Thank you.
Thank you. Any further questions? Thank you. Seeing none, I will move on to Dan Albrecht. You've asked for 5 minutes, and we're 35 minutes over our time, so if we can make it brief and not repeat information we've already heard, I'd appreciate it.
Thank you, and I
Thank
think I can do that because a lot of people earlier covered points that I wanted to cover.
Yep.
So, again, for the record, my name is Dana Albrecht, and you heard me testify previously, and I support this bill. I've had a lot of appeals in my case, and I'll get to that momentarily. But echoing the prior testimony, there's a lot of cases where appeals simply don't get heard at all because they're discretionary. And so you have fundamentally no right of appeal to anywhere of a family court division. And I've got an exhibit, if that could go around. You don't need to look at it now. You probably don't even need to read it all. It's just a good case study.
Thank you.
In how this happens. But first, I'd like to address something that the judicial branch said in their analysis of this bill. They talk about a scenario where half of family division cases might be appealed to Superior Court. So I guess my question for them is, are they saying that the family division is so messed up that in half of all cases there's an aggrieved party who is sufficiently aggrieved to want an appeal? Because if that's true, we've likely got a much bigger problem than we could solve with any of these bills, so maybe they could address that. Next, I'd like to point out that at the state level, 41 of the 50 states have an intermediate appellate court. There's only 9 that don't, and we're one of them. So back to my case, where I've actually filed a number of appeals. And again, the exhibit is simply a case study. You can find others. I don't expect you to read it carefully. Heck, the trial court sure didn't read any of this stuff. It was their job. They didn't do it. So, So just please remember that I had Paul Moore, Master Dalpra, Kathleen Sternenberg, Julian Turcaso, Mark Derby, all deciding my family's fate. And I just want you to realize that if I thought their orders were wrong, in practice, I don't necessarily get to appeal to anyone. And there's your case study. Let me tighten this up. Just pointing out, we have mandatory appeals under Supreme Court Rule 7A and discretionary appeals under Supreme Court Rule 7B, which require a process called certiorari. You heard more on that earlier. If you need more from me, you can ask me in the questions. This is typically because of the caseload up at the appellate court. So, for example, the U.S. Supreme Court would only hear 4 to 6% of all cases. They just don't have time to hear all of them, so they take the biggies of national importance, and those are the ones you read about in the news. Again, that's U.S. Supreme Court. And again, the big problem I'm trying to bring up is the state Supreme Court kind of works the same way. They don't have to hear your case. And I think you already heard in prior testimony the situations in which they don't, so I won't repeat that. So just a quick note on that case study. What we've got here is a case in which all of the judges involved, Julian Turcaso, Mark Derby, claimed not to actually know anything about the orders they signed. And so I wanted to appeal that. And I had no right of appeal, so I guess my rhetorical question to this committee is, what's my remedy in this situation? I mean, I sent it all the way up. I wasn't expecting the U.S. Supreme to hear it. I mean, I'm not of national importance. But it's really, that's why it's such a good case study in which there is no recourse. And this was just about a Julian Turcaso order where they wouldn't enforce my cross-country parenting plan. All I was trying to do was get a cross-country parenting plan enforced. And when the trial court didn't do that, you know, I wanted to send it up, and I couldn't. So that's the issue there. And I would just point out where all the family court judges involved claiming to know nothing about the orders they signed. I'm not making that up. That's in the official record. It's in hearing transcripts, and it's in sworn JCC depositions. So I guess kind of I'm saying, if we think we got the wrong decision, why can't we go up to some next level intermediate state court as an appeal by right, just like we can in 41 other states? Finally, in closing, I'd also say that most of the complaints I've heard from other people about family court involve a claim that the judge got all the Most of the complaints I've heard from other people about family court involve a claim that the judge got all the facts wrong, typically because they failed to read pleadings at all or failed to look at evidence at all, along with some kind of documentary evidence that the aggrieved party claims proves that. Again, they're just making a claim. My question is, what's the remedy if an aggrieved party wants to make that kind of claim? And I think it's the Superior Court, and it's not our Supreme Court, and that's why I support this bill, and I'd be happy to take questions.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
You're welcome. The next person I have is Vivian Gerard. And you've asked for 2 minutes?
I might not even need that much.
Okay, thank you.
Thank you, Madam Chairwoman and members of the committee. Again, my name is Vivian Gerard. As you heard my testimony earlier, I'm just a mom. I'm not a lawyer, but I had 4 appeals to the New Hampshire Supreme Court, and my lawyer won all of that for me, and it's still not fixed. It was extremely expensive and probably took a toll on the court system. It definitely has taken a toll on my family. I've heard some of these complex case dockets were someplace, but where? I found them in the basement of the courthouse. I guess I don't count for that, huh? Hello? It's like Bueller? 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 Does anybody know that reference? Or maybe not. Is it the Supreme Court the only way to even try to get my case fixed? Anyways, a question for the committee, and you don't have to answer this right now. Do you think if my case had just gone up to the Superior Court the first time around and stayed there, that I'd still be in this mess? Anyways, at Julian DeCasso's plea hearing and sentence hearing, my friends and I actually even tried to intervene at the Superior Court just to have the right to be heard. That's all. Judge Temple denied that and said that my complaint related to my specific case and there are other remedies. So can anyone on this committee tell me what those remedies are? I guess parking my truck out front of the National Court didn't work. Because in the document I handed out to you, that's my truck in that photo within that exhibit I handed out to you. So that's why I'm trying to support this bill, and I'll take any questions that you may have.
Thank you. Any questions? Seeing none, thank you very much. Next person will be Angela Lozier. And you've asked for 2 minutes?
Yeah, maybe not even. I guess this past year, oops, thank you, Chairwoman. Thank you,
You're
Family
welcome.
Committee.
You're welcome.
This past year has really made me learn about the court process a lot more, something I never thought I would have to do, and I'm still learning. My name is Angela Lozier, as you heard me earlier. In my situation, where a GAL made her recommendation in a temporary hearing, and a judge signed off on it, and I went 8 weeks on a temporary order that then turned into a permanent order. It's terrifying to think, what do? I don't know what to do. I've been told you go to the Supreme Court, and then I hear stories like other people that tell me, good luck, good luck. To me, that's scary. I'm already petrified of the result I had. Do I want to emotionally keep putting myself through that and my daughter? No. It would have been nice to have a de novo hearing, to maybe have all the evidence, to hear both testimonies, without anybody being biased in my situation. We would hope that we wouldn't have to go there, right, to the Supreme Court or the Superior Court. We would hope that people that are evaluating our families would do their job, so we wouldn't have to have more emotional stress, and keep asking for things when they're not being looked at. So I guess learning, like I said, to me this seems like a bill that would help a lot of families, and therefore I support it. Any questions, I'm happy to answer, but again, I'm just a mom. I'm not a lawyer. I don't know a lot about it. But to me, and what I've heard in testimony today, it would give families a chance, if they weren't heard, and maybe hold people accountable to do their jobs, so it wouldn't be handed down and down, and then objected, and then it just seems very complicated. And I don't think the average person that's trying to work and provide should know these things or have to pay the expenses to get justice. Like, I just feel people should do their jobs, and we wouldn't have this, right? We wouldn't be sitting here today. So thank you again, Madam Chairman. Thank you, Family Law and Committee.
Thank you. Any questions? Seeing none, thank you very much.
you.
And our final person will be the Honorable Dan Itza. You've asked for 5 minutes.
I'll do my best to be less. Thank you, Madam Chair, members of the committee. For the record, I'm Dan Itza. I currently reside in Manchester. The most critical aspect of this bill is the de novo nature of the appeal. The problem arises primarily out of the manner in which evidence is received into family court. A person in family court can be confronted with what I call ambush evidence, something that they were not aware of going into the hearing and therefore are not prepared to rebut. It can be by the opposing party, it can be by the GAL, but they are then stuck. Unless they or their attorney, if they have one, is well enough prepared to make an offer of proof, then they can make no more rebuttal of that in any future proceedings. Their first recourse is what's called a reconsideration, in which you bring the case back before the judge that just heard the case. And in that case, not being able to enter any additional evidence, the probability of achieving a different result is extremely low. Sometimes you can get a reconsideration before a different judge if you can make cause for the judge to be recused from the case, or you can appeal to the Supreme Court, which may or may not hear your case. In any case, you can't present any additional evidence because you're limited to what was before the original hearing. A lot of this can be alleviated by statutes you might contrive to regulate or require evidence to be submitted. The other thing that you heard was instances where the judge openly defies the statutes the legislature has instituted. There is recourse for that, but that also resides with you, and it's under Part 2, Article 38. I would suggest you read it. It's for maladministration in office. I'd be happy to answer any questions.
Thank you, Representative. Any questions? Seeing none, thank you very much. And with that, I'll close the hearing on 1426. Thank you. I'm sorry, 1436. And does anybody need a refresher break? Huh? Soon. Okay. So with that, I'll open the hearing on 1265. And again, Representative Gay, I don't have a pink card.
I'm so sorry.
That's okay, thank you.
Haste is so important right now.
We're going to try to do a little bit of catch up here. So we'll, with your permission, we'll go to about 12:30 and then break for lunch. Does that sound good? Is that okay? Okay, thank you.
Thank you.
Go ahead.
Thank you for your caring. I feel that way. Okay. House Bill 1265, relative to a judge's discretion to set aside rules in family court proceedings, is totally legal right now. The judge, the magistrate, marital master, whoever is in charge of the proceedings, is permitted to set aside any of the family court rules. And so that means that when you come in as I don't know to call it litigant, a participant, party, when you come in, you don't have any rules that you can cling to state your case, because any of the rules can be set aside. So this just very simply says they can't do it. The rules that are there need to be followed. And somebody said, well, if they're going to set aside fees, don't you want them to be able to do that? So we added that. And my personal feeling is it's not in the bill because it's not polite. If it's a bad rule, don't have it in the rules. So that's my whole testimony.
Thank you. Any questions? Representative Long?
Thank you, Representative Gay. I mean, every governing body has rules that they're allowed to override those rules. I mean, we have it in the House.
We have to
We
vote.
have rules,
We have to
and we
vote
could
on 'em.
change those rules when we vote on them, correct? So, I mean, I'm trying to grasp how rules don't get changed. Once they're established, they wouldn't get changed until yearly, or, I mean, any,
I can answer?
sure.
I'm thinking there must be a process where the rules are made. And this is just one of the rules. Unfortunately, it's the very first rule that all the subsequent rules can be overruled. I understand discretion sounds really great. Maybe there ought to be a set of rules that are discretionary. But as it is now, we have pages and pages of rules that nobody can count on because it's the option to ignore them. And I don't think that is fair for people to go in on what's a very scary situation and not have anything to be confident about.
Okay,
Okay.
thank you.
Thank you. Thank you.
Thank you. Any further questions? Seeing none, thank you. Oh, I'm sorry. Please.
Oh, I'm sorry.
Thank you, Madam.
Representative Belanger, you have a question?
Thank you, Madam Chair, and thank you, Representative Gay, for being here and answering the questions for this committee. And when we refer to judicial discretion, what exactly, in an example, can you give me as to what you're trying to solve? What's the problem that you're trying to solve as far as judicial discretion?
Well, since I'm not an attorney and have the rottenest memory in the entire world, I could compete. I'm thinking that so many of the examples given today of things that went wrong were against rules. They weren't following procedure. So I'm going to guess that among the many, some of those happen to be violation of, not violation, but setting aside rules. There are many pages of rules, but I just stopped at the first two. The fact that people don't have the, are denied rights because there aren't any rules they can count on.
Any further questions?
Thank
Seeing
you.
none, thank you, Representative. The next person I have is Richard Head. You've asked for 5 minutes.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. The ability to waive rules is one of those sort of necessary concepts that a judge needs to be able to have to ensure that what they're doing makes sense in the context of a specific case. There may be, you can disagree with a specific decision to waive a rule, but if the judge is going to have an orderly and thorough opportunity for the parties to be heard, there are instances in which rules need to be waived. What is unclear from this bill is is there a specific rule that we're talking about as opposed to all rules, all context, all family division cases? Because again, we're talking about a wide range of cases that fall within family division. Each of those types of cases has their own sort of body of rules. And really what we're talking about is a blanket rules must be applied whether or not it's going to be fair in a particular circumstance or activity. So we're talking about the rules regarding adoption, domestic violence, guardianships, marriage, termination of parental rights, and a host of others. And this statute would say, under no circumstances, in all cases in the family division, the judge has zero discretion in waiving any rule, no matter how inconsequential that waiver may be. And in fact, not waiving may prove to be harmful. We're talking about, as I said before, 25,000 cases being filed. Every one of those has their own nuances and change and little quirks about them. And maybe a rule needs to be waived in order to provide fairness to the parties. What this statute says is, nope, no waiver, no rules can be waived, sorry. You have to follow exactly what the rule says, no matter how unfair it may be. And what is unclear from the bill is, are we talking about a specific rule? And then secondarily, and I think the question was raised, is should the rule be changed? And if the rule should be changed, there is a rules committee in the court system. That rules committee does have a member from the House of Representatives and a member from the state Senate that sits on it. If there is a rule that should be changed, really the best vehicle and process for that is to go to the rules committee and say, there's a problem with this rule, you should look at it. And that can be introduced through the representative member, through the senator member. But I think what we're talking about is, the operation of the court that is typically maintained through a court rule, not through a statute that says, we don't know what rule we're talking about. We think you should apply them all without regard to any waivers. I think it's too broad, and really the proper process is, are there specific rules that are at issue, and if so, those rules should be evaluated through the process of drafting rules. And there is a process, and there is a membership that can allow the House or the Senate to bring those forward. I'd be happy to answer any questions with that. Thank you.
Thank you. Representative Grossman, you have a question?
Thank you, Madam Chair. Thank you for coming today to our committee. So who sits on the Rules Committee? So there's a representative from the Senate, the House, and then...
And I apologize, I had it last week for another hearing, and I forgot to bring the list of who's on it. It is on the court's website. If you just search for Rules Committee, the membership of the Rules Committee is on that.
Okay, great, thank you.
Representative Belanger, and then Representative Long.
Representative Long can go first.
Representative Long.
Thank you, Madam Chair. When a judge waives the rule, is there always an explanation as to why he waived the rules? Is that required? Is that a rule? That he's required to do that?
No, it is not. The rule does not say that. It just says that, rules can be waived except if required by statute.
Okay, they don't need a reason. They don't have to tell the parties what the reason of this waiver is.
My experience is they do, but I can't cite you a rule that says that they're required to put it in writing or tell the parties.
Okay. Thank you.
It's my general experience is they do.
Thank you. Representative Belanger.
Thank you, Madam Chair, and thank you, Mr. Head, for being here today. Is it not an advisory committee?
That's correct. That's correct. They don't write the rules, but they do they bring input on the rules.
Follow up.
Can you give me a definition of the difference between an advisory committee and someone who tells somebody? Can you give me the difference between an advisory committee?
Thank you for the question. An advisory committee is what its title suggests. It provides information and recommendations. It does not have the authority to implement.
Follow up, Madam
Follow
Chair?
up.
So with respect to an advisory committee only, if someone has an issue, that representative or that senator could maybe say, we advise that we change that, but it doesn't have to get done. Is that correct?
That's correct. But that is the mechanism, and that's the process by which our rules are developed, is with input from the advisory committee.
So I guess, may I follow up again? I
Final
apologize.
follow up.
I don't know about that, but we'll see. I guess I'm just kind of curious, why would the, you know, why does the judicial branch feel that having such a high judicial discretion and then only having an advisory? I mean, if you look at this bill, it is bipartisan support. Both representatives and a senator on each side of the aisle. So I'm curious why the judicial branch doesn't feel like this is a problem. Because it is.
I think what we're talking about in terms of what I'm presenting is the rules go through a fairly substantive process, both with the Rules Committee, which, as you said, is advisory, and the court itself to implement the rules. If there is, I suspect there are going to be people who will testify about a specific rule in a specific instance. If there are specific rules that should be reevaluated or considered, I think that's a more structured way of approaching it. Simply saying we are eliminating all discretion in all circumstances with regard to all of the court rules in family division, I think the level of unintended consequences that flow from that can be significant and severe. And what I'm suggesting is that when we're talking about court process and procedure, the mechanism for doing that is through the rules and through the rules that apply that are created by the judicial branch. So I do think it is that process is an important one to follow.
Thank you. One more? Final one. Okay.
Thank you, Madam Chair.
You're
Thank you for
welcome.
answering the question. So I'm a judge, right? And I choose to use my judicial discretion to make a decision that I feel is the right way based on my own personal experience of the case that's being presented in front of me. So I make a huge change, and I'm using this as an example, because I have that judicial discretion, but I have maybe unintended biases towards a party. Do you believe that that's not being taken advantage of in many family case hearings?
I think there are, as I said before, roughly 25,000 cases filed every year. I think the judges work very hard to implement the intent of the statutes that they're following and the rules that are before them. And they are trained and they receive training on a whole host of areas of law. Whether or not mistakes get made, I can't say no mistakes are ever made in the family division. But I do think that the judges, when we're talking about cases involving children, they try very hard to apply the best interests of the child standard. I think if there are instances in which a rule needs to be waived in order for them to receive information about the best interests of the child, they may do that. You may get some better insight if you ask the question from Judge Lemire this afternoon. She unfortunately had a trial today and won't free up until after 2 o'clock. But I think you have judges that are working very hard to do what is described in the statute and applying the rules to achieve the result that the case, the facts, and the evidence present. Sometimes what is being heard in court has to be the evidence that the judge is relying upon. And the judge is going to make the best decision based upon the evidence that is presented and based upon the statutory guidelines that are provided. I think in the vast majority of these cases, you have a very diligent judge doing that. I'm not going to make excuses for Judge Introcaso. I'm not going to make excuses where somebody like Judge Introcaso has done something wrong. What I am saying is that this bill would, in all cases in the family division, in all circumstances, prevent any discretion on the part of the judge. I think that is a step further than really what it is what is the goal of this committee. I think if you have a specific rule that has been waived and has been waived unfairly, that's a different conversation than what this bill is, and I'm just here to address the bill, which says all rules cannot be waived under any circumstance, under any of the types of cases that are presented in family division. And I think that the unintended consequences from that are significant.
Thank you. Representative Rung?
Thank you, and thank you, Mr. Head, for taking my question. You made a couple comments in your opening statement that waiving rules is often necessary for orderly and thorough hearings, and that not waiving could be harmful. Would you provide an example or two of that, please?
One, I probably wouldn't say often. So if I said often, that was unintended on my part. It's probably a better question for Judge Lemire, and I apologize. I did not sort of take a survey ahead of time on what circumstances they may be considering a waiver of a rule. Usually it's a timing issue, but it's probably a better question. I apologize. I just didn't come up with examples before today.
Okay, thanks.
I apologize. I'd like to declare that Representative Rung is a co-sponsor on the bill. I should not have called on
Oh,
her.
I'm sorry.
I apologize for that, but thank you for answering the question anyway, Mr. Head.
Right.
But we do have one more question from Representative Wazir.
Thank you, Madam Chair, and thank you for taking my question. This question is more of a broader that I have been hearing all these bills so far. So the question is, I have been hearing thousands of bills or thousands of cases are being filed each year, and there are backlogs. In the court system, how are they prioritizing those cases? Do they go by the dates that has been filed, or based on the case scenario? I'm just trying to wrap my head around this.
So it's a fair question. So as I said, circuit court has roughly 125,000 cases, and that involves probate division, district division, family division. Probate division is sort of set aside because those are largely now being handled in Concord at the Administrative Office of Courts, where they don't need to have trials. So that's sort of a separate issue. So I'm going to set that aside. District division and family division, those cases are prioritized in a number of ways, and I won't get them all. But so, for example, criminal cases may have, if there's a potential for a jail term, those have constitutional priorities. There are some statutes in which the legislature has provided priorities within the statutory language. It is a question also sometimes of how long is the proceeding going to be? Is it a 30-minute hearing? Is it a 4-day trial? So, it depends on what judges are available, what other cases have to be heard either through a constitutional requirement or through another statutory deadline. So, for example, during the course of a day, domestic violence petitions may be filed. You can have termination of parental rights cases that are pending. Various, as I said, family division is not just divorce. And each one of those may have their own internal required deadlines, and then you have those that have no specific deadline. Within family division, they roughly are able to get to a final decision in roughly 75% of the cases within a year. And then beyond that, some of them do take multiple years. Some cases are heavily litigated and have just boxes and boxes of pleadings. And those tend to just take longer, and they're just highly contested. Obviously, the goal is we have sort of internal goals of trying to get a certain percentage out within 6 months and within a year, but it's managing the entire docket, and that's done by staff at each of the courts. They know, basically you don't want aged cases to continue to sit. So, it's really a very complex case management role that our clerks handle every day within each of the courts. And it really can be fairly complicated. With regard to backlogs, there clearly were some things that were slowed down during the course of the pandemic. I think during, I can give you roughly in circuit court, I'm not talking family division, but circuit court generally, they were holding, even through the pandemic, about 15,000 hearings a month. And it's a very busy, complex system that gets set up, but I can't give you, any particular case is going to be heard within a certain period of time. It's the clerks working very hard with the mix of cases that they have before them, and what have fixed statutory deadlines, what have constitutional deadlines, what don't, what's the length of the proceeding, what are the unique circumstances, an interpreter needed, a whole host of things go into scheduling. Long-winded answer, I apologize, but there's no easy sort of shortcut to sort of how these things get scheduled.
Thank you, Mr. Head. Any further questions? Seeing none, thank you, Mr. Head.
Thank you.
I'll call Katrina Heinrich.
Thank you. I am Katrina Heinrich. Just listening to our judicial representative, I wonder, a question popped into my mind. He talks about the complexity of the cases. Does the system itself, is it such a complex system that our judges actually use and waive the rules in expediency and haste? It's just a question. I'm going to quote from Goldstein, well known for his research on this topic. He stated that professionals who looked at these cases found a pattern of mistakes and dangerous outcomes. Court professionals reacted defensively to any research questioning of their practices. The assumption continued that when the decision was made, it was right. Our friend from the Judicial also talked about reasons being given. And at no time in my case have I been given any reasons for the waiving of rules or rights or anything else. One of the biggest examples I have on that leaves to question if the family court judges have evolved to rely on the ability to just dismiss and apply specific rules that they choose. 1.2 and 2.2, which I spoke of earlier, waives the right to due process. You cannot submit evidence. You cannot have witnesses. All the cases we're talking about have that similarity. In my specific case, I have an issue for the fact that envelopes are being passed in court with, we don't know what in it. We don't know if it's evidence. We don't know if it's money. We have no idea what's in these envelopes. And they were being passed from the guardian ad litem to the judge. The judge was accepting them. The judge would peek in them. And we never knew, regardless of our question, the right to see it. So with that said, in my case, the New Hampshire rules that were consistently abused and dismissed was Rule 1.2 and 2.2. Specifically for me, it was evidence. You cannot get evidence in. One of the other issues that is really huge in all of these cases, and I'm sure if they all take the time, the requisite time, and think about it, is that by eliminating the right to submit all of this, the courts are also extending that by eliminating your right to bring in family history. My case didn't exist. I had a divorce. Everything was set. But the moment the papers were signed, I was back in court for no reasons. I was told specifically by Judge Cross that there would be no family history, there would be no official documents, school records, medical records. We started from zero. That's literally eliminating our family life in every aspect post-divorce. So I question the ability of the court to exercise judgment over post-divorce issues that are truly issues. In my case, ex partes were just filed randomly, even by the guardian ad litem. That is not his mandate. The ex partes were frivolous. There was no evidence for the ex partes, but yet they were granted. This extended our case out to where we are now, well over a decade. Guardian ad litem made a lot of money off of it. These ex partes, without evidence, did nothing but emulate imminent harm. And that is due to waiving of the rules of due process. Thank you.
Thank you very much. Any questions? Seeing none, thank you very much for your testimony. We'll call Alicia Brochu. Thank you.
Thank you. My name is Alicia Brochu. Once again, I am in support of this bill. The reason why I support this bill is very simple. Judges have and they do set aside the court rules. And when they do so, they're not looking out for the best interest of the children, because that is foremost what these family court judges are supposed to do, is look out for the best interest of these children when it comes to parenting cases. The rules themselves provide a framework for how these matters are pleaded and the procedures that are supposed to be adhered to. So when the judge sets aside the court rules, it sends a message that in the family court, forget what you think you know about law and the legal system. It is the Wild West of the court. When I was taking my legal classes, I had to take quite a few family law classes, and my family law professor actually sat there and told us, don't get into family law. Take it, because if you do, take everything you think you know and throw it out the window. When my husband's rights to 2 of his children were terminated and the lifelong contact order was placed that I referenced earlier, it wasn't because there was a finding of abuse, neglect, or abandonment. It was because he failed to appear at a hearing. The mother reopened the case, and she did not serve him, and there was no proof of service filed with the court. The judge decided to set aside the court rules regarding service and proof of service and strip the children of their loving father. And that isn't even the worst tragedy. The worst tragedy of that came less than a year later when the Exeter Police Department knocked on our door at 2 o'clock in the morning, asking if he could take physical possession of the children. The mother was found several blocks away from the home, high on drugs in a tree. The children were left home alone. They were 3 and 6 at the time. I will never forget the look of anguish on his face when he had to tell the officer that he could not help his children because there was a no contact order in place prohibiting him from doing so. All because the judge set aside court rules. And it's not just the judges that we hear in the news that do this. That order was signed by Judge Foley, who is retired now, and he's actually very highly regarded in the judicial system. In other cases of his, because my husband has multiple children, I've seen the judges set aside court rules regarding deadlines for answering pleadings. and the time that they have to actually issue orders, all to the detriment of the children. In the case where he now has primary residential responsibility for his daughters, the judge waited on average 10 days beyond the deadline for the respondent's attorney to file an answer to his motions for contempt for violation of the parenting plan. There were 23 of them filed by the time the case was settled. They never saw a hearing, and orders were never issued. The same case and a different judge, there was an ex parte motion that was filed by the mother, conveniently right before he was supposed to start his overnight, claiming that he kicked his 2-year-old across the room. The initial orders were granted, a hearing was set, they had the hearing, the judge waited 4 months to reverse the ex parte orders, saying that those allegations were unfounded. So his child lost 4 months of parental contact for nothing because the judge set aside court rules. So in the meantime, these children have to deal with the emotional distress of having their father ripped out of their life again and again, all because the judge used their discretion to set aside court rules. I'm sorry, but as the gentleman in the smashing tie stated earlier, it's for expediency. But these judges are not there to be expedient. They are there to protect children. They are there to issue orders in the best interest of children. And the way that it is now, they're putting their convenience and above what they're supposed to be doing, and that is looking out for the best interest of the children. Thank you.
Thank you. Do we have any questions? Thank you very much. Next, I'll call on Vivian Gerard. You've asked for 1 minute.
I don't even need that much. Madam Chairwoman and members of the committee, thank you again for having me up here. My name again is Vivian Gerard. And in my case, Julie and DeCasso constantly allowed my ex to file items so late that it was very biased against me, not allowing my lawyer enough time to prepare for hearings. My attorney said these multiple late filings have blindsided me. Judge Julie DeCasso also allowed my ex to submit evidence after the fact, but not me. Those were multiple serious violations of the family division rules that really hurt me in my case. And this book that I have here, I did not make everybody copies, but if you would like it, I can get it to you. But this is what happens when the judge has too much discretion. I had to go to the Supreme Court and fight just what's in here because of her discretions. And that's pretty much all I have, but I do have one comment to Richard Head. Obviously, there's problems with the rules. I don't understand how this is fair that I have to go through this for one hearing to have those rules fixed through the Supreme Court for one case. And she did not tell me why she did not follow the rule. But this is my last hearing to get those discretions fixed. So if you have any questions, I'll be happy to answer them.
Thank you. Any questions? Seeing none, thank you very much. Next, I'll call on Dan Albrecht. You've asked for 2 minutes.
Thank you, Madam Chairwoman, excuse me. Again, for the record, my name is Dana Albrecht. You've heard me testify previously. First, I'd just like to remark, if you've got a bill with great intent, but maybe there's some issues in the specific language proposed, let's address that with amendments. To that end, I actually just emailed the committee some proposed language changes to this bill that I think would address a lot of Mr. Head's concerns. Respectfully, I asked you look at that offline. back to what I had prepared. I just want to say if we had this law, perhaps as amended, that maybe I wouldn't have needed to go up to the New Hampshire Supreme Court on my last appeal at all and spend a year getting a vacate and remand, when instead the family division judge could have just followed the rules. Speaking to a specific rule, Family Division Rule 126E. It requires that motions that are not assented to will be held for 10 days from the filing date of the motion to allow other parties time to respond unless justice requires an earlier court ruling. So this is the opposite problem of Vivian. They're not giving me the time the rule allows, and they're giving the other party in her case far more time than the rule allows. And so I'd just like to echo what Alicia Brochu, forgive if I mispronounced that, said earlier, where you've got aggrieved parties that feel they have false accusations against them. That would be me. I've done nothing to deserve a domestic violence restraining order against me. I got one anyway. I appealed it to the New Hampshire Supreme Court. They gave me a vacate and remand. If you want any further details under the underlying circumstances, let's save it for questions, because we should focus on the bill we're discussing. Just suffice it to say I'm a peaceful person, never committed a violent act. Back to the rule. Unless there is an ex parte or emergency situation, the court is supposed to hear from both parties before it decides what to do about something. But in my DV case that the Supreme Court just remanded, the Judge Curran ruled ex parte on the other party's motion when there was no reason he couldn't waited 10 days to allow me to present my side of the story and file an objection. It wouldn't have been prejudicial in any way. We were just talking about changing something. You know, that's what he should have done, and then figured it out after hearing both sides of the story. And I think this is a widespread problem that goes across a lot of different underlying types of cases. You heard earlier from Laura Montgomery about getting Kathleen Sternenberg appointed by an ex parte email with only 27 minutes to object. What do you do? And her kid's taken away by that in an ex parte proceeding. And another one where kids were taken away in a 20-minute review hearing. So we're not following the rules that allow a party who's had serious accusations leveled against them to actually be able to respond to those and appropriately have at least an opportunity to rebut them, so the judge hears both sides and we can figure it out. And I consider that the real problem. What we're really looking for is just to get the right decisions out of court cases as much as we can. So I would just suggest that we adopt this, or maybe some amended version of this, or just do something so we can address this issue. Let's fix it, and I'll take any questions.
Thank you. Any questions? Representative Long.
Thank you, Madam Chair. Mr. Albright, were you represented by an attorney through all this?
I was previously represented by an attorney, but at some point you kind of run out of funds on that, so I'm presently pro se.
Okay, thank you.
Thank you. Any further questions? Seeing none, thank you very much. Considering that there's only
Thank you.
5 minutes left before 12:30, I'm going to ask the indulgence of those who are left to testify that we can recess this hearing until 1 o'clock. At that time, we will resume testimony. Is the committee okay with that? Okay, then we will recess this hearing at 12:25 and come back at 1 o'clock. Thank you.
apologize for asking that question. In other committees, obviously sponsors have to go and read the whole packet of resources before they sponsor the bills. I just wasn't aware of the rules. No, but I'm sorry about that.
Don't worry about it. I just wanted to.
Where do we go?
This morning, the reason why I was running late was because I was looking for the minority office. I was just like, where's the minority office?
The chairs actually.
Yeah, where are we now?
On the third floor, but it was
In the old place on the third floor? Where is it now?
not this year. Like right after the testified speakers finished.
So it's on the left in the back corner? In this corner?
Yeah.
Okay.
Yeah, you'll pass by. After main office is that office.
Me neither.
Not yet. In a little bit, we'll want to hear what you have to offer. So we're resuming 1265. It is now 1:08, and we'll call on Representative Dan Itza. You're up, kiddo. And you've asked for less than 5 minutes. Thank you.
Thank you, Madam Chair, members of the committee. I'm still Dan Itza. I still live in Manchester. The issue of waiving rules, one thing, sorry. Representative Long raised the idea that in session, or if you change House rules regularly. But I want you to imagine the equivalent of what happens to the litigants in family court. You go into session, and normally you have an order of precedence on the bills as to which motions supersede other motions. But what if on any particular bill, the speaker might change the order of precedence based upon whom the representative was making the motion and how much experience he thought they had? And that's the kind of situation you have in family court. I understand Mr. Head's concern and some of the concerns of the committee regarding unintended consequences. Number was over 200 family court rules, and this says that none of them can be waived. And there will be unintended consequences. I would suggest that if the committee was not inclined to adopt the proposal before them, that they might take a different measure, which is to require the judge, when he wants to waive a rule, to cite the rule that he's waiving, make the justification for it, which makes it actionable in further hearings. It can be objected to. It could then also be put into a court or into a database that would cite the judge, the case, the court rule, the justification, and which party in the case the rule was waived for. And that would give the judiciary and the legislature the power to see patterns. And if there is a pattern, are there one or two judges that are principally involved in waiving the rules? 3 or 4, a limited number. When a judge is predisposed to waive rules or disposed to waive rules, is it happening in favor of one party or the other? Those are very salient points as to know, and is there a particular rule that's getting consistently waived because it's not written well or it's a bad rule? Those are all parcels of information that need to be brought out. If there were a particular judge waiving rules consistently, then the legislature would be disposed to removing that judge by impeachment. But you can't know you can't act on what you don't know. I'd be happy to take any questions.
Thank you. Any questions? Seeing none, I appreciate your time. Next, I'll call on, is it Gail? Gail? Does she choose not to come up? While she's getting her things together, I just want to let you know that we have been receiving your emails. And I just want you to know that during these hearings, this is not the time for rebuttal. So your emails will be taken into consideration. They will not fall on closed eyes. but there will be no rebuttal process. Everybody's information is important to us, and we're the ones that get to ask the questions, not the general audience. So we appreciate your emails, but if you don't get a response quickly, that's why. Gail, you did not write in a time, so I'll give you 2 minutes.
Okay.
Okay? Thank you.
I'd like to give other background, but I'm going to submit it to you so that that's no big deal. But
Thank you.
I am in support of this bill. I think too many rules are being overlooked, such as opposing counsels are getting into private bank accounts without without even letting the other party know, and the judges are not doing anything about that. So I think that's a civil rights violation, and I really think the judge should have addressed that in the hearing and not let that go. So I think it's very important that rules should not be set aside for their peers. So, any questions?
Thank you. Any questions? Seeing none, thank you for your time. Next, we have Ms. Erin Jacina, and you've asked for 2 minutes. And the,
Yes, thank you,
the
Madam
floor
Chair.
is yours.
Good afternoon, Madam Chair and members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. I had not planned on testifying today. I did sign in opposed, but a quick review of the family court rules. I just wanted to point out a few things. That there are situations where it may be beneficial and even safer for litigants to have some discretion in waiving some of these court rules. And I'll just give you a few examples if that would be helpful.
Thank you.
Rule 1.25 addresses discovery deadlines. It allows for a response to interrogatories, and interrogatories are those questions that one side can ask to the other side. And there's a 30-day response deadline to those interrogatories. So if someone had access to information and it was beyond the 30 days, it may be helpful to the person's case to have that information submitted. And so it would be necessary, if that information wasn't available until after the 30 days, for a judge to say, all right, upon request, I've looked at that, and this is information that would be helpful in this case, so I'm going to extend that deadline. So that would be helpful in that situation for that rule to be waived. Another one is Rule 2.11, which deals with first appearance. For those of you who don't know, first appearance is required for all parties, either in a divorce or parenting case involving minor children. You have to attend first appearance. And it gives you really an idea of what the family court process will look like, and it's also the time when your first court hearing or mediation will be scheduled. That rule, 2.11b, requires attendance by both parents, and both parents are expected to attend the same first appearance. So if there's a domestic violence situation where it wouldn't be safe for the parties to attend first appearance together, you would want to waive that court rule, or you would want to make a request that that rule be waived. Rule 2.10 involves the Child Impact Seminar. That rule states that any action involving married or unmarried parents of minor children, the party shall attend the Child Impact Seminar. Somebody may make a request that this rule be waived. So, for example, if you didn't want to have to, let's say you attended a Child Impact Seminar 2 years ago, and now you're involved in a new family court case where it's required that you attend the Child Impact Seminar again. You wouldn't want to necessarily, since probably not a whole lot of new material in 1 or 2 years, you may not want to attend that Child Impact Seminar again. It's time away from work, time away from your kids, more money. That's a very lengthy seminar. I think it's 4 hours. So you might want the judge to waive that rule so you don't have to attend the Child Impact Seminar again, and you can just show your certificate. Rule 2.8 is in regards to children testifying,
And that rule states a child shall not be brought to court as a witness. And I will just point out that Representative Gay is a sponsor of a bill this afternoon, HB 1550, which seeks to waive that very rule. So I did just want to point that out, and I appreciate your time in allowing me to testify, and I'm happy to answer any questions.
Thank you for your time. Any questions? Seeing none, thank you. And the final person to testify would be Representative Cody Belanger. You've asked for 3 minutes.
Thank you, Madam Chair and fellow members of the committee. I wasn't going to testify today, but this bill is very important to me. I have testified before this committee and have spoken to many of you individually about my history with the family court. Most recently, Referee Foley from the Rochester District Court, Dover District Court, excuse me, told me in a court hearing that his court, his rules. He has an issue with pro se litigants. I am a pro se litigant because I understand the law. I may not have went to school for it, but it doesn't take a rocket scientist to figure it out. Interestingly enough, after that hearing, I'd Googled Referee Foley, and there is a Yelp review for the Rochester District Court. And it specifically names Referee Foley. We have an issue in our state, and I've been saying this for years prior to becoming a representative, and I'm saying it now, and I'll continue saying it until these issues are fixed. Judicial discretion is a problem within our family court system. It needs to end, and I support the bill as written, and I'd be happy to take any questions.
Any questions? Sure. Representative Long.
Thank you, Madam Chair. Now, the last speaker, did you hear her justification of waivers, and would you be opposed to those waivers also?
So thank you for the question. So I would be opposed to any waiver that allows for any form of judicial discretion, that allows for a judge to overrule any judicial discretion that he sees or she sees fit, because unfortunately we see a lot of the times, myself in the 2 hearings with the 2 different judges that I've had, in the other cases that I'm aware of families just in my district alone who are having these issues, that there are unintended biases towards families, and it's a problem.
Okay, thanks.
Thank you.
Thank you. Seeing no other questions and seeing no other pink cards, I will close the hearing on 1265. We're going to now reopen the hearing on House Bill 1142. I believe the prime sponsor would like to speak, and I'll need a pink card. Turn on your microphone, dear.
Thank you. Relative to the right to submit evidence and testimony in family court proceedings, as we have just been discussing, right now, some of the rules give tremendous discretion, and this rule is written in that on issue of testimony and evidence, you cannot present it in your case unless the judge gives you permission. So it's not a right. And then we learn that if you appeal your case, as currently you would appeal to the Supreme Court, you can't bring it up then. So that's why it's very simple. We just want to get rid of that rule and so that people have the right to present evidence and testimony. So if you have any questions.
Thank you. Any questions? Seeing none, I appreciate your time.
Thank you.
Next, I'd like to call Richard Head. You're asking for 5 minutes.
Probably won't need it.
Thank you kindly.
Thank you. Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. This bill would put give the capacity to any party to provide any testimony or any evidence whatsoever. So, for example, let's take this hearing that we're here for today. It's not that unlike a court proceeding. You have a lot of people, you have a lot of bills, you have a lot of people that want to come testify, and you have a limited amount of time. So you are limiting the amount of time that I have to speak, appropriately so, because everyone's testimony is important. All the issues are important. And what you're asking is that we come and present testimony that is relevant to the bill that's before you. And we've heard that today, too. And that's what a judge is doing when they're in a proceeding and they're asking for the parties to present evidence that is relevant to the case. The way this bill reads is the parties in any proceeding have the right to present evidence and testimony. As written, it is unlimited. They can come and provide testimony on anything. They can come and provide evidence on anything, and it's unlimited in terms of time and scope. So what the significant concern about this bill, at least as written, is that every case can get out of hand almost immediately. You have a judge who has a number of cases that have to be heard that day. All of them are incredibly important. All of the information is important, and what the judges need is testimony that relates to the issue that is before the judge and evidence that is related to that issue. And once you start going outside of that, you start to lose the ability to hear all of the cases that day, to have all of the parties present information and testimony. And as written, this would essentially provide unfettered discretion on the parties as to what they present, how long they're presenting, and the nature of that information and evidence. And quickly, all hearings will get out of control. And that's the reason why the judge needs to be able to control what is the evidence and what is the testimony. If the intent of this bill is to say every case you're entitled to have evidence and testimony, okay, again, these are family court proceedings, which again, we don't have family court, we have family division. These are not all marital cases. Every party does have a right to an evidentiary hearing in a marital case, unless waived. That said, not every issue is entitled to a trial. You get ultimately on the case itself an evidentiary hearing unless it is waived. But what is really very unclear about this bill is what types of cases, what types of cases are we talking about? Because not every case needs to have a hearing. So there are a large number of probate cases that get resolved without a hearing. It just happens. But that is, and so in family division, there are also other types of cases that do not need a hearing to be resolved. This bill, just as written, is so broad that it will prevent the courts from doing anything and being able to do their jobs and being able to get to the issues and to be able to resolve those issues, unless you want to add a significantly larger court system. And I don't think that's ultimately your goal. It just is not manageable as written. So we would oppose this bill as written. Thank you. I'd be happy to take any questions.
Thank you. Do I see any questions? Representative Long.
Thank you, Madam Chair. So, in your opinion, the parties shall have the right to present evidence and testimony. Is that just the parties presenting evidence and testimony, or do you read this as the testimony can be from anybody?
The bill's written talks about the parties.
Okay, so
but it doesn't say at what stage. So
right, so-
is it the initial conference
Yep.
To the final trial? But at least as written, it's the parties.
Okay, thank you.
Thank you. Any further questions? Seeing none, thank you very much.
Thank you.
Next, I'll call on Katrina Heinrich. You've asked for 3 minutes. And again, I'll remind you that if you have written testimony, please submit it for the record.
Again, I'm Katrina Heinrich. I am here for this bill because I do believe it is an important bill. Any party should have the right to evidence. In my case, the court denied my right to due process as guaranteed by the 5th and 14th Amendments of the Bill of Rights. The excuse I understand is Rule 1.2 and 2.2. But there's no explanation as to why that is. The family division is a piece of our court system that should afford litigants to have the right to evidence and testimony, just like a civil and criminal case. I understand that we want to make it family friendly, but that's not what is occurring in 20% of these cases, if not a larger number. In my case, orders are then written without due process, but carry the burden of legally binding decisions with consequences and no options for recourse. And we've already heard testimony about how recourse is very unapproachable. As previously testified, and I do hate to repeat this, but it is about this bill, no evidence or witness testimony was permitted in post-divorce proceedings. Again, this is a post-divorce proceeding that should have never happened. All life history was eliminated. You can't bring in any facts. You get nothing. You get zero. Without the ability to submit evidence or history and orders, victims to be legally bound to their abusers without due process. And in my case, there was abuse. It is well documented. There is criminal records. Furthermore, this failure of due process opens the door for coercion, slander, allegations, gaslighting, corruption. Moreover, and more, I feel like you could almost call it court-facilitated abuse. But the question is why? Why is that allowed? That's why we're here today, is to look at the laws, look at the facts, look at what is not as working. There is a pattern. It is not just in the state of New Hampshire. This is across the United States of America. There is about 3 states that do not have this problem. All other states do. Henceforth, I have already commended the governor for signing the proclamation for the Family Court Awareness Month, which again has embedded in it supporting facts and evidence that this is real. I think I'll end on that because I know that there's other testimony.
Thank you very much. Any questions? Seeing none, thank you. Next, I'll call on Alicia Brochu. You've asked for 3 minutes?
That's correct, yes.
I'm sorry, what?
Said that's correct, yes. And thank you for hearing me again. I am testifying in support of this bill. The purpose of the judiciary is to look at the facts and apply those facts to the law, then issue orders in concurrence with the law. How is the judiciary supposed to ethically do so if the parties do not have the right to submit evidence to support their claims? If a judge is permitted to look at one of the parties and say, "No, I'm not accepting your evidence," it creates a bias to the entire proceedings. I've witnessed a judicial referee tell my husband that she would not accept evidence that he had that his oldest child graduated high school. That evidence was public when they post the graduates in the newspaper. Instead, she took the mother's word that even though he was almost 19, he was still enrolled. This led to my husband paid child support for a year longer than the statutory requirements, because I think it was like a month into the hearings when he first filed that the child actually turned 19. I've witnessed the judge refuse my husband evidence that the mother forged a paternity test to make it look like he was not the father of his youngest he has with her. That evidence was in the form of a police report where she confessed to the officer that she forged the test to alienate him from his daughter. I've witnessed the judge refuse my husband's evidence that the mother of his daughters lied to a mental health provider by claiming that there was a restraining order in place for the purpose of preventing him from taking part in the children's therapy. That evidence was in the form of the children's mental health records. I've witnessed the judge refuse my husband evidence that she lied to the court, the mother, in a financial affidavit and did not disclose that she was receiving TANF benefits for the children. That evidence was in the form of a letter directly from the Department of Health and Human Services that confirmed that the children were receiving the benefit, and as well as the date that they started receiving the benefit. I've witnessed the judge refuse my husband's evidence that the children's maternal grandfather threatened to pack up his daughter and her children and leave the state so he would never see them again, and there would be nothing he could do about it. That evidence was in the form of a recording of the voicemail he left a threat on. My husband was trying to obtain an ex parte order to prevent the threatened kidnapping. In one of my husband's older case files where the judge refused his evidence, that the DCYF caseworker, never attempted to contact him before she initiated court proceedings. She testified that she tried to contact him by phone. His evidence was his certified phone records, proving that she lied. He said I wasn't going to take it, and he had to deal with over a year of jumping through DCYF hoops to get access to his children back. When a judge refuses to accept evidence, then on the record, all they have to base a decision on is one party's word against the other. That allows them to claim that one party was more credible than the other and pick and choose how they will issue orders based on their own personal biases. Because according to, and the family courts don't have evidentiary rules, but the Superior Court does, and in Superior Court evidentiary rules, physical evidence has a higher weight that they have to look at than just testimony. So when you eliminate physical evidence, now you just have the testimony. And they can say, well, you know, I kind of like the way that that person looks better. I think that they look like they wouldn't lie to me. So it enforces their personal biases, and it oftentimes leads to orders that are not in the best interest of the children. Thank you.
Thank you. Any questions? Representative Altola?
Thank you, Madam Chair. Is this working?
Yes.
Yeah, okay, thank you. Thank you so much for your testimony today and all of the testimony you've presented throughout the day. Just so I can wrap my head around the mechanics of how this is playing out, it sounds like I'll ask just about your case specifically, or the ones that you have firsthand knowledge of. What does it look like, and what is the occasion that a judge, that there's evidence to be presented and the judge refuses? Is it during the course of a case review, or
it's during the
can you
course
just walk
of
me through that?
So basically what happens is you will file a motion.
Mhm.
You don't file exhibits with the motion.
Mhm.
You submit exhibits when you go into hearing. So when you go into hearing, professional courtesy, you give the other party, your evidence beforehand, but you don't have to do that with family court. You could just show up with whatever. So what it looks like is you go, my claims are supported in paragraph 1, 2, and 3 of my motion. by these exhibits. And the judge looks at the bailiff and he says, "Bailiff, can you take those?" And he does one of these. That's exactly what it looks like. And then there's no reference to them in any orders. And they are not even in the case file when you go to take the case file.
Right, thank you for demonstrating what that experience is like. And
Yeah,
thank you.
it's very disheartening, especially when you're submitting evidence that, like I said, family courts don't have rule of evidence, but the Superior Court does. In my husband's cases, he made sure that everything would at least be submittable because you have to make sure you're submitting credible evidence. So when a judge is looking at a police report proving that the mother is actively alienating the child to the point where she forged a medical document and she admitted that to police, and the judge doesn't even want to hear it, when the action in front of the judge is to restrict her decision making because she's not able to make good decisions for the children. It's very, very disheartening.
Thank you.
Thank you. Any further questions? Representative Belanger.
Thank you, Madam Chair. Thank you, ma'am, for being here today with your testimony, and I appreciate it. And I'm sorry you've had to go through this. So, again, I'm going to preface, and I'll get to my point. So, in my hearings, I present, if I haven't provided the evidence beforehand, I ask the judge if he will accept it.
Mm-hmm.
And he or she, technically, but in my case, I've had both male judges, he will say it is up to the other party if they will accept it or not. They have to review it and then go through it, and then I can give it to the bailiff, who will then give it to the judge. Is that not happening?
The hearing, the child support hearing, that was in front of referee Colligan, and was issued by Judge Foley, that did not happen. She just absolutely refused it. The other cases was Judge Burns and Judge Polly Hall. Judge Burns was better about it. He did give the other party, the ability to say, here, did you look at it? Is that okay with, do you accept it? Or did you want to rebut it? But Polly Hall was the one that liked to just take things and just kind of throw them in the trash. So it really depends on the judge.
Follow-up?
And by Polly Hall, you mean, thank you, Madam Chair, and thank you for answering my question. By Polly Hall, you're referring to Judge Hall, correct?
Yes, I'm sorry, Judge Polly Hall.
Thank you.
Yeah, the one that recently made the papers.
Thank you. No further question, then.
Questions from anyone else? Thank you very much. Thank you. Next, we'll call on the former Representative Dan Itza. You've asked for 5 minutes. Can we? Thank you.
Not a problem. Thank you, Madam Chair, members of the committee. I am still Dan Itza, and I still reside in Manchester. Making sure that both parties have equal opportunity to present evidence to the court in these decisions is critical to the parties receiving justice. In past years, I have submitted legislation that would require that the evidence be submitted 5 days before the hearing, so that each party has the opportunity for discovery and the capacity to rebut evidence that's spurious or false. I don't know that this is the best presentation, but the issue is clear and present. You have to make sure that the parties have the opportunity to present relevant evidence to the court, and that both parties have the opportunity to examine that evidence before they get in the courtroom. I'd be happy to take any questions.
Thank you. Any questions? Seeing none, thank you very much. Next, we have Angela Loja. You've asked for 5 minutes. Can we?
committee. Again, my name's Angela Lozier for the record, resident here of Concord, New Hampshire. I'm just going to kind of give some examples because, again, like you guys have heard, I'm fresh out of court, so I'm going to give more examples more than kind of other things. So in my case, there was a reference of collateral resources that the GAL, Catherine Schernenberg, and opposing counsel mentioned. One is my daughter's school teacher, and the other is my daughter's therapist. At parent-teacher night, the 5th grade teacher spoke to my ex, and I followed up with an email to the teacher. Then the 5th grade teacher changed his story. What happened in my case is everyone involved had a different story about the 5th grade teacher. Kathleen Sternenberg wrote one thing in her Cal report. I got a different story, and my ex said another thing. So nobody agreed with what the 5th grade teacher was saying. He didn't come to court to testify. That would have been nice. Excuse me. Regarding my daughter's therapist, Kim Thurlow, there is no email communication that I could find in Kim Thurlow's record stated anything regarding my parenting or her concerns or her recommendation. On that bill summary, it reflected phone calls primarily. This is conflicting hearsay evidence, and I'm just hoping that we can fix that with this bill. Any collateral resources that are referenced in a GAL recommendation weren't subpoenaed for the final hearing, nor was I given a fair opportunity to rebuke some of those concerning allegations to support the GAL's recommendation. On November 30th, 2020, there was a status hearing to review Kathleen's report. Kathleen recommended that my daughter go live with her father. Kathleen stated in court that my daughter would be harmed if the current parenting plan was not changed, which is an exhibit in support of HB 1346 in establishing a commission to study New Hampshire family court systems early today that I testified at. Kathleen had not completed her investigation. She had not finished speaking with parties on my end before filing her report with the court. A premature recommendation without completing her investigation. Another collateral resource that Kathleen failed to reach out to was my therapist of many years that I signed a release for Catherine and for my therapist. Speaking with my therapist would have been beneficial when making assumptions, as Kathleen had about me. Kathleen Sternenberg only reached out to my therapist after the status hearing in her recommendation to remove my child. There were allegations made to DCYF in March of 2020 that were unfounded. Kathleen Sternenberg never pulled the final report from DCYF to review. It was alleged I was doing drugs in her report. I voluntarily took a hair follicles test, which was negative, to refute the allegations of drug use in Kathleen's report. There was no evidence submitted in the form of police reports or other information in support of any danger to my daughter that would justify Kathleen Sternenberg's recommendation. In all my years, I have never been convicted of any crime or had any calls made on me to DCYF. Meanwhile, my ex had 3 DUIs. That wasn't a concern to her. The court took Kathleen's recommendation on a 20-minute status hearing through WebEx prior to our final hearing, which was scheduled for January 28, 2021. So they completely ignored the evidence I submitted to rebut false allegations of drug use, but took Kathleen Sternenberg's made-up claims instead. After the temporary hearing was granted from the status hearing in November 2020, I submitted a couple videos to Kathleen that my daughter sent me dated. One was 6/1/2009 stating, "Help me." This was 4 months prior to my ex motioning the court for custody. This video is alarming, along with other recordings of my daughter talking about her stepmother hitting her and other alarming information that would hopefully make Kathleen look at things a little bit closer. This didn't change her recommendation at the final hearing. It was discredited, and never did she ever mention it in her final report, even though I addressed these concerns on my first interview and in my questionnaire. And I didn't think I would have to send the videos. However, she did bill for the time to review them. Again, more evidence that was simply disregarded.
I also provided multiple text messages between my daughter and myself prior to court to demonstrate the relationship we had. Texts between my daughter's therapist and myself about the video helped me. Mentioned above, text message documenting my daughter was not happy with her father and stepmom and clearly wasn't mature to have a say in this final decision. But all that was just ignored. So I support Bill HB 1142 because the court didn't look at the evidence I gave them and just took Kathleen Sternberg's word on everything.
Thank you. Any questions? Seeing none, thank you, ma'am.
Thank you.
Oh, I'm sorry, Representative Belanger.
Thank you, Mr. Chairman, and thank you for being here today and providing another heartbreaking testimony.
Thanks.
In relevance to this and your guardian ad litem, do you have the same judge that had a conflict of interest?
No, I what I have heard today is the last marital master, Thomas Cooper.
Thank you.
Thank you.
Thank you. I'll call Eric Brand.
Thank you, Mr. Chair, committee members. For the record, Eric Brand from Nashua. I am here in support of HB 1142. This is a perfect example of why previous bill number 1265 is so important, because these judges tend to take and make their own rules. So this is just another great example of this. I'm going to give you a story which I haven't been able to share yet with this committee and other testimonies. 5 minutes prior to my temporary hearing, the opposing attorney brought in a motion to the judge asking that I basically wipe out my entire life savings from my deferred tax account and pay it to the other opposing party. There was no hearing, no evidence provided at that particular time. There was an order that was given with the rest of the temporary orders to pay the opposing party the balance of the tax deferred account, all penalties and tax liabilities within 5 days. Meanwhile, we never had a chance to provide evidence or to show anything during that temporary hearing, let alone having that motion given to us prior to the hearing with enough time to prepare for it. So once we received the order, we'd filed a motion to reconsider. My attorney used many laws that were backing up our claim. That motion to reconsider was denied, and there was threat of incarceration to myself. We then filed a motion to stay on the payment, requested a hearing. Eventually, 5 months later, we had this hearing. We provided evidence in over 500 checks and account statements to show where prior funds had been used. The evidence that we provided was uncontested at the time by the opposing party or the judge. And that was all based on money that was spent before the actual divorce proceeding started and prior to the anti-hypothecation order was even issued. After the hearing, we finally received the orders. The orders continued to say, pay the balance of the funds, the fines, the taxes, and now attorney fees and additional fines. And then there was continued threat of incarceration if we didn't pay it. The judge's answer, this was former Judge Introcaso, as to why I had to pay it, had nothing to do with the evidence that was provided. She said, you're paying it because I ordered you to. This bill demands the court to listen to both parties and make rulings that are affecting their lives. Without this bill and HB 1265, we're leaving all of this discretion up to the judges that could have a biased opinion against somebody, and it is just leaving way too much in the hands of somebody else to make decisions and taking away from our civil rights. We heard earlier today, and I'll quote, that judges rely on evidence provided.
I wasn't allowed evidence to be provided and ruled upon within my case. It was completely ignored. Both Bill 1265 and 1142 are being proposed to stop this biased judgment, ensure all parties are getting a fair hearing, and to ensure their civil rights are left intact. We're talking about people's lives here and the lives of their children and how they're being affected. Thank you.
Thank you. Any questions? Seeing none, thank you.
Thank you.
Next, I'd like to call Dana Albrecht. I got your name right this time.
Thank you. I just want to say I support the intent of this bill, but I fully respect Mr. Head's concerns. Just want to say that almost all police reports entered into evidence in my case were completely ignored, insofar as substantial testimony about them was never mentioned in any narrative order. So I just ask how we can maybe craft something via amendment that addresses both the concerns of all of the aggrieved parties here in family court, as well as the concerns of the judicial branch. I mean, I don't think we want to get rid of like legitimate motions in limine or something like that. So I'd really like to see something that addresses the issue, and maybe we just fix the language. Thank you.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Next, we have Vivian Gerard. You've asked for 1 minute.
I might actually only need like 30 seconds. Madam Chairwoman and members of the Children and Family Law Committee, in my case, Judge Inticaso refused to allow me to submit evidence in the hearing and didn't admit it on record at all. I want to be clear that she did not even tell me why. It's not like my ex's attorney even asked Judge Inticaso to exclude it by filing a motion. My entire divorce would have ended up completely different if the judge just took in my evidence. Thank you. Any questions?
Thank you. Any questions? Representative Altshuler?
Thank you, Madam Chair. Thank you very much for taking my question. At the time, I'm going to ask you a question that I asked a previous witness. What did that look like at the time? You showed up in the room, you had paper. How did you, like, how did it play out? That's what I want to,
Yep.
I want to see it, if you don't mind.
Yep.
Thank you.
So at the time that I was in court, my ex's attorney gave in their package and they started going through my employment. And she asked if I had seeked any employment. And my attorney turned around and said, I don't have it in my hand, but I can get it to you. She says, nope. And not only did she not look at that, that actually was the whole reason why she took child support away from me. I had a work log. I also own a bed and breakfast. She told me that my hobby needed to be shut down within 6 months and said, I'm glad you're trying to live the all-American dream, but go out and get a real job. But what she also didn't look at, which I tried to submit, was the fact that my income dropped more than half because my ex at the time took my Facebook, my Instagram, my booking engine, my website, shut everything down because he was the one that started to get it going. He was the technical guru. He set up the websites and all these accounts. He had all the passwords. He had tucked his email behind. So when I tried to go in and rechange a password, it went back to him as a, hey, your password was changed. I didn't know anything about the technical parts of this because that was his specialty. I had an email from one of the accounts that I was trying to get reestablished, and they acknowledged that it was shut down by Mr. Silva, and that alone would it show the judge that my income was affected, which made it look like a hobby because he tampered with my accounts. And till this day, if you look at how much money I make, it's probably triple of what it was back at the very beginning of the divorce. So as soon as I reestablished those accounts, but it took me a year, I had to have court documents to say that I was awarded the business. I had to show all my my passports. I had to show my operating plan. I had to prove to them that this business was only established by me. We bought the property together, but the business was 100% mine. He had no involvement whatsoever. So by not proving to the court these things that has happened affected my child support tremendously. And as I said, I've been doing this for 7 years, and he shouldn't have been tampering with those documents. Is that enough? Okay. Any other questions?
Any further questions? Thank you very much. And we have one more person to testify, and that's Gail. I'm sorry, I can't. Drobet. You did not specify how much time you need, so I'll give you 2 minutes.
It'll just be very, very brief. Thank you again for allowing me to testify before you. My name is Gail Drobet for the record, and I am in support of House Bill 1142. I feel it's imperative that all litigants be allowed to submit evidence, as this is not happening. The judges are picking and choosing who submits evidence, what can be submitted. To the extent when a litigant files a motion to add evidence, it's denied, and then opposing counsel will submit evidence second day of trial.
Can you speak into the microphone, please? Thank you.
Do you need me to start over? No. The judges, opposing counsel submits evidence that is not assented to second day of a final trial and leaves out a portion of the exhibit. The attorney makes material misrepresentations to the court, interfering with the judicial process for the judge to make a non-biased decision on her material misrepresentations. Again, the judges are defying their judicial canons by not treating each litigant with respect when not being represented by a member of the New Hampshire Bar. Thank you.
Thank you. Any questions? Seeing none, thank you very much. And with that, I will close the hearing on House Bill 1142. I'll now open the hearing on House Bill 1551. Representative Gay.
Thank you, Madam Chair. I did pass out earlier, well, I hope I did, a pink sheet. Did everybody get that? That's testimony from the person whose parents' entire contents of their house were being delivered to her house today at 11 or all days. She points out the whole point of my bill, which is to give justice to people who are not rich. It's extremely expensive to have transcripts made. The recordings of hearings are $25 to $35, so that's doable. But if you get a transcript, which is what you need to pursue a case, it's $1,500 is a drop in the bucket. She says in her testimony that she has spent $25,000 just on transcripts. And I'm sorry I'm not focusing because I'm thinking of so many issues that affect every single one of the bills. One is that these court proceedings go on and on and on, and it's part of harassment because if you have enough money and you're mad, you can just keep going back to court, and it causes the person that you're filing against to have to spend money and take time away from work and answer you. So it gets extremely expensive. It is a method of torture. So this bill simply says that the written transcripts, each party under the jurisdiction of this chapter shall have the right to create their own written transcripts of the court proceedings. And we can certainly, some of the other bills that we will be talking about submitting them in appeals, you know, we can put controls in so that they have to designate what time a certain thing, whatever's important, they have to say at what time in the minutes. What is the right word to say? The chronological order of your transcript has to match the official tape, or in the case of some other bills, the tape that the recording you made to be compared to the official when they're different. So it's just a matter of money because it excludes the rules that they are, that you must buy the transcripts from this one company in Arizona, which I understand is considered modest by New Hampshire standards. You still have no other option, and if you can't come up with a transcript, your appeal, I've seen it denied. And the weird thing is, if you're a criminal and you don't have money, you are given not prosecutor, you're given an attorney. But Lord help you if you're just a poor person who's been hounded in family court. So, thank you.
Any questions for Representative Gay? Representative Belanger.
Thank you, Madam Chair, and thank you, Representative Gay, for bringing this forward. I guess my take is, while I understand that the cost is high, perhaps maybe looking at it and figuring out a way to make it more affordable. But do you not see this as an issue that anybody can transcribe an interpretation of the recording? Do you need me to clarify?
Well, I would think that the opposing person, whoever's on the other side of this hearing, would be very happy to listen to the recording and to point out any discrepancies. So I really think that you're always going to have somebody checking on your work. And now that we have software that converts spoken word to written word, it's be a lot more, you'd have to, once you had that, you'd go back and edit it to make sure you had paragraphs and everything. But I would think that the opposing party would be happy to say, you didn't do this right. Here's my transcript.
Follow up?
So then it becomes, thank you, Madam Chair, and thank you for answering the question. So then, again, to further that issue, then it becomes a he said, she said situation, and then it just kind of bounces up. I think there's I guess, do you not see that as a problem? Because I would rather see something along the lines of finding it more affordable to get transcripts.
Are you proposing an amendment, Representative?
No, I'm trying to ask her if she would, if she doesn't see that as a problem, and maybe she could come back with an amendment.
Thank you.
That's where I'm going with that.
Well, you're welcome to write an amendment too. I certainly appreciate help. One of the real serious issues is that multiple people have told me that when they get recordings, the recordings aren't even right. So we're talking about, because they were edited as they were made, that we talked about this last week, so I'm sorry that I'm revisiting it, but the three issues are tied together. Making a recording, making a transcription, submitting it. I have three separate bills so they can be all argued on their own behalf. if you're, what currently you are stuck with the recording, and it can be edited, and we have many people who can testify that the recording omits some really questionable things that the judge or court personnel said. So if you get the recording, and yours is different, we're not proposing that anybody file an appeal and just use their own. They would have to submit the official recording and the official transcript. But then here's my recording and here's my transcript. It's one of those real serious things that we have no proof of right now until you can submit your own and make your own. And it's so important that I think if we do it, finally, people who are misbehaving, that's the nicest word I can think of, will know they're going to get caught. And there ought to be teeth in it too. You know, you're going to be reviewed if you do things like this and you get caught. So no, I didn't think it was simple. I don't think it's easy, but I think it's real important to address that problem.
Thank you. Any further questions? Seeing none, thank you very much. Next, I'll call on Richard Head. You've asked for 5 minutes, and we'll try to squeeze it down a little bit, please.
I will. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We're obviously very sensitive to the issue of cost. It does cost money. Litigation costs money. Transcripts are expensive, and I don't disagree with that. I've certainly represented enough clients who raise concerns about the price of transcripts on appeal. The transcripts, sorry. The transcripts are a necessary element of the appeal, and the court relies upon it, and not just those parts that are identified in briefs, but the whole record as it's been submitted to the court. This bill as written has no, and actually, I'm sorry, I did take a look at the cost of transcripts in the other New England states, and the cost of transcripts that New Hampshire charges is in almost all cases lower than our other New England states or the same. So we're not charging sort of an outrageous amount as compared to the other states, but it does cost money, and I'm sensitive to that. The issue, though, is really the reliability of that transcript, because that transcript does become the record, and it does become what the judges at the Supreme Court are ultimately looking at and ruling upon. And the current requirement does have a certified transcriber, or a certified record from a transcriber that is filed with the court. That is sort of an incredibly important part of ensuring that the Supreme Court record is accurate. That said, mistakes do happen, and if those are raised with the court, they can be addressed at some level. But as written, this has no standards for what that transcript would look like. It could, for example, as written, this bill would allow for a handwritten transcript of somebody who is taking notes in the back of the room. I'm not saying that's the intent of the sponsor. What I'm saying, though, is as written, this bill has absolutely no criteria or standards for what it is that would be submitted as a transcript. So we have significant concerns about the bill as written. I'd be happy to answer any questions, however.
Thank you. Any questions?
I should also point out there is a provision in the Supreme Court rules that allows for the parties, if they can agree, understanding these are highly contentious cases, if they can agree and file a stipulation of the facts, you don't need to submit a transcript, you don't need to submit those records, and essentially that's a no-cost alternative. I recognize the limitations of that, but just wanted to point it out.
Thank you. Representative Belanger.
Thank you, Madam Chair. Thank you, Mr. Head, for your question, for answering this question. I did think of one actually before you take off. Do you know what the cost is for a transcript?
So it depends. Part of my answer, it depends on the turnaround time. So a 45-day turnaround, it's $2.75 a page in New Hampshire. Massachusetts, it's $3. Connecticut, $3. And Rhode Island, it's $3 to $5. But New Hampshire is $2.75 a page for a 45-day turnaround.
Thank you. Any further questions? Thank you again.
Thank you.
Next, I'll call on Representative Kurt Welper. Representative, you've asked for 1 minute.
Thank you, Madam Chair. Yes, for the record, my name is Representative Kurt Welper. I represent Stratford District 3. And I just wanted to clarify something that I heard Representative Gay say, and maybe just give you just a tiny bit of why she's got a bill in Judiciary as well that deals with this type of thing. I'm supportive of this bill because it allows the individuals to make their own transcripts, for which they have to have their own recordings. And part of the problem with what goes on in family court is that the judge controls the recording. So if the judge doesn't want to have some stuff recorded, the judge just presses a button and recording stops. If the participants were able to make their own recordings and make their own transcripts from their recordings, then there would be a fuller record than what is often contained in the official transcript. So I think this is a needed check at this time. The testimony we heard was that, well, if you wanted to put a court stenographer in the family court, that would solve that problem, and it likely would, but it would also cost a bundle. So this is a way of handling the situation to provide full evidence for the participants and for the courts in later hearings. And with that, I'm done.
Thank you. Any questions? Seeing none, thank you very much. Next, I'll call Katrina Heinrich. And you've asked for 3 minutes, and hopefully we can squish that down.
Do my best, I promise. Okay, so I do have just an example, a visual example. This is actually a CD recording of the last hearing that I had. This was unobtainable for me to get written. It was going to cost me $1,000 for a one-day trial. There's no way. While getting this, it still needs to be translated in some form of print in order to be accepted for any court proceedings. This is important to me because on this day, the guardian ad litem specifically talked about how he was going to pass this envelope that I had no right to the contents to, and that he was a GAL that represented more men than women. Not children. He represented over 50% men, but he called it about equal. That's critical evidence. With that said, this was a significant issue in my case. There's inherent denial of access due to the extremism of the cost burden to the access of written or audio content of record of the court proceedings. Transcription fees are technologically unnecessary with modern technology and software. To that point, the current way the court uses the technology to record hearings sows mistrust, as evidenced by discrepancies in family court records. The importance of transcripts is critical, specifically when there is conflicting data. A case I intended for another family court litigant specifically has missing testimony that I witnessed by Judge Foley, who also was stopping and starting with clicks and feet devices. He was in full view. This happened to be a time in the case where he berated one of the litigants. It brings into question how the court software is controlled, reviewed, and if it's true to what actually occurred in the courtroom. So a solution to me because we do have technology, we do have software, is something as simple as a travel drive is very inexpensive. Each litigant can have it. The court has a copy of its own records. There has got to be a workable solution for this. Access to records needs to be obtainable to all parties so that personal transcribing software, even manual, could work. But I would disagree with that and go more with a travel drive. That is verbally what occurred in the courtroom. Discrepancy is more than just a financial issue for someone like me that's trying to obtain the actual records that occurred. But it's also an issue of discrepancy of what actually occurred in the courtroom, which more often than not has showed missing data on transcripts we've obtained. I think this could be at least the start, if there is possibly an amendment to solutions that could start restoring the integrity of the family court with a new form of checks and balances. And on this topic, I thank you.
Thank you. Any questions? Representative Long.
I'm not sure if you will know this or not, but could you just transcribe the portion that you wanted? Or do you have to transcribe the whole day, the whole hearing?
In that particular case, on this one that I spoke of, we were not sure what time of day it occurred, so we had to have the entire day.
Okay.
We had no time stamp to know otherwise.
Okay, thank you.
Mm-hmm.
Thank you. And our final person is Dana Albrecht. You've asked for 30 seconds.
Based on prior testimony, we might want to bump that up to 1 minute, but I'll still keep it short. Again, still Dana Albrecht. Just like to say, in my recent Supreme Court appeal, the official transcript from e-scribers left out key portions of the audio, causing the New Hampshire Supreme Court to order an amended transcript. The stuff they left out was key to the court's order to vacate and remand. So I believe that's one problem that a lot of people here are trying to fix, and I certainly support fixing that. I think another problem people here are trying to fix is cost, and I'd point out that a company like SpeechPad, widely used in the entertainment industry, is much cheaper than a company like eScribers, widely used in the judicial system. I don't want to take that too far, but I'd just like to echo Mr. Head's point that if the parties in a case can reach some sort of stipulation that a transcript of far lesser cost that perhaps they prepared themselves from their own recording is sufficient to decide the record on appeal, and they agree to that, I don't see why the court shouldn't take that just as a starting point to address some of these issues. Thank you. Happy to take questions.
Thank you. Any questions? Seeing none, thank you very much for your time.
Thank you, Madam Chair.
And with that, we will close House Bill 1551. We will now open House Bill 1550. And did you,
Amendment, and it takes words out, so it doesn't make it longer.
Representative Gay, did you pass in a pink card?
No, I'm sorry, it's sitting.
Thank you.
Thank you, Madam Chair. This is very, very simple. We just took out a couple of words twice. Right now, children do not have a right, no matter how old they are, they do not have a right to testify. And some children are not, it's not appropriate for them to testify. But I've certainly met teenagers who are frustrated out of their mind that they cannot speak on their, all these decisions that weigh heavily on them. So that's why this one, well, I'm so sorry that I'm such a poor speaker, so thank you for being patient. House Bill 1550 says the court shall permit a child 12 years of age or older to testify orally at any proceeding determining parental rights and responsibilities, and the court may permit a child under 12 years at the discretion of the judge. And how we changed this is it used to say the child could testify orally or, and the official terminology for a signed statement that's witnessed, I can't remember the adjective, but it means it's officially legal, somebody's observed it. It's not just a child writes something and hands it in. But after discussing this with several people, court experienced people said, we'd never accept a child's submission of something written as testimony because you can't cross-examine them. And we don't define how the judge would take the testimony because we figure that's the discretion of the judge, how to do it. So that's the entire point of this. And there is I hope I passed out a pink sheet on this. If I'm not, I've got to go find them. But it's testimony from the mother who's can't show up today because of all days. But her children were desperate to be heard, and they would write letters to the judges. But of course, the letters didn't go anywhere. So I'm thinking of all the kids who really, really want to be heard, to give them that opportunity if they're 12 or older, and then if they're under 12 for the judge to decide whether that's appropriate.
Thank you. Any questions? Yes.
Thank you, Chairwoman, and thank you for taking my question. How was the age of 12 determined?
Out of thin air.
Okay.
In the past, I've heard, in the past, kids could and have input, and that may have been 12, that may have been 14. So I just took the younger of the two.
Thank you.
Thank you.
Any further questions? Thank you, Representative. Next, I'll call Richard Head.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do have significant concerns about this bill as written. The risk of manipulation of a 12-year-old is immense, and the requirement without any discretion on the part of the court to allow a 12-year-old or older to testify creates significant risk to that minor in terms of manipulation by a parent, threats to that child if you don't testify a certain way. The consequences will be X. To pit a 12-year-old against two parents, to have a 12-year-old cross-examined on the stand. It's hard enough for an adult, but to have 12, 13, 14, 15-year-olds required without any discretion of the court would be potentially significantly detrimental. Be happy to answer any questions, but as written, we would oppose it.
Thank you. Any questions? Representative Long.
Thank you, Madam Chair. Does the judge have the discretion now to speak to the child in his
What typically
office?
happens is it would be a motion by a party to allow that, and then the judge would talk to the child in chambers.
So it would be a motion,
Follow-up?
if I may, thank you. So it would be, one of the parties would be requesting it?
Correct.
Okay, thank you.
Any further questions? Thank you very much.
Thank you.
Next, I'll call upon Aaron Jacina.
Thank you, Madam Chair and members of the committee. I did send written testimony last evening by email. I have extra copies if anyone needs it. Again, my name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. New Hampshire Legal Assistance is in opposition of House Bill 15FN. NHLA is a statewide nonprofit law firm. Our attorneys and paralegals represent low-income and aging clients in civil cases involving urgent, basic needs, including safety from domestic violence and stalking. NHLA's Domestic Violence Advocacy Project provides free legal advice and representation to low-income victims and survivors of domestic violence, sexual assault, and stalking in high lethality protective order cases and divorce and parenting cases. And when I say high lethality cases, I'm referring to cases where there is a significant risk that the victim will be killed or seriously injured by their abuser. In 2021, NHLA represented 207 victims and survivors and spent over 9,500 hours representing victims and survivors in New Hampshire courts statewide. House Bill 1550FN requires the court to permit any child 12 years of age or older to testify orally or in writing at any proceeding to determine parental rights and responsibilities. And as we just heard regarding the amendment, gives discretion to a judge to allow a child under the age of 12 to testify. While I'm sure this bill is well intended, this bill is problematic for the following reasons. One, this bill is not in the best interests of children. Someone testified earlier today that children don't deserve to be put in the middle. But if called to testify, children may perceive their participation as forcing them to choose between their parents, which is a harmful proposition in the best of circumstances. But consider an abuser skilled in the art of coercive control and manipulation, grooming their 12-year-old child to testify against the other parent at a final parenting hearing. What is to stop that parent from making threats? For example, to kill the child's beloved family pet, to harm or kill the child, or to harm or kill the child's sibling, if they don't testify exactly how they want them to? The answer is nothing will stop them. What then happens to that child if the court does not rule in favor of the abusive parent? That child may be susceptible to further abuse if their testimony just isn't right in the eye of the abuser. This bill doesn't shield the child from cross-examination. That means that each parent will have the right to question their own child on the stand under oath, either themselves directly or through their attorney. This bill doesn't make the courtroom confidential, unlike child abuse and neglect cases. That child will be forced to testify in public about their home life, their relationship with each of their parents, what they have witnessed, and where they prefer to live and with whom. 2, this bill contradicts state policy. Section 6, page 5 of the parenting plan states, each parent shall promote a healthy, beneficial relationship between the children and the other parent, and shall not demean or speak out negatively in any manner that would damage the relationship between either parent and the children. Forcing or encouraging your child to testify against one of their parents in no way promotes a healthy or beneficial relationship between the child and their other parent. Ironically, it also puts a condition on a minor child to speak out negatively about one parent, while simultaneously advising parents, the adults, against doing that very thing. In fact, if passed, this bill would be in direct contrast to the state's policy under RSA 461A2, which is that children do best when both parents have a stable and meaningful involvement in their lives. Allowing for children to testify against their parents in a family court proceeding has significant potential to irreparably harm the parent-child relationship and is likely to lead to instability and further tension and conflict within the family unit. This bill does not account for existing court practices. Family Division Rule 2.8 states that a child should not be brought to court as a witness or to attend a hearing unless there is prior written order from a court allowing that child's participation. So the court does recognize that there are some circumstances where child testimony may be warranted, but certainly that is the exception, not the rule. This is intentionally done to protect children from the process, which is likely to be adversarial. Traditionally, it was the GAL who would interview the child and report back to the court about the child's demeanor, concerns, and preferences. This process, while at times is not perfect and may even be problematic, was an opportunity for children's voices to be heard while being spared from being placed squarely in the middle of a contested court battle. With the elimination of the GAL fund in 2011, families who are unable to pay for a GAL no longer have a GAL appointed to their case. As a result, some judges have been more inclined to interview children in chambers in the process that you just heard from Mr. Head. And this is done in an effort to increase access to justice in those cases involving low-income litigants. Another person testified earlier today that children don't deserve to be with the best parent, but both. But that is exactly what this bill does. It forces the child to choose the best parent. For these reasons, NHLA asked this committee to vote inexpedient to legislate House Bill 1550 FN. Thank you for your time, and I will take any questions.
Thank you. Any questions? Seeing none, thank you very much for your testimony.
Thank you so much.
Next, we have Anna Goulet Zimmerman. You've requested 2 minutes.
Thank you, Madam Chair, members of the committee. My name is Anna Goulet Zimmerman. I am an attorney. I practice in Manchester, and I am also a member of the New Hampshire Association for Justice. I used to do a lot of family law. I now do as little as possible. But I do still do it. And one of my big philosophies was always, what's the best thing for the children here? And I turned down cases when I thought the people who were coming to me were being unreasonable in their expectations and what they wanted. And if I had ever had a parent walk into my office and say, my 12-year-old is going to testify, that is definitely a case I would not have taken, because I would not want to have been part of harming a child in that way. Children should not be in court picking a parent against the other parent and then being cross-examined by the other parent. It's almost like the Tale of Solomon, right? The parent who puts that child on the stand is harming their child. There are ways to get that evidence, as you've heard. They're guardian ad litems. Honestly, it concerns me when I hear people say things like, children are writing these letters that they can't give the judge. They're writing down all the time what they think should happen, because children shouldn't even be involved in this process. Now, there are exceptions. I guess I shouldn't say that too strongly, but there are some exceptions. But for the most part, this should be parents saying, we're working this out. Mom and dad are trying to work this out. No, we've got some disagreements, but this is not what you need to worry about. Parents should be promoting healthy relationships for both parents with their children, and having those children get involved, take a stand against one child, one parent, write letters against one parent, go to court and testify against one parent is not that. We have a standard now which, once someone's a mature minor, and it's not automatically 12, it's not automatically 14, the views of that child can be taken into consideration. And that's done, as you've heard, through either guardian ad litem or the judge privately in chambers talking to that child about what's going on, what are the concerns, why are they making that. And then the last thing I'd add is that it's not just, I'm talking about 12 and 14-year-olds, I would say this applies all the way up. No child there should never be an automatic, we're gonna put the child on the stand. If there's an extraordinary circumstance and the judge thinks it's appropriate, in my experience, the judges are very concerned about trying to do what's right for the children, trying to weigh all the evidence in family court, which is a very difficult place to be often. The large number of pro se litigants makes that even more difficult. But it's just not appropriate. I mean, I look at my own life. My daughter, who's now 20, when she was 16 and 17, she hated me. You know, and if you've got little kids, anyone, you know, it's common. She's a great kid. She loves me now. But would we still have that relationship if that had been, she's going to be in court telling everyone how much she hates me and how horrible her life is with her mother and all that, instead of us working it out and doing the things that we did? So I would ask you, please, vote in expedient to legislate this bill. Oh, and I'm happy to take questions.
Any questions? Representative Long.
Thank you, Madam Chair, and thank you for your testimony. Have you had cases where the child went in the chambers and
Yes.
spoke with the judge?
Yes.
And a follow-up, if I may, on that?
Certainly follow up.
And what was the disposition of those generally?
So generally, the judge would say something along the lines of, I've spoken with the child, their wishes, because it was usually like, what would the schedule be, are consistent with what is presented in this order, and then they'd issue the order without getting into a lot of details, any details about why or what they said against one parent or the other parent or anything like that.
Okay, thank you.
You're welcome.
Thank you. Any further questions?
Thank you for your
very
time.
much for your testimony. Next, I'll call Representative Belanger. You've asked for less than 5 minutes.
So I said give or take 5 minutes.
You said less.
It's like somewhere in between there. I'm not sure, but I'll make it brief.
Thank you.
So for the record, my name is Representative Cody Belanger, and I represent the center of the universe. For those who don't know, that's Epping. Thank you. When I was 12, I was removed from my mother's care from the state of Vermont. And I'm very open and honest about my stories. I have nothing to hide. And my father was there, and my mother came to me crying and said, "Your dad's trying to take you from me." I was about 11 to 12 years old at the time. Now, despite now as a grown-up, I probably would have been better off with my father because my mother was an abusive person, and now I realize that. I was about 12 years old when this happened. So if this bill was to pass, and I stood up in the court hearing, at my foster hearing, and told the judge, I want nothing to do with my father. That's what we're talking about. Now, I do oppose this bill for personal reasons and other reasons. There's a better way that we can go about doing this. In my adult years, I was a parent educator for a company in New Hampshire that services DCYF. And I saw firsthand a family persuade their 12-year-old daughter to tell the judge that they belong with mom and dad. And these are issues that are happening. So for those reasons, granted mine was from Vermont, but we eventually moved here about 12 years, a few years after that happened. For those reasons, I ask that we oppose and ITL this bill. Thank you. And I'll take any questions.
Any questions for the representative?
Thank
Seeing
you.
none, thank you. I don't have any more pink cards, so I will now close the hearing on House Bill 1550. And we will now open the hearing on House Bill 1511 with the sponsor, Representative Gay.
Has everybody gotten their copy of the amendment
Yes.
and the pink testimony.
Can you pass a couple back this way, dear? Thank you. Oh, I'll keep one of those. There you go.
This is the conclusion of the two other bills about making your own recordings and making your own transcripts. This is really why the effort was made to make it legal for people to make their own recordings and transcripts. And this in no way undoes the current method of filing an appeal to a higher court, because the appeals currently mean that you have to submit your official transcript with, and maybe the official recording. I'm not sure if you have to do the recording, but in this case, it would mean that to file an appeal where the recording was wrong, omitted important information, you would submit both. You would submit your own recording and transcript and the official recording and transcript, and you would have to notate where they differed so that the court personnel would not have to waste a lot of time trying to find it. And this is a very serious issue, as you've heard some people say, and there are plenty of people who have told us who are not testifying today, that their official recording and transcripts were different, omitted really important information. So if you have any questions, I'll be glad to see if there's any more to clarify.
Any questions for the representative? Seeing none, thank you for your testimony.
Thank you.
Next, I'll call Mr. Richard Head.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. There's actually a series of bills, one of which is in Judiciary, House Bill 1592, that would allow parties to make their own recordings. And then we had the other one, which would allow the parties to submit their own transcripts. And then this one, which is to submit any recording or transcript of any relevant hearing to the appellate court. So I lose track a little bit of some of the bills in terms of what their intent was. One of the problems with allowing, and again, we're talking, because we don't have family court anymore, family division. And family division does a wide range of cases, and this would appear to allow any party to record any proceeding in family division, whether they be confidential, whether they, without regard to the subject matter, domestic violence proceedings, just a wide range of types of cases. Some are extremely confidential or private, some are extremely or confidential, and without any sort of role of the court. And again, I understand that some have concerns about court discretion, but court discretion is important because one of the aspects is, what is the subject matter being discussed here? What would this recording be recording, and what would it be capturing? The other issue and concern with individuals recording hearings is what is being captured. Are we capturing conversations that are happening in the galley behind by people who don't realize they're being recorded because the microphone may be at the telephone, which may be not up front, but maybe in the back? Is it capturing information that people don't realize is being captured? Is it, what's the nature of the proceeding, because the court does not have control over that recording. Is that something that would be posted on a website or on the internet, social media? Would it be modified in some way so that it would appear in some social media setting to be testimony along different lines than what actually happened? I'm also very sensitive to testimony that has occurred where the court's recording is not complete and accurate. And some of that has occurred, and as you've heard some testimony, that in circuit court, the judges are responsible for controlling the recording. We used to have what are called court monitors. Before that, we had court stenographers. So the stenographers were actually doing all the stenographic, and you would order the transcript from the court stenographer. Then we had monitors, and the monitors were responsible for the recording equipment. And then through more budget cuts, the judges are doing it now. If we brought it back to monitors, you wouldn't have sort of that concern that exists that we've heard in testimony here about the judges controlling the recording, but we don't have that currently. So I get, and I'm sensitive to the concern that people have raised about having something that would ensure that the recording, the official recording, is accurate. This bill, however, doesn't quite do that, and I'm not quite sure what this bill would do, because it would allow apparently the parties to submit any recording to the Supreme Court. Somebody else may submit another recording to the Supreme Court. Some of these hearings are multiple days. So we have multiple days of recordings that are being given to the Supreme Court. Supreme Court doesn't just focus on a particular line or a particular sentence in a transcript. It's looking at the record. So now we have multiple days of recordings that the justices have to be listening to sort of discern what is the record. It's really not the way an appellate record is created, where you have competing recordings, competing whatever it may be. It's really a role, and maybe there's a better way of doing it. And I'm not insensitive to that. But as this bill is written, and again, I'm talking about the bills that are being presented, and I haven't seen an amendment if there is one, that this would just allow the parties to submit any recording or any transcript. Again, no standards, no quality control, no sort of unclear as to what that means to the appellate court, and then the appellate court decides which may be used as the basis for the appeal. And it's really the burden of the parties to present to the court what the record is. And if under this scenario, it's really the parties are leaving it to the court to determine what the record is, when they're not the appealing party. The court has to be the unbiased, Supreme Court's the unbiased receiver of what the record is. It has to be sort of as accurate as it can be. So whether there's an amendment that gets to a particular issue, I don't know, but this would just have, without any ability of a trial judge to decide, given the context of the hearing, whatever, a right to record, and that recording of whatever quality is now potentially the record that's going to the Supreme Court. It just have significant grave concerns. And again, as I testified earlier, there is at least a court rule that would allow parties to stipulate as to what the record is. Again, I get and I understand that these can be incredibly contentious cases, but there is at least another avenue for presenting the record. If there are other ideas and solutions, as I said before, what we're talking about here are the rules of the appellate court, and there is a rules advisory committee, there's a rules making process. If people have suggestions on rules about what is the record, it's really not, it's a judicial function as to what is the official record that goes to the Supreme Court. And with that, I'd be happy to answer any questions. Thank you.
Thank you. Any questions? Seeing none, thank you very much for your testimony.
Thank you.
Next, I'll call Katrina Heinrich. You asked for 3 minutes. We'll give you 2. Yes, I do, right here.
Hi, I'm Katrina Heinrich again. I agree that the intent of this bill has some merit. but it does need some amendments. As to what those amendments are, that needs to be determined. But one of the things that has popped up in testimony was the fact that judges that are supposed to remain altered and neutral can control the record. I believe a bill like this needs to add some kind of element that holds them accountable. So official court recordings that bear missing time and discrepancies shall be deemed suspicious and possibly altered and subject to penalties under New Hampshire RSA 64.7. I think something like that is critical when we're talking about, well, no, we're not going to give you a right to actually have a recording that might prove you were telling the truth and somebody else altered it. These are issues we certainly need to look at. As I've already stated, in my case, the discrepancies and missing time segments is an issue. I observed both ethical and procedural misconduct by the officiant toward one party in a case, which I've already testified to. I think it bears maybe a little more scrutiny, but I don't believe it should just be tabled. Thanks.
Thank you. Any questions? Seeing none, I'll call on the final speaker, Dana Albrecht. You asked for 30 seconds again. Thank you.
Maybe back up to 45, because so this echoes the issues on HB 1551. You already heard my testimony on that, so I won't repeat it. For this, I'd just like to point out that currently the record is governed by Supreme Court Rule 59. And because of the issues in my case, I asked the trial court clerk to provide me with a certified CD of audio. By that I had in mind she'd sign it, some kind of seal, the same way you do with paper copies. Just indicating that the clerk was representing that this was true and accurate audio. And apparently that's prohibited under Supreme Court Rule 59. So there's no way we can ask the court right now for official audio. You know, there is no such thing as official audio. And I just think it would be valuable for us to at least be able to do that. That concludes my comments.
Thank you. Any questions? Seeing none, thank you very much.
Thank you, Madam Chairwoman.
And that concludes the hearings on House Bill 1511 FN. I will close that hearing. We can now open the hearing with a pink card from Representative Gay. Okay. However you choose, Representative. I know, huh? Okay, we're going to open the hearing on House Bill 1458 FN.
Whoops. Supposedly, there's already a rule that judges can rule that motions are excessive. But apparently, it happens so frequently that that's why I've submitted this bill. People are being harassed by, it is a favorite way to harass the person that you aren't happy with. So even though you're, like, for instance, for child support, there's really a rule that you can only address it every 3 years, and yet you're going to hear from people who have a motion filed against them every 2 months. And so that's why that's the real basis for this rule, for this bill, to stop these frivolous, excessive, harassing filings that a judge should be able to tell is unfounded. The testimony sheet from, again, that mother of 2 daughters, she says, my case spanned many years with countless filings. Her parents, she told me her parents paid for her legal fees. Apparently her ex had a lot more money than she did, and he ran up because she would have to answer his filings, and she was afraid to go pro se. Her parents paid $500,000 to respond to his constant harassing motions. She said, I was eventually let go from my job due to the days off I required to attend court hearings and court-ordered appointments. She was also ordered to go to years of therapy to determine whether she was a stable person. And so that was expensive, and that took a lot of time. So she says, overall, the solution would be to limit the length child custody cases remain open, especially where there's substantial evidence for one parent to have custody. That's the dad was a drug addict and had other things that made the kids not want to be with him. So anyway, to me, it's a very simple request that the judge uses their legal power to deny motions that are repetitive, excessive, and harassing.
Sorry, are there any questions for the representative?
Thank you.
Seeing none, thank you, Representative. Votes? Richard Head? Yeah, I didn't realize.
Morning, Mr. Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We don't have a position on this bill, but some information. There is a rule, as you heard, that would allow parties to, if there are sort of harassing pleadings that are being filed, for the parties to essentially not have to respond. That does get used, and it has been used. One thing that so I practiced litigation for a better part of 30 years. One thing I know about rules is rules beget more litigation. So once you create a rule which would itself impose costs and penalties, you're going to see motions asking for those to be imposed, and you're going to see more litigation over whether or not something is harassing. It's just an inevitable part of putting together a rule like this. You're going to see more litigation, perhaps more harassing litigation over something like this. In the context of divorce and family division, as you've also heard, there are a significant number of pro se parties who are not represented with an attorney. And it is true that judges do give some leniency, not leniency is the wrong word, but some leeway for unrepresented parties who may not be familiar with the system in the nature of their filings. It does not mean that they're allowed to be harassing. It does not mean that they're allowed to be intimidating. But a judge does take into account the sophistication of the party and whether or not they're an attorney. If there is an attorney that is filing it and the judge believes that those are being filed improperly, that judge can direct that attorney to stop filing them and can impose sanctions in terms of a referral to the Professional Conduct Committee if that's appropriate. But what the bill sort of as written simply says that if the judge finds that there's excessive or harassing legal filings, that they can impose these penalties. I'm not sure that's going to change the number of those cases that are found to be intimidating, harassing, but it will itself create some more litigation over that subject matter. The bill is also, and I think there was an amendment which I've not seen, but it also says that it shall report such conduct to the Supreme Court Committee on Professional Conduct, which is appropriate, but only if the party doing it is an attorney. And as I said, the vast majority of these cases are pro se, so there is no attorney, so there would be no referral, and so I'm not sure what that line was intended to do, since most of these are not going to be caused by an attorney. But I'd be happy to answer any questions if there are any. Again, we don't have a particular position on the bill, but just had some information.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Next we have Katrina Heinrich. You've asked for 3 minutes. If we can squish it to 2.
This is, I'm Katrina Heinrich. Again, sorry about that, but this case is my case. This is over 30 pages long, and this is the case summary. All it is it says how many hearings and stuff there's been. Within the first year post-divorce, there was numerous ex partes, all frivolous, nothing. There was nothing, and yet the judges gave merit to them. This is part of a process that has been well documented, again, in the proclamation that the governor signed. The studies support exactly what we're saying. Again, it's across the United States, not just New Hampshire. There's a process, a methodology to finding the cases that they're going to elongate. My cases happen to be one of them, but it has to have several pieces to it. The studies choose to use words like, it has to be post-divorce. They say, well, the court already, during the divorce, already has all your financials. They know where your assets are. There has to be an unhealthy parent. There has to be a healthy parent. The discovery documents are critical. And then, of course, the GAL, outsider information. These pieces are necessary for any of these cases that I've been talking about, like mine, to proceed. With the inherent over filings, it affects jobs, it affects visitation, no matter who has the child. It just is a constant reminder. In my case, every Friday that there was visitation, there was something filed that would inherently ruin that visitation. The judge would not be able to hear it. So you lost another one. This was a way to slowly take away visitation. So in my case experience, the other party was permitted to file meritless ex partes, frivolous emotional slander, and allegations. The filings were not only entertained, but the entertaining of them, always finding in the favor of the filer, the court encouraged his behavior. He was very, very outspoken and arrogant about it. He could file as much as he wanted. With the lack of due process, the court did not require any evidence of allegations, Instead, permitted the frivolous motions to be used to prevent established visitations to control my movement through society. That included access to children's events, activities, access to records, and more. And remember, at the end of the divorce, I was the primary parent because I was always the primary parent. But that switched in these ex partes for no valid reasons. My children were healthy, clean, and well educated. They were very outspoken and considered above average. Yet, the court refused to listen to those facts. In entertaining these baseless filings, the court undermines the public trust and the integrity of the institution. The court has the ability to protract cases and post-divorce on facts from the discovery process. Once established, the GAL re-engages and frivolous filings begin and final divorce is turned upside down. The damage goes beyond financial and time ramifications. In the end, they are artificially manufacturing a brand new reality. This brings me back to the testimony I gave you earlier in the day, where once you are out of divorce court, they start at zero and they create an artificial reality. And these cases get prolonged. Again, mine is over a decade old. And that's all I have to say about it. Thank you.
Thank you. Any questions? Seeing none, thank you very much. I'll next call on Anna Goulet Zimmerman. You've asked for 2 minutes.
Again, my name's Anna Goulet Zimmerman. I practice law in Manchester, and I am a member of the New Hampshire Association for Justice. I would point out that with regard to attorneys, under our rules of ethics, professional conduct 3.1 already prohibits attorneys from frivolous filings. And there is actually an RSA 50715, which applies generally to all courts and covers this exact same language. So I would start by saying I don't see why there's any need to add this separately into two separate provisions of the family law statutes where it already exists. I would also add that the courts do have the ability to limit the frivolous filings. You have to ask for it. I was trying to remember if it's once or twice. I think I've asked for it twice, and I might have gotten it twice, but I know there's at least one case where I just filed a motion saying, please tell me I can stop answering these things. It's taking too much time, and it's going to cost my clients money, and this is just harassing. I was a pro se on the other side, and I proposed that if there was a motion that the court thought might require a response, they would notify me, and my 10 days to file my objection would happen at that time. And it worked great. I just stopped responding to anything for about a year and a half, and then there was one that came up, and we had to answer it. So there are remedies already in place, and this is just unnecessary. Thank you.
Thank you. Any questions? Representative Belanger?
Thank you, Madam Chair, and thank you for being here today and providing that testimony. Quick question. So you mentioned you were an attorney, correct?
Yes.
Follow up to that technically.
Certainly.
I was just clarifying. So if you as an attorney were filing repeatedly over and over and over and over again, do you think the judge would catch on and go, what's going on?
Absolutely.
Follow up? I'm sorry, were you done?
Certainly follow up.
No.
Okay. And then second to that, don't you have ethical obligation to not do that?
Yes. Yep. That's rule 3.1. I have an ethical obligation not to. The court can report me. If there's an opposing counsel could report, could do that. Most often, again, we're talking about pro ses. And then, of course, the other problem is, as an attorney, we only have half the story when we hear the story, right? So we get lots of calls that sound like, oh my gosh, this horrible thing has happened. And I always would start those by calling the opposing counsel and say, help me understand. Do you know what's going on? But sometimes you can't reach someone. Sometimes it is something that requires immediate action, and you take it based on, good faith and what you believe is the right thing at that time. And then sometimes, you find out there's more to the story, as there often is. But but we're all kind of going into the system usually, at least the attorneys on it, trying to do the right thing, understanding what the right thing is. And I think the courts are in the same situation. If they get a pleading that looks like it's an emergency, someone's filed an emergency, you know, they can't take the risk of just saying, okay, never mind, just go back with that other parent. They have to have a hearing on it and look at it and figure out what happened. And it's unfortunate in some cases, but we've all seen the really, really tragic cases that have gone wrong. And you know, that's what the courts are always trying to weigh, I would imagine, and that's a heavy burden.
Any further questions? Thank you very much for your testimony.
Thank you.
Next, I'll call on Vivian Gerard. You've asked for 2 minutes. Is she here?
She stepped out to speak on a Senate bill that affects her.
Well, we'll put her behind you,
Sure.
Mr. Albrecht, and if she's back, we'll call on her.
Thank you, Madam Chairwoman. Again, Dana Albrecht, Nashua, New Hampshire. I'd just like to point out to the committee, first of all, that just because something might have hurt me in my case doesn't mean it's bad legislation. And briefly echoing back to my morning testimony on appeals, in that exhibit was a finding by Master Dalpra that my attempt to correct his bad order was harassing, so he could have hurt me for that. But that's, I think, an issue of judges and not legislation. So again, just because it would have hurt me doesn't mean it's bad legislation. I think it's good legislation. I like it. I don't think it goes far enough. I just want to bring up one other problem I had where there was a witness in my case who felt very intimidated because he was facing false criminal charges. I was also given false criminal charges. And he was hoping to make it here today to testify. So I don't actually want to speak too much to that. I just wanted to provide his police report for you while I'm here because I already made copies. And I'm sure he can follow up with any written testimony later. So that's all I have on this. If there's any questions,
Thank you.
happy
Any
to take them.
questions? I see none. Thank you very
Thank
much.
you.
So although Ms. Gerard is not back, there is testimony being passed around. I did speak with her and let her know that I would put her at the end. And but we are going to have her the benefit of her testimony. You can make a note that she's not here, but we submitted, yeah. And with that, I will be closing House Bill 1458 FN. Yes. And we're going to give 2 minutes break. You take your time. Okay.
So I don't get into trouble sometimes. I'm still the co-sponsor.
Yeah, no, there'll be no execing today. Thank you.
OLS. Oh, it may have fallen out. I did, but it must have fallen out, so I'll make another one. Thank you, Madam Chair. We are, sorry. Bill 1458. Nope, that's not it.
No, it's Bill 1253.
I'm sorry.
That's okay.
I just got lost.
It's all
And I
righty.
just had it. If somebody just gives me, there is nothing to add, there's nothing to pass out. If somebody just hands me a copy of 1458, I can do it.
No, 1253.
1253.
Thank you, ma'am.
Thank you. Okay. This bill would allow parents to choose the counselors because kids are assigned by judges counseling on many occasions, and the parents don't have any choice in who this counselor is. And we really think that if you can get the parents, if the parents agree, they can suggest counselors of their own choice. And of course, if they're going to not agree, then after a certain amount of time, the judge would regain that prerogative to make the choice of counselor. What changes in the bill is that, number one, that the parents get the right to choose. And this is an old change that should have been written years ago because they tried in previous laws, previous RSAs, to direct payment. In selecting a counselor, they would accept, the old terminology was accept direct payment from the provider because that was the best wording they could come up with, so that they would be honoring the parents' insurance so that they would not be paying out of pocket. But actually, the most current terminology, one of our representatives is a retired MD, and so he said it should be, instead of accepts direct payment from, they are a participating provider in the party's health insurance. This is already in RSA that you're supposed to try to accommodate families' medical insurance. But right now, from all the cases that I have heard, parents get told who they're going to take their child to, and they don't have any choice in who this person is, and lots of times it's out of pocket. And that goes for the parents as well as the children. So it's one more debilitating financial burden of being in the family court. That's it.
Thank you. Any questions? Seeing none, thank you very much. I appreciate your time. You've had quite the day. And it hasn't come to an end yet. So next I'll call Katrina Heinrich. You've asked for 3 minutes. We're asking that you squish it a little. And I appreciate it.
Squishing, Madam Chairwoman, squishing.
You've done a great job.
Okay. Well, I try to eliminate, if you've already heard it, what's the point? So on this bill, you know, we know counseling has numerous issues. Some of the biggest ones is that children that are already in counseling, maybe you have a proactive parent, they're getting pulled from those counselors in that relationship. And as Representative Gay said, billing is an issue. Frequently going to therapists who don't necessarily have a license, they're getting billing codes that don't exist, so they can't really bill for it, so they're having to pay cash out of pocket. I think this is a familiar topic that we talked about in 2020. With that said, I think there are some things that could be relevant if we added to the bill. I think we should add something to the extent of any existing patient-provider relationship shall remain intact. Any existing provider evaluation and/or diagnosis within 1 year time frame shall be accepted as current information. and the court shall accept the professional conclusion as fact. If a child has been in therapy for more than a year or consistently receiving treatment from a specific provider, that provider and diagnosis shall be considered current. Such a relationship shall continue as long as considered necessary by the provider. Selection of a provider shall not be contingent upon the sole discretion of the policy-holding parent by default. Both parties must be in agreement with provider and insurance. The court shall not order counseling and therapy services unless medically indicated and not as a mechanism to advance one party's cause over another. The court shall also not make medically unnecessary inquiries or interventions. I refer back to what happened to my middle child. All the children had already been evaluated. They were all considered to be excellent students, well-respected students, and above level. However, once the case started being flipped, the first thing they did was they tried checking the middle child into a psych ward with no reason. I got calls from the police coming to pick up the child. This happened 2 days in a row. The child then gets pulled by a self-inserted guardian ad litem who has not been reappointed to the case, and he comes to me and tells me that if I ever want to see my children again, because he is going to take them, that I have to comply with who he has chosen. He has an existing relationship with this provider. He used them for his case, and they are known to do specific therapies that are not in the best interest of the child. The billing on that, there was some that was cash, there was some that was not. At the time, I was not wise enough to really be paying attention to the billing codes. That is a huge issue. So I think when we're looking at something like this, I think the additives to it is probably a way to make the bill better. Not necessarily to make it more complicated, but I'm looking to find a way to make it perhaps a little better, so it actually has a very thorough purpose, and that there is accountability, which is what is lacking throughout the family court. And with that, I'm not going to give you any more examples. You definitely understand this case. The only thing I will add is my daughter that, as I mentioned this morning, due to severe PTSD, could not be here as much as she wanted to. She did want me to convey the simple fact that had she not been moved, she wouldn't have this PTSD. She wouldn't be in the situation she is in. The state of New Hampshire's court failed all 3 children, specifically her. She wound up with medical incapabilities that were physical that could have been prevented, and then she wound up with mental. All preventable, and all with the only parent advocating for the child. So, thank you.
Thank you. Any questions? Representative Katrina. Ma'am?
Excuse me.
Yep. Oh, hello.
Thank you so much for taking my question. I
Oh,
just
yeah.
wanted to know if you submitted your recommendations for amendments to Representative Gay, because you presented a lot of
I
ideas.
did submit them to her. I don't think she has them on her, but I did submit them to her via email, so she
Okay.
does have them. I will also put it in my things to you guys.
Perfect.
Thank you very much.
Okay?
Thank you.
Mhm.
Anything else? Any other questions? Thank you all. Next, I'll call Gail Drubat. Thank you. You've asked for 3 minutes.
Yes. Thank you, Madam Chair.
Can we squish?
Oh, I'll read quick.
Thank you.
Thank you, members of the committee, for the opportunity to testify before you today. Each of you, as our elected policymakers, have the greatest ability to reform outdated laws to better protect children and families of New Hampshire. My name is Gail Drobat. Although my own family is intact, I advocate for other parents that have been abused by the New Hampshire family court system. I come before you in support of HB 1253. I believe this is imperative. A counselor ordered by the court of their choosing, in my opinion, allows the court-affiliated therapist to be biased from the onset of therapy. It is also imperative that each therapist in court-involved proceedings, at minimum, are credentialed in family systems therapy, a therapy that can assess, diagnose, and treat the symptoms that recognizes the breakdown in the family. Otherwise, these therapists are getting it wrong a lot of the times and side with one parent. Again, one of the fathers previously mentioned was forced to sign on with a therapist of the mother's choosing, believed to be recommended by the guardian ad litem. That therapist allied with the mother, did not include dad in the process, made unfavored assessments that was dictated by the mother. This information is in email correspondence. This therapist, again, was court-ordered to provide billing and insurance records to the parties in a September 2020 court order. To date, the counselor is in contempt of that court order, and the court defies making her present those documents. She states she doesn't have them, although her ethical codes dictate that she is to maintain those for 7 years after the age of majority. So there should be no reason that she doesn't have those documents. And the court now is making the father pay attorney fees to opposing counsel because she's defied that court order and he wants the records. So it's imperative that I believe therapists need to be chosen by parents and not court officials, because I feel they're choosing their peers that aren't qualified in the breakdown of the family. So,
Thank you so much.
you're welcome.
Any questions? Seeing none, thank you so
Thank
much
you.
for your time. And with that, that's our, whoops, wait a minute. Whoops. We have Dan Itza.
Thank you, Madam Chair, members of the committee. For the record, I'm Dan Itza, and I reside in the city of Manchester. First, a technical correction to the bill. Roman numeral 3, line 4, the first word parents, that should be parties. The way this is written, the parties would have the power to choose their counselor, the counselor for their children, but not their own counselor. And very often, the parents are included in the counseling requirements. So that there's just that word change to make the law correct. Beyond that, I want to advocate for the power of the parties to choose the counselor or counselors. Very often in the instances that I have observed where the cases have gone sideways, where they become complex cases, there is a pattern where you have a judge, a GAL, and a counselor, and you see that triumvirate repeated on multiple occasions in multiple cases. And it appears to be, at least in my opinion, a cottage industry. The fact that these counselors are making life decisions for families, the families need to be in control of whom their counselors are. I think it's vitally necessary. I'd be happy to take any questions.
Any questions? I see none. Thank you very much for your time. And with that, I will close the hearing on House Bill 1253. And Representative Gay, do you have a pink card ready? Okay. If you will hand them to my able assistant, that would be great. And with that, we'll open the hearing on House Bill 1199, and it's 3:38.
Thank you, Madam Chair, and thank you for all your patience in dealing with so many issues. House Bill 1199 deals with such an important issue that we have a judge who has come to plead her case. I'm here because as a person who got involved in family court through victims of domestic abuse, I am particularly concerned about the effects on children, as you all are. And the testimony, this pink testimony, is not from the mother. This is from the 15-year-old daughter who had to endure 5 years of reunification therapy. I'm not sending you or giving you all the many aarticles on reunification therapy, but one of the real strong points is you can reunify people who were unified before. But to call it reunification if those people had no relationship or had a very hostile relationship, that is totally different. I thought it was so important that this girl decided that she really wanted to tell you what it was like, because it's not anything like counseling that you've ever heard of, and that's why most professional counselors have never heard of reunification therapy, because it has no training, it has no certification, it has no coverage by insurance. So when people are ordered to go through it, they get to pay out of their pocket the $150 to $350 per hour for it. So it also impoverishes people. Besides, in the case of domestic abuse, it forces children or spouses to sit there in the same room with their abuser. And it takes, by law, it's very difficult to prove abuse. So even though it happens, and we have centers around the state to help victims deal with it, it happens a lot. And I have learned last week, I heard back from Attorney Barry Gold, I'm saying his name wrong, Gold. It's not Goldsmith. Oh, you can see why I'm really an unusual politician, since I can't remember words and names. But
is it Goldstein?
Yes, it's Goldstein. And he's written several books. And I actually did print, I'll have to find it because somehow it didn't make it into my bag. I guess I'll just send it to you, because in his webpage, he lists 12 things that in the 1970s people just assumed were facts. And since then, we've had a lot of research to refute those and explain better how you identify domestic abuse. You know how it started out as just bruises, but then we realize it's much more extensive than that. But I will send that to you because it was extremely educational. But he's written at least 3 books. So I will send that to you. But meanwhile, the pink page is the testimony from a 15-year-old who says in here she's actually written to court before, and of course nothing happened as a result of that, but it made her feel better that she was trying to give herself a voice. So please read that. And the change, this law, we had lots of people offer what they thought was a best way to state this. I'm personally not against family counseling at all. I think that's a really useful tool. And when children have been swayed by one parent or the other, or bribed, we all know we don't like that. We really want somebody who's impartial but caring to try to do an analysis of the children's situation, of the parent situation, and work as a family system to bring the best result that they can. However, what's happening right now with reunification therapy is they're pretty much following its creator's opinion, Richard Gardner, who liked to be called a doctor, but he didn't have patience. And he had some really strange opinions, like sexual abuse of children really wasn't sexual abuse, and reporting it was more damaging to the child than the actual acts. He has a very strong following because rich abusers loved him, and unfortunately that has taken over as a credible argument in American courts, in British courts, in Australian courts. Meanwhile, counselors, real genuine trained certified counselors, say this is not true. This is they don't say hogwash, they use other words, just meaning it is not legitimate and is extremely damaging to children who have been abused to be put in front of a counselor who's going to tell them that they need to make a peace with this parent who has abused them. So the wording here doesn't say anything negative about unifying in a family. What it says is the court shall give due consideration to selecting a counselor who is a participating provider in the party's health insurance. The money does count. People do need to be protected that way. Any therapy to unify a family with counseling shall be provided by a mental health therapist certified or licensed by the state of New Hampshire and trained in family systems, who will first evaluate the family members to determine if such therapy is appropriate, whether or not the children are covered by health insurance. That's a legalese thing dealing with previous laws. So this says to unify a family, you need to have a trained counselor. And right now, people who have a shingle out that says I'm a reunification therapist do not have to be. They don't have to have any training in family counseling. They may be a counselor, maybe in weight control or something, but if you read, I hope I've already sent it to you. If I haven't, I'll resend it. Testimony from 5 different people who have experienced devastating effects of being pushed into reunification therapy with a person who doesn't care what has happened, and if you're been abused, that's tough. You need to make peace with this parent. And the children are told, if you don't, we're going to give custody of you to that person. So that you can imagine what fear these children live in once they've been taught. And she's very good about talking what it was like. And she had to go through it 5 years. And the amazing thing was, she and her sister finally, at the end of 5 years, they told the counselor, they went in there and they said, we're not coming anymore. So she was horrified. And she said, they said they had to stay. So they stayed the whole hour looking at the floor, which I thought was amazing gumption for kids who had gone through this for 5 years. So that's my story.
Thank you. Any questions? Seeing none, thank you very much. Next, I'll call on Katrina Heinrich.
Again, I'm Katrina Heinrich. On this particular one, and Betty did an excellent job of conveying so many of the stories, some that I've participated in. This particular bill is critical to kind of some of the pieces that the Honorable Itza spoke to for the trifecta tactic that's being used. In particular, again, in courts across the nation, not just New Hampshire, the GALs are specifically working way outside of their context. They shouldn't have the ability to go beyond the scope of their jobs or in function to move the case from one direction to another post-divorce. That can be occurred by all these different avenues that they stack up, one being this reunification therapy experiment. And that's the only word I have for it. It's an experiment, because all I have heard is the kids that have been in it and the kids that my daughter has met with, is they become very confused. They don't know how to function anymore. The only thing I can really summarize my feeling on this is that in my experience, the title, or whatever you call the action for a type of certified therapy, is only relevant when it is a proper billable diagnosis, that it is provided by a neutral certified practitioner who can justify their findings, that it is medically necessary, that there is a reason component for it. There must be something. That brings us back into the courtroom, where judges are allowing, even ordering it and practicing in the trifecta. If it isn't necessary, why are we doing it? Are we trying to force relationships? It's just a very valid question that I think needs to be explored. And that is all I have on that.
Thank you. Any questions? Seeing none, next we'll call Anna Goulet Zimmerman. You're asking for 2 minutes?
Madam Chair, members of the committee, I'm not sure if I should keep introducing myself, but I will in case the record's split up. I am Anna Goulet.
Yes, for the record.
I am Anna Goulet Zimmerman. I practice law at the Law Office of Manning and Zimmerman in Manchester, New Hampshire, and I am also a member of the New Hampshire Association for Justice. I think if I'm understanding the modifications or the amendment that was proposed as it was read in by the sponsor, I am less concerned, but I also don't know, I just don't understand why this is necessary. I mean, one, if there's no training or certification or anything like that specific to reunification therapy, how do we prohibit it? But this notion of what is medically necessary. I can think of a ton of situations, and I'll give you a couple of quick examples, where it is definitely, without a doubt, in the best interest of the child to try to have a positive relationship with both parents. And I don't know if we call it reunification therapy, I'm going to put that in air quotes, or if we call it how do we improve the relationship between the children and the parents therapy, but it amounts to the same thing. I represented a young father once who had a little kid who he didn't even know was his child. When DCYF came in, took the child from mom, there started being questions about, well, who's dad, where's dad? And that was when he found out that he might have a child. And he was great. He came back, he went to counseling, he learned about kids, and there was a process. Because we weren't going to just take this child, who was a couple years old at the time, and overnight move her in with a family with someone she didn't know. But there was a process to forge that relationship, and it ended up being a great relationship, and last I knew, he was a great dad. You see this through DCYF, where you've got parents that have drug or alcohol problems. They have an opportunity to get clean and be reunified with their children. And are we saying we're not going to do that in family court? If someone actually had a problem and they have fixed that problem, we're just going to say, never mind, your children don't want to see you. We're not even going to try to make sure you can have a positive relationship with them. I know there's questions on alienation. Does it happen? Does it not happen? Why does it happen? But there's a variety of situations where throughout the divorce process, the children are upset, reluctant to spend time with another parent. There's some issue going on. And certainly, and I didn't catch all of the amendment, but I would urge you to certainly not pass anything that prohibits the courts from encouraging the children to go through counseling that would allow them to have a positive relationship with both their parents.
Thank you.
Thank you for your time.
Any questions? Seeing none, thank you very much. Next, I'll call Dana Albrecht.
Again, just for the record, Dana Albrecht, Nashua, New Hampshire. Echoing what was just said, I know this has been through a couple different revs. I would urge you to pass something similar to the latest, requiring that a family systems therapist support a positive and healthy relationship with both parents, absent clear and convincing evidence in a court order that that's not in the child's best interest. Because I think that's what we're really looking here, is a good, positive relationship with both parents, unless we've got a good, really good reason why we shouldn't have that. So I'm a little less hung up on wording as some of the other folks, but I think we should focus on what it is we want rather than what it is we are maybe trying to avoid. This one is particularly near and dear to my heart. Up until April 2016, I was actually probably the primary parent in my household. Just to remind the committee from my testimony on shared parenting, I'm the father of 4 children, 2 older boys, 2 younger girls. The older kids kind of is, so they're in much better shape. But I do have a poor relationship with my daughters, and I don't need some crazy, unlicensed, unrecognized person or therapy to fix that. I need a really solid, licensed marriage, family, child, family systems therapist who is willing to work with both parents to help our kids put this back together again. And there's been some real challenges there. Since the hearing where Master Delpra basically said, "Who the F cares?" about my testimony and that my kids were morons. Actually, the resulting order from that hearing is still in effect right now. We filed a motion to vacate, but the court hasn't heard it. And it gave mom sole decision-making authority to select a counselor, which probably speaks to the last bill as well. And I've actually had serious issues with that person. I'm not going to blame them too much. I think they're young and inexperienced. But I've heard multiple conflicting stories from her why she will only communicate with mom or only communicate with mom's counsel and not me. And even a story from her that there's a court order preventing her from communicating with me. So I think if we can just kind of really clean this up as to what's allowed and what's not, kind of echoing almost the theme of the day on discretion, that would be a good thing. I would further add this has been exacerbated since, you know, Kathleen Sternenberg sent the kids to California. They've moved a lot. So they've been from Hollis, New Hampshire to Pasadena, California, to Sierra Madre, California, currently to East China, Michigan. And so when you put the whole multi-state thing into the mix, it can get even more confusing. To that end, I would just have one concern about the language is written where it says New Hampshire. Maybe take this offline. I just want to make sure that we're not causing jurisdiction problems if kids are in another state, and I'm sure it's an easy fix if that would be an issue. I think that's it. If there's any questions.
Any questions? I see none. Thank you.
Thank you.
Next, we're going to call Dale Dubot.
Thank you, Madam Chair. Thank you, members of the committee. Again, I support this bill. There is no evidence-based practice for reunification therapy. Again, I believe at minimal, it should be family systems therapy where they recognize the breakdown in the family dynamics and maybe can rebuild that. Also, if there's allegations of abuse or neglect, in my opinion, there would need to be a certified therapist well-versed in childhood trauma, attachment pathologies, stuff like that. And figure out why one child is allied with another parent and figure out where that's coming from.
Okay.
That's my, and I actually have some information to give you guys to read on
Great.
that.
Please submit it. Good? Yeah. Thank you very much. Any questions? Seeing none, thank you. We'll call on our last speaker on this bill, Her Honor Judge Jennifer Lemire. Thank you for taking time out of your busy schedule.
Thank you very much, Madam Chairwoman and members of the committee. I was here last Monday, but I don't know, I think some of you were here, but in case you do not know me, I just very quickly wanted to give you a little bit of background. I am Jennifer Lemire. I'm a circuit court judge here in New Hampshire. I'm born and raised in New Hampshire. I live in Stratham. And I have, well, I practiced law in New Hampshire as well as Maine and Massachusetts, but primarily New Hampshire for 14 years before I went onto the bench in 2010. I did general civil litigation, but a focus in family law as well, representing parents and parties that were going through difficult family law matters. I've been on the bench now for 12 years here in New Hampshire and full-time, and I sit as every, or almost every circuit court judge does, in the 3 different divisions of the New Hampshire Circuit Court. We have the Family Division, the District Division, and the Probate Division. Almost all of the circuit court judges sit at least in 2 of those divisions at any given time, usually family and district. Probate divisions don't appear in every courthouse in the state. There are fewer of them, but I actually sit in a courthouse that does have a probate division, so from time to time I'm also called upon to preside over those matters. But in the family division, we hear, of course, divorce and parenting cases, but also a number of other types of cases on a daily basis. And those include child support, domestic violence, child abuse and neglect cases, termination of parental rights cases, adoptions, and guardianship of minors. And then at the same time, we're hearing cases in the district division of our courthouses for criminal arraignments, pleas, bail hearings, trials, civil litigation, including small claims hearings, landlord and tenant disputes, stalking petitions. So in a given day, any of us might have a mixed docket. We talked about that a little bit last week, what that means. The docket is just the hearings that we have on every day, from 8 to 12, and then from 1 to 4. Usually there are 6 to 8 hearings in the morning, 30 minutes each, no time in between, maybe 6 in the afternoon. If they're longer hearings, there are fewer of them, of course. But we're very busy in the circuit court in New Hampshire, have been for quite some time, and we try to hear as many cases as we can because we are so busy. Also, at any time throughout the day, we have walk-ins with domestic violence petitions, stalking petitions, emergency landlord and tenant petitions, and at night we take calls 24/7, and on weekends, 365 days a year, from local police departments looking for emergency restraining orders, search warrants. DCYF may have an emergency request to remove a child, or the police may have a juvenile that they wish to seek to detain or have in custody and need us to help them determine where that child should go if a parent isn't available, for instance. So that's what we do in the circuit court on a day-to-day basis. And we do the best we can because we're statutorily authorized, of course, to apply the law to the facts that are presented to us. And in the parenting and divorce realm, of course, that's RSA 461A. That's our Parental Rights and Responsibilities statute. In the very beginning of that statute, it sets out the policy of the state of New Hampshire. And it is to support the frequent and continuing contact of a child with each parent unless it is detrimental to the child to do so. And it sets out that we have to take into consideration safety issues that may be present for the child or a parent. And we have to obviously always be guided by what's in the best interest of the child. When we're faced with a parenting case or a divorce case that has a parenting component, we have to help parties develop a parenting plan. That's within the statute, and it is in fact an 8-page document that is a roadmap for parents going forward, how they're going to share and their parental rights and responsibilities with one another. Because of course, at the outset, every parent has the same rights as the other parent under the New Hampshire Constitution. And we have to determine what happens if they cannot agree on how they're going to share those rights going forward. They have a conflict with one another, the parents do, or a parent and a guardian if that's the case, or what you may have in your particular case. So we encourage in the first instance, and it's part of the New Hampshire state policy to do so, that the parents can enter into a parenting plan together that they agree upon together. We help them to do that if they can't do it on their own, with mediators that we provide, with case managers who work in the family division, who help them prepare the forms. They're not attorneys or mediators, but they can assist people who aren't represented by counsel to do, some very difficult work that needs to be done because we request a lot of forms. And we also have along the way something called neutral case evaluation, which is free to the parties. And we have a judge or a retired judge sit with the parties and act somewhat like a mediator, but spend a few hours with them, hear what their issues are in their case, and help by telling them what they as a judge, if they were the judge on the case, might order. Sometimes that helps parties to settle the case themselves. And that's all a voluntary process. The parties have to agree to participate in that. It's been quite successful. I currently sit on the complex docket for Region C of the state of New Hampshire. We have 4 regions. Region C is Rockingham and Stratford counties. And 2 years ago, when Judge Foley stepped back from being the presiding judge of the complex family division docket, we split the case in the state into 4 regions, and I became the presiding judge of the complex case docket for the family divisions of Rockingham and Stratford counties. All that means is that the judges who have these busy regular dockets in those counties, if they're faced with a case that's particularly complex, can request that it be transferred, reassigned to my docket, because I have more time and resources available. I have a dedicated case manager. I have a complex list of ADR, alternate dispute resolution mediators, who have been vetted and interviewed by the ADR office at the administrative office of the courts to deal with complex issues. And that's at no cost to the parties who are on my docket. And the complex cases generally fall into one of 2 categories. The majority of them that I have presently are legally complex, or they have large financial interests and complex interests of that nature. They may be, they may involve assets such as real estate in other countries, in other jurisdictions, conflict of laws issues across states, closely held businesses that need to be allocated in a divorce, which can be quite complex, tax issues, real estate valuation issues, requiring long trials. I have mostly long trials on my docket, and I have the time set aside to do that. The regular dockets can't handle, perhaps in the next year or so, a 5-day, a 6-day, a 10-day trial, but I can do that on my docket for those legally complex matters. And the other complex type of case that I do see occasionally on my docket are those that have very high conflict, difficult parenting issues, such as those I'm sure you've been hearing about today. They're very difficult cases. Of course, there is a lot of emotion in many aspects of what we do in the circuit court, but certainly in these cases, and I understand it, having presided over many of them over the last 12 years. I sat in Manchester, Portsmouth, Dover, Rochester, and now Brentwood for the last 2 years. And we do, as I said, what we can to apply the law and the policy of the state of New Hampshire to the facts before us. One of the things that we do have to do, shifting now to this House Bill 1199, is in some cases, and I just want to, again, I can only speak about my experience, but it's rare, first of all, that I would order something that I would understand to be reunification counseling, as you're hearing about it today. Certainly we see many cases with counseling being ordered, and it may be actually in many cases the parties or the children are already in counseling before they even appear before me in my courtroom. And that's because the parents have put them there. They might have done that by agreement, they might not have, but that may already be in place. If there is a particular issue in a case that makes it difficult for me to determine what is truly in this child's best interests, because maybe there's a substance abuse issue in the case, maybe mental health issues, maybe the child is resisting or refusing to go with a parent and we don't know what the cause of that is. I'm not a child psychologist, I don't have those qualifications. I may have two parents in front of me, one that is absolutely adamant that he or she is doing everything to encourage that child to go, and the other parent saying, no, you're not, you're withholding the child, you're in contempt, you're not doing what you need to do to comply with this order. They may not have any evidence to show me that can help me decide what is actually going on here. But that child may need to have a place to go and a counselor to talk those things through. If I order counseling in a case, I always first promote the parties to agree to who that counselor is going to be. Sometimes they have absolutely no idea and they need someone to help give them a suggestion. Sometimes, well, first, and again, the part of this that talks about insurance, I don't have an issue with, because there's already written into the law the fact that we have to give due consideration to the presence of insurance and whether or not a counselor is on someone's insurance. We consider cost, or at least I consider cost, and my colleagues as well, to the parties in many areas in these cases, not just counseling, but also if we're going to appoint a guardian ad litem. We can no longer appoint a guardian ad litem in a case in New Hampshire if the parties cannot demonstrate, and we get their financial affidavits, and we get whatever evidence they give us, tax returns, pay stubs, what have you, of their income. If they can't demonstrate an ability to privately pay for a guardian, we can't appoint one. We used to have a fund in New Hampshire, a GAL fund, that's no longer there. And it was fantastic to have something to assist parties who needed that, because in some cases, a GAL would be tremendously helpful. A good qualified GAL would be very helpful in a particular case. But we can't appoint them now, even in cases that need them. And sometimes parties are asking for them, and if they can't afford it, there's no resource there for us any longer. But we consider cost, and certainly when appointing a counselor, or ordering a counselor, I should say. What I do, if they don't agree, I ask who has the insurance, if they have insurance. If they do, they may not know who's covered under their insurance. I'll ask them to have a printout made of whoever's available under their insurance policy and share it with the other party. They might both have insurance. They can exchange them. If they still can't, after they do their own research on who they'd like, can't agree, I might propose that they seek the recommendation of their pediatrician. Show those lists to your child's pediatrician and see if the pediatrician can point you in a certain direction that he or she would recommend, and choose that way. If there can be no agreement and the child has a need for counseling, and I feel it's in the best interest of the child to be in counseling, then I ask each parent to propose a counselor and tell me why that counselor is the person he or she proposes, and submit that. We'll have a hearing. I'll hear their respective positions, and ultimately I need to decide. But I do assure you that in my experience, that any counselors that have been, and again, I'm not usually selecting a counselor. Certainly if a party needs to be in counseling, that party should pick his or her own counselor. It's a very personal process. And I don't know that I've ever ordered a party to go to a particular counselor. If a child needs a counselor, again, we promote agreement. If there can't be agreement, look to the pediatrician. Usually that's where they find the recommendation. But in a very extreme circumstance, and again, I've only had a handful of these over the years, even on my current complex docket, where there is a reunification protocol in place. What that involves, in my experience, is each parent is in counseling and the child has a counselor. And then there's a master family therapist who is someone who has a master's, if not a doctorate, in child clinical development or child clinical psychology and counseling psychology. I heard New Hampshire certified and licensed mental health counselors. That is something I see quite often in these cases. I know of no one myself that is involved in any of these cases that doesn't have those type of qualifications. But again, it's a very rare circumstance because a child is refusing to go with a parent. It may be that, and I heard mention of a case where perhaps a child may have been traumatized by the parent that they're refusing or resisting from. I need to know that as the judge on the case. If that's the reason that a child is truly resisting or refusing contact, I am not going to order there to be contact with that parent because I have to take into consideration what's safe and certainly what's in the child's best interests. But sometimes we don't know that until the child's been evaluated. Courts need all of the resources available to us to help us with these very difficult cases. We are truly concerned about what is in the best interest of these children and these families that come before us. And I agree with the attorney that spoke earlier that we want to foster healthy, strong relationships within families, certainly when it's appropriate and in the child's best interest to do so. Again, we take in whatever evidence we have available to us, and if we don't know the root of the issue, it could be a child's age. The child could have separation anxiety, could have developmental issues, could have his or her own mental health issues that are causing this issue, resisting or refusing the other parent. If that child isn't being evaluated and treated for that, then reunifying that child with the other parent isn't even going to be an option. And the cases that I have currently on my docket, and I only have 2 or 3, 2 that actually have a reunification protocol in place. They were agreed upon and proposed by the parents. They bought into this process. One of the cases, I can't speak to the facts of a pending case, but I'll just tell you that in one such case, a father hasn't had contact with seeing his child in many years. And there are issues that cause the parents to not be able to agree upon anything. And that's understandable. That happens quite frequently in our cases before us. But what they did agree to was that they would prefer to be in a therapeutic process that might have a long-term sustainable effect for this child than to be constantly in the courts and coming back to relitigate year after year until this child turns 18. And unfortunately, that's what keeps a lot of these cases in our court system a long time. Unfortunately, the fact that there hasn't been a sustainable solution to whatever the issue is that is causing this family to be hurting so and causing this child to not have a healthy relationship with both parents. So a colleague of mine, when I spoke with him about this bill, said, why would anyone want to take one of the very few arrows we have left in our quiver in terms of the few resources we have as circuit court judges to try and help children and help families in these very, very difficult cases? I have no agenda. I have no desire to cause anyone to pay for something they can't afford or to be in a process that they don't believe in. And so I attempt to have everyone agree at the outset in my cases. If that can't happen, again, we have to come back to, well, what's in the child's best interest? And one thing that we can't do because there is case law. The Miller and Todd case tells us what we can't do is if there's a case where it has been found that a parent is alienating a child against the other parent, and such that the child no longer wishes to have contact with that other parent, we can't just pick that child up and put that child with the other parent, particularly if there are any allegations of abuse, certainly. Particularly even if there's no evidence of any abuse, but there are allegations and the child is resisting and refusing, and it may be a belief that one parent's alienating the child from the other parent. We can't do harm to the child. We can't force the child. We can't cause trauma to that child that may already have experienced trauma. That's what we're trying to avoid doing. We're trying to also promote frequent and continuing contact between a child and both parents, because that's what the state of New Hampshire tells us that we need to do when it's appropriate and in the child's best interest. I know I circled around there a little bit. I touched on a bunch of things. I know you've been at this. It's been a long day for you all. I'm happy to answer any questions if you have any questions, but I just wanted to touch on a few of those things from where I sit and how I see it.
Thank you, Your Honor. That was very informative. I see Representative Belanger has a question.
Thank you, Your Honor, for being here. Thank you, Madam Chair, for allowing me to ask the question. So, what you're saying is this. What we're hearing is this.
I understand.
How do we do this?
All I can tell you, and I mean absolutely no disrespect to anyone here in the courtroom, and I don't know their individual cases, and all I can tell you is from my own experience. And we have tens of thousands of these cases coming in new every year. I think you heard Administrative Judge King talk about that, or if you were here a week ago, Monday, he spoke to the numbers, and the cases that have been brought forward are almost equal to that. And we have, I think now, 39 judges handling those thousands of cases. And these are difficult cases. There is a lot of emotion. And there are often people who have concerns about the process, who've had a very difficult experience with the process. I understand that. I've seen that. But we need a way to make orders that are going to promote the children's best interests. And we can only do what we can with the tools that we have and the evidence that's been presented to us and apply the law to it. I mean, that's the thing. We have to apply all of the factors under 461A6, which include evidence of abuse. And that would be abuse of a parent, abuse of a child under the Child Protection Act or domestic violence statute. I understand you're hearing very, very different stories. All I can tell you is how we approach it from the bench. And I truly believe it's not the vast majority of the cases that we hear. But I don't know how else to explain it to you. There are people who absolutely have had a very difficult time with their own case, and their case is important. Everyone's case is important. Every child is important. Every parent going through this process. If it were an ideal world, we'd have more judges, we'd have more staff, we'd have more time to spend on each case. Some cases that have been in existence for a long time, and maybe some of these folks here have cases like this, they have pleadings and pleadings over years, and they've been involved in the court system for a long time, and it's horrible. If we could all spend as much time as I'm fortunate to be able to do on this particular docket at this time, across the state, maybe we could help these parties more, help these children more, but we do what we can with the resources that we have. And I've also had success stories. I have had great success stories with children who may have had, for whatever reason, a strained relationship with a parent, then go on to have a very strong relationship. You heard earlier talk of what happens in child abuse and neglect cases, and for 4 years sitting full-time in Dover, that was almost my entire caseload, was child abuse and neglect and termination of parental rights cases, and they were so difficult. But we always, always, always worked towards reunifying the child or children with the parent or parents. And that by law is what we have to do. That's the original plan starting out, and whatever the issue was that brought the parties before us, whatever the conditions were that led to a finding of abuse or neglect, they have 12 months to correct those conditions. If it's substance abuse, they get into a recovery program. They have services that are provided, and we encourage them. We meet with them on a periodic basis, and often counseling is involved, as you can imagine, in that process, and has to be with a child that may have been subjected to some very serious, trying things. If we were straight out, flat out precluded from ordering counseling or what is being called reunification counseling here, what would we do in cases like that? In those cases, once they close, they go into the regular parenting or divorce docket, because they need to have a parenting plan then. If the child is reunified and if they don't have orders presently in effect and they're in separate households, they need court orders to help them going forward. And we likely are going to have counseling continue in those cases if we can. And the parents are probably going to want it. The children are going to need it. And we can't be precluded from ordering it if it's truly appropriate and in the child's best interests. Again, the reunification protocol I spoke about is expensive. It is. I understand that. And so we do consider what parents are able to afford. If they can't afford it, it's not going to work. If they don't agree to it at the outset, it's not going to work. I saw something about not wanting one parent to choose a counselor, perhaps, for a child, or what do you do if the parties have joint decision-making responsibility, meaning they're supposed to speak to each other and reach an agreement before they make major decisions like putting a child in counseling? What does one parent do if they really want their child in counseling and the other parent just won't agree, won't respond even? Make a court order, disregards the court order. What do you do? In that case, that parent brings that to the court's attention, and we might make an order that allows that parent the ability to provide a counselor for that child. Every case is very fact-driven, and we just have to pay particular attention to the facts in that case and what the child in that case needs, and what the parents are able to do, not only financially but otherwise. Are they able to communicate? Are they able to agree? If not, how do we do that? I'm not going to just pick a counselor for a party or a child. I'm going to get them to refer to other professionals who might know that child. Pediatrician is a great one. That's someone that should be able to make that referral. I can't say what every judge has done, but I can tell you that I and my colleagues that I know I've been on the bench for a long time with, working in these cases, caring about these cases, about the parties that appear before us and the children. We're just striving to do what's in the child's best interest. And I fear I've been talking too long, and I don't want to keep you longer than
That's okay.
I'm welcome.
Thank you. We don't take questions from the audience. You're awesome. Thank you. There'll be no interactions, please. But thank you so much. Any further questions from the committee? We really appreciate your time. You've given us a plethora of knowledge. We appreciate that. And thank you for taking the time out of your day to come here. You've had a very long day, too.
Well, thank you. Thank you
So
for your
thank
work
you.
on this committee. It's very important.
Thank you. And that was supposed to be our final speaker. However, I do have one more pink card. Vivian Gerard, 30 seconds, and I will hold you to the 30 seconds.
That's quite all right. I just wanted to say thank you. You sound like a very good judge. I wasn't going to discuss this bill, but at this point, just to give you a quick little heads up here, based on my case, which you've all heard my case all day long today, being the Silva v. Silva, my income has been compromised through child support, as you all know. So right now, our lifestyles are not equal. And by a parent who keeps spending more money on the children and buying them the things that they want, it's very damaging on a relationship like mine with my daughter. My children right now, my relationship has been so damaged that I don't think it'll ever be the same. So I think by this bill, I obviously think that some of it has to be modified to a certain degree to make sure that it is covered by insurance. But for what has happened in my life and trying to alienate me from my children, it is not in the best interest of my children. And this actually has abused not only the system through harassment of all of these years, the 7 years that I've been in the system, but it's also mental abuse on my children. So at this point, and to your point exactly, is now I have to go back through the court to ask for therapy for my children. So now I'm in the same situation as you guys are here right now. Thank you. Any questions?
You're very welcome. Any questions? Seeing none, thank you. And thank you for speeding it up. I appreciate it. I know it's important.
I wasn't even planning on speaking.
No, what you have to say is important and we want to hear it. And with that, I have no more pink cards. On 1199, I will close the hearing on 1199. Do you need a few minutes? Okay. I will open the hearing on House Bill 1515. And I'm sure that Representative Gay is going to send a pink card up with some testimony. Any more pink cards? Final call. Thank you, Representative Gay.
The amendment is short, and even though the bill looks long, it only has 3 things in it. They just put the entire bill, the entire RSA there, or several, and then, so there's just, let's see, there's 4 little things here. So if you want to look at your bill, go to page 2. This is about if you're, well, there are multiple things about dealing with your GAL. So number one, some of the issues that I've been told about by people who are very unhappy were that they had the GAL who wasn't treating both parents equally, and their real concern is supposed to be the children. So they shouldn't be favoring a parent over the other parent. They should be gathering information about alls. Another problem with guardian ad litems right now is that they can bill without specifying what they're billing for or how many hours it was or when. You just, all of a sudden you get a bill and you've got to pay it or else you're going to be in trouble. And then it also, this bill also addresses the issue that when you have a GAL that you think is doing things that are underhanded, you really don't have anybody but the GAL board to report them to. And statistically, their response is really about 0. So on page 2, line 13, the guardian ad litem in the course of their appointment shall offer to meet with both parties simultaneously, with each party separately, or any combination of those options for equal amounts of time. So they're not spending, 70% of their time with one and 30 with the other or worse. Then on line 19, when appointing a guardian ad litem to be paid from a state fund, the court shall establish an hourly rate in writing and a maximum fee. See, that's paid from a state fund. You're not going to be a state fund, which shall not exceed the hourly rate maximum established by court rule for abuse and neglect cases. You may not be in an abuse and a neglect place. So we need to protect everybody so they don't get surprise billing. Then line 23, when appointing a guardian ad litem to be paid directly by the parties, the hourly rate, this is the ad, in writing. So if you're going to pay a guardian ad litem, you need to be notified in writing what rate you're going to be paid. being paid, and the maximum fee for the appointment. And then it has some restrictions on how much it is. However, the judge can change this rate. They can increase it, so it's not fixed by state law. Let's see, the fees for services of the guardian ad litem and others utilized by the guardian and others utilized by the guardian and approved by court shall be a charge against the parties, this is the ad, in an itemized bill, which may be requested by any party at any time. You might want to ask before it's over what they're charging. So you can ask at any time during the guardian ad litem's appointment, and which shall be paid upon the conclusion of the guardian ad litem services. Then the amendment is to page 3. The line that we're amending is line on 6. As it reads, originally the party shall have the right to approve, refuse, or report to the appropriate licensing board the illegal behavior of an appointed guardian ad litem or other appointed counselor at any time. The amendment says, since so many people have said when they did appeal to the guardian ad litem, the board, I'm sorry, I'm not saying the right name, I can't remember what it's called, but they're part of licensing. They have a subset of the licensing of our state. They've said they are not getting any kind of response. So my amendment to the amendment says, the party shall have the right to approve, refuse, or report to the appropriate licensing board the illegal behavior of an appointed guardian ad litem or other appointed counselor at any time. If there is no satisfactory response within 28 business days, the parties may refile their complaint to a higher appellate or reviewing licensing board or court. That's it.
Thank you. Any questions? Representative Belanger.
Thank you, Madam Chair. Thank you, Representative Gay, for being here today, again, on our last bill today. Are you aware of House Bill 1520?
Is that your bill?
It is.
Follow up.
So specifically, I'm very keen on clean bills that are very cut and dry and to the point. So 1520 seeks to, and I quote, which has not been heard in this committee, the guardian ad litem shall provide an itemized bill to the paying party, and all parties...
Excuse me, Representative. We're discussing
getting to my point.
1515. We're not discussing any other bill.
I'm getting to my point,
Thank
Madam
you,
Chair.
Representative.
Thank you. You and Representative Rice do that to me all the time.
Well, sir, you have to stay on the subject at hand.
I'm getting there, I
Thank
promise. And all parties shall have the right to request the itemized bill for review. Cut and dry and to the point. Would you, cutting and drying to the point, be willing to come forward to this committee with an amendment that focused on the non-billing requirements so that that may be brought up in a different hearing?
Yes, I would really like our bills to be merged so we cover all the points with one bill instead of multiples.
No further question.
Follow up? Okay.
No further
Thank you.
question.
Representative Altshuler.
Thank you. Thank you, Representative Gay. I just don't have the amendment. Did that go around?
There are copies
All right, thank you.
somewhere.
Here.
Yeah.
The amended amendment. Okay, sorry.
Any further questions for Representative Gay? I thank you very much, Representative, and I appreciate the fact that you have extra amendments for us. The next person I'll call is Angela Lozier. Ms. Lozier, you've asked for 20 minutes. Yes. No, you asked for 20 minutes. God bless you, but you're going to get 2.
I'm tired, my apologies.
As are we.
We're
But
all
we'll work
glazing
together
over.
to get this done.
Yes, much appreciated, thank you.
Again, my name's Angela Lozier for the record. You have heard several testimonies from me today, and one on Tuesday, the 11th, on shared parenting. A few things about my GAL. One was the billing and how she spent more time with one house than the other. I received one of her bills during the court proceeding, and the other one wasn't until, 6 months after the final hearing. At this time, I discovered she had spent, significant more time speaking with Stella via Zoom when my daughter was with her father. Kathleen also spoke again about to my ex and his wife that I was unaware of. Not only did she ask for weekly updates from him after the status hearing and removing her from my custody. Let's see, I'm trying to glimpse it over for you. I don't need to go over that. After the status hearing, Kathleen asked for weekly updates with my ex, which consisted of more construed allegations about me and my scheduled time with our daughter. At no point during those weekly updates did Kathleen ever follow up with me regarding these allegations. I was asked for an update on January 13th before our final hearing. I stated my concerns and answered Kathleen's questions. Kathleen immediately emailed my ex to ask him to explain the concerns I had, but she had not done the same for me. I wasn't given the same opportunity.
This bill is concerning the procedures for guardians ad litem in the family court proceedings, specifically the billing.
Okay.
Can we stay with that, please?
Sure.
And you have 1 more minute.
Okay. I guess I wish I would have been aware of, on the bill, you get an itemized.
Yeah.
Not only how much is she charging, but how she's spending her time. You don't discover these things until maybe 24 hours before court. I got her file. But like I said, her final bill I didn't get till six months after my final hearing, which if I wanted to, proceed forth, I don't know, whatever way I would have wanted to, I feel like it's been so much time, why reopen it? So I guess billing is definitely important to know and keep maybe an updated on both parents, not keeping it from the other. So thank you.
No, thank you. Any questions? Seeing none, thank you for your time. Next, I'll call on Dan Itza. Honorable. Dan, you're asking for 5 minutes. In the interest of time, can we squish it to maybe 2.5?
I'll do my absolute best.
Thank you.
For the record, I'm Dan Itza. I still reside in Manchester. 12 years ago, I was vice chair of the committee to review the GAL audit. And the legislation that you see here was one of the products of that in 2013-14, I forget particularly. One thing that I would add to the law as it stands now, page 1, line 23, the guardian ad litem has to report their investigation at the pretrial hearing. I think it would be beneficial to the parties if there were some additional period, like 5 days before the pretrial hearing, so that they know what they're expecting. As to billing, the rate is essentially set by the state because it's all keyed to the rate set for abuse and neglect cases. So that's the benchmark. And then for those privately paying, there are no state payees right now because there's no fund. For private payees, the rate can be no more than twice that. And it can't exceed more than 23 hours unless they agree. I think it would be very beneficial to insert after they agree that the GAL or the parties or the court has to say 23 hours plus 20 hours plus 40 hours so that everybody knows what they're getting into. No blank checks. That's a real problem. I would go on under, now it was the intent of the committee that once the GAL's contract appointment expired, there was no more work done, there was no more billing, that was all the parents were obligated to. And that is, from what I hear, not the case. That the guardian ad litem's activities continue after the appointment in some cases, and that some judges require those additional fees to be paid. I think you should strengthen Section 5, Roman numeral 5, and make it clear that the parties are not responsible once the appointment expires. If the GAO wants to work, then it's on them. It's donated work. And that's it. I'd be happy to take any questions.
Thank you. Any questions? Thank you so much for your time. I appreciate you squishing it down. The next person will be Dana Albrecht.
Thank you, Madam Chair. Again, for the record, Dana Albrecht, Nashua, New Hampshire, and thank you for helping to move this along. It's a very brief preliminary matter. I just want to make sure that the copy of this, page 2, lines 13 to 15, speaking to equal amounts of time, that something like that is still in whatever, or similar to it, whatever version we're discussing now, because I don't have the most recent. And also the same for billing down in 2830, so I do speak to the bill.
Yes.
Just as one more very brief preliminary matter, I just want to echo Rep. Belanger's comment about he's hearing this from the judge, all wonderful things, and this from the parties, and how do we get from here to here? So you might get just a couple sentences of that mixed in to address these two portions of the bill. So I'm just going to say Kathleen Sternenberg in my case. I'm one of the 9, essentially heavily favored my ex in terms of how much time she sent. I would go so far as to say she acted almost as her second counsel, and I believe the written transcript of her testimony, the GAL testimony presented last Tuesday to this committee, would support that. So again, I think that's speaking to equal amounts of time and non-bias. In terms of billing, she charged over $10,000 in fees for her investigation to relocation to California, when the maximum written fee cap I ever got was $4,000. At the time, I didn't know any better, but I think the billing in here is speaking to that. In terms of equal amounts of time, I just might suggest it say something about references as well, because I found that she spent a whole lot more time speaking to Mom's references than mine. And just to kind of wrap this all up and close, in terms of what happened here with meeting the time in the billing, if by law we're supposed to promote a healthy relationship with both parents, I would just have to ask, in my case, how a GAL moving the kids all around the country does that and charging $10,000 for it. What's going on here? And that's just to kind of close with the gulf, once again, between Rep. Belanger and Her Honor. How do we get from here to here? And happy to take any questions.
Thank you. Any questions? Seeing none. Thank you very much.
Thank you.
Next we have Eric Brand. you're asking for 5 minutes. Can we squish it down to 2.5, please?
Yes.
Thank you.
Thank you, Madam Chair and committee members. You've heard many bills between today and last week as well. I'm in support of 1515 and possibly Representative Belanger's bill as well, but with a modification that I didn't see in either one of these, though I haven't read your complete bill yet. We all know from some of the happenings in the Nashua court system that there can be a conflict of interest that can arise. I like to believe all judges in the systems are very good judges, but we've seen that there are some that are not. If we were to add in a lottery system into the appointments of guardian ad litems, this may help many families feel comfortable and not feel that somebody's just hiring a friend, such as what's happened in Nashua. Now, what I mean by a lottery system, if we all think back to when we had the housing real estate crash back in 07, 08, there were a lot of appraisals that were going on. It was a lot of bankers, loan officers that were leaning over to their friends and saying, hey, I need an appraisal that's going to match what this house is selling for. Can you get it for me? And if that friend wouldn't do it, they'd go to another one. So then the states moved into this lottery system where the appraisals were then appointed, and that took away that whole flaw within that system. If we were to add in something within these bills, or maybe there's an additional bill that's added in that could hopefully change this and regain some confidence from some families that don't have confidence with how the guardian ad litems are appointed. This all ties back into what we spoke about last week with the 50-50 shared parenting. If we start with the 50-50 shared parenting, there's going to be a lot less guardian ad litems that are going to be needed and appointed. Because as I've testified once before, and this is one sentence here, that I still believe that each parent brings to each child being raised a substantial amount of characteristics and helps form that child. And when you take one parent away and make them an every other weekend parent, it doesn't make that child whole. Thank you.
Thank you very much. Any questions? Thank you.
Thank you.
Next I have Gail Drobat. I'm so sorry.
Still
Drobat. It looks like a U. When you write it,
Oh,
it looks like a
sorry.
U. That's why. Gail Drobat.
So can I speak to the last part? The party shall have the right to approve, refuse, or report to the appropriate licensing board the illegal behaviors of an appointed guardian ad litem. Again, I'm not personally in the court system. I have spoken to many parents over the years, so I advocate for them. But this one particular case, Kathleen Sternenberg allied with the mom. Dad has not seen the child in 4 years. The egregious behaviors of Kathleen Sternenberg in many, many cases are affecting children in this state. Here's his complaint to the Guardian Ad Litem Board. I just received on December 27th, there was no finding of violations on her. They said under 50302, they found no violations. Under 50302C says she is to follow her order on appointment from the court. She did not do that. She did not go to Dad's house. She did not meet with Dad and the child. How is it possible they have found no wrongdoing? And where do you go from here? Like, there's got to be somewhere for these parents to go. It's been to the JCC. It's been to the Attorney Discipline Office. This child is in turmoil. He's got 125 behavioral referrals. The courts will not address his mental emotional state. And Kathleen failed this child. She concealed important information. She concealed 87 behavioral referrals in 4th grade alone from the court. She concealed inappropriate behaviors in the mother's care from the court. There's nowhere for these parents to go to protect their children. So this is important that there's another board where you can go to report these people, to protect children in this state. And we've all seen the news, we're national news now for abusing children. This has got to stop. These children need to be protected in this state.
Thank you.
I mean, that's got to be important to all of us, and we are failing our children.
Any questions? No questions, seeing none. Thank you for your
Thank you.
testimony. Next, I have Anna Goulet-Zimmerman.
Madam Chair, members of the committee, I am still Anna Goulet-Zimmerman. I practice law in Manchester, New Hampshire, and I am a member of the New Hampshire Association for Justice. I signed in opposed, but that may be the wrong word. I more just have several concerns about the wording on this, and I wasn't even planning on testifying about this one, but since I've been here all afternoon, I figured I'd stay for it. First part is this additional requirement of equal amounts of time. I understand the sentiment where that's coming behind, but there are lots of reasons why time might not be equal. That is not necessarily because someone's biased. I'm going to give you an example of me and my husband, who are fortunately not before guardian ad litem and not getting divorced. But if you ask either of us to tell a story, it takes me about 5 times as long as it takes him. I say he's missing a lot of context. He thinks I'm adding a lot of stuff that really doesn't matter. But that's just how people are. So some people are going to have the exact same. They're going to have a harder time formulating their thoughts. Maybe they're rambling more. Maybe they're a little less organized, where someone else is like, here it is, dum, 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 dum. It doesn't mean there's bias. You can, of course, on cross-examination, if you think these issues have come up, you can say, well, look, you went to this house and you spent this much time with the kids there. How come you didn't come to this house? So there is a way to address those issues. As far as evidence that the guardian, I mean, it feels a little like today we're more talking about, is there a problem with a guardian ad litem, which of course is not what this statute and the is to address. I have no issue with itemized bills. I think that's fine. Which shall be paid upon the conclusion of the guardian ad litem services, I do have an issue with. Never been a guardian ad litem, but you've heard today people talk to you about cases that are going on for 7 years. And if guardians aren't going to be paid until the very end of their cases, it's hard enough to get guardian ad litems. They ought to be paid as they're going along for the work they're doing. There is, under Section 5, already a provision for the maximum fee. And you have to go to the court, they have to ask for additional time, say they need the additional fees, and have that approved. So I'm confused as to why there needs to be kind of duplication of that, or why that's an ongoing issue. The last thing is this Section 7, there's already a right to report illegal behavior. I don't know what we're trying to add here, except maybe get even more complaints against guardian ad litems. I also don't understand the language. You know, if I take out some of the words, the right to approve to the appropriate licensing board, the right to refuse to the appropriate licensing board, I don't even know what that means. I mean, I get the right to approve, report to, but I don't know why we have approve and refuse in there. And this notion, this additional thing of if there's no satisfactory response, I'm sure this has already come to everybody's on this committee's thought, but obviously there's going to need to be a fiscal note, because you're talking about creating an entire new division. I would suggest, with great deference to the parties that are here today, I understand that family law can be a very, very difficult process to go through, but that if a complaint has been to the Guardian Ad Litem Board and the Professional Conduct Committee and reviewed by the court, and everyone has said there's nothing there, maybe there isn't a need for another board who will also review those complaints. So, thank you for your time.
Thank you. Any questions? Seeing none, thank you very much for your time. Next is Katrina Heinrich.
Thank you all for your time. It's been a long day for everybody, so I just wanted to thank you. I left my glasses back there, so please bear with me for a moment. Oh, thanks. I knew that was going to be the issue by the end of the day. Okay. All right, now that we've had comic relief. So on this, basically, I'm just going to cover a few quick points. That's it. I don't think we need to extend too much on this one. I reiterate from my previous statements, not just this testimony, but the testimony of the past 12 years that I've provided to the committees, that the GAL is a private citizen with immunity, and he is for hire. In my case, the discovery process of the divorce, which ended his appointment, showed the wealth that was there to get. The GAL spent a significant amount of time post-divorce, even possibly pre-divorce, with the other party. The GAL testified toward the end of our 12 years, when my daughter was kidnapped out of the state. He testified to the last 3 years of her life when he had no contact with her. So the discrepancies in what's actually happening and what we know people can do or should be doing is quite great in about 20% of the cases. I lost one of my points, I apologize. For me personally, I got no record despite repeated requests of all the billing. I never got any billing records at all from him. I never got any records after repeated requests of his file. It is my understanding we're allowed to have that. I have yet to be provided for it. I don't know. I cannot tell you what his true total was that he accumulated in 12 years, including the 2 years that I previously mentioned in my case summary, that he functioned post-divorce, immediately post-divorce was functioning with the court and never reappointed. But the court allowed all of it, regardless. So there are discrepancies, and I'd like to believe that everybody is there for the right purposes. But in my case, everything went completely sideways. When it comes to the guardian ad litem, I think they're an evil necessity with a double-edged sword. They are not a CASA guardian ad litem. So I think the billing, when you're talking about a private contractor, is very, very critical to be overseen to avoid undermining the court process and our belief in the system. With that said, I'm going to end today, and God, you guys have a great night.
Thank you. Any questions? Seeing none, thank you very much. And our final, although she gave us 2 cards, you only get 2 minutes. And that would be Vivian Gerard.
Sorry, it is a long day here. But I appreciate you guys taking the time to meet with us. So in this particular bill, I do support it because I see the effects that it's had on me, my friends, and their children. During my divorce in 2014, the family court ordered a GAL. My experience was concerning as my GAL tried to pull my children away from me based on a false police report. Divorce with or without children is stressful. A GAL has many influences on the future of your children and is unnecessary in many cases. In my case, my GAL was very biased. She did not have equal visits to both homes. She did not look into the false police report. She did not look into the false DCYF reports. I was fortunate that I didn't have the outcomes that could have very easily and negatively impacted my time with my daughters and the decisions. I hope that I will never have to go through a GAL again, but based on the harassment that I've experienced, it scares me to death because I probably will end up back in court again. My friends behind me here today, you have heard their testimony. It's very concerning, to say the least. They are just a few that have been traumatized, but a GAL. My hope is that with all the testimonies that all of us shared, this will make an impact on the family court. These laws will help our children lead a better life. Unfortunately, you cannot report on any of the GAL reports or concerns until your case is closed. By then, it's too late. So please stop GALs like Kathleen Sternenberg from making the children victims by pulling a parent away from a child. That's all I have. Thank you.
Thank you. Any questions? I see no questions. I just want to take a minute to thank everybody here who has brought us some very valuable information. We obviously have our work in front of us to try to implement what you've said to make these laws better. And I thank you for sticking it out for the day. It's been a very long day, and we do appreciate it. Thank you. And with that, I will close the hearing on House Bill 1515. Have a nice day, people. Whew. Holy moly.